Someone make it make sense.
Probably a couple.
Hello, hello, scroll friends. Welcome on in. Welcome, welcome, welcome. We finished closing arguments last night as we were revisiting key trial testimony from the Murdaugh trial. And here we are in the wake of all the Miss Becky shenanigans news to cover this evidentiary hearing from January of 2024. Shout out to Justice Jane. I believe you are a new scroll friend. So welcome to the scroll crew. Happy to have you here. First one in the chat as well. So awesome. Happy to see that. And yeah, so funny thing, because we were already going through and recovering some of this key trial testimony when just, what was it, last week, was it? Her arrest was announced, and we watched her bond hearing and everything, and we went over her charges, but we're going to take a look here at these again before we jump on into this hearing. So hopefully Nightbot will wake up from his nap. Okay, there he is. Thank you, Nightbot. Love it. So, all right. And for anyone who's like, I don't know much about this Becky Hill stuff, don't worry, because this hearing that we're about to watch will get you completely up to speed with all of the details and everything that went down, and also contributed to these recent charges that we are going to take a look at right now. So this is from SLED again. I think this was last week with Karen Reed going on. Everything is a blur here. Yeah, May 14th. All right. So that's when she was charged. Okay. So we have her indictments here. So okay, let me zoom in so we can actually read this. All right. You zoom in more. Okay. Okay, so here's the first one here. So in Richland County, on or about January 29th, 2024, that's the evidentiary hearing. Becky Hill, being the elected clerk of court of Colleton County, did willfully and unlawfully give false, misleading, or incomplete testimony while under oath in a court of record. So one question that a lot of people have been asking is, how does this recent arrest affect Alex's appeal, which is still pending? Poot recently spoke out and says he thinks it's going to be heard before the South Carolina Supreme Court by December of this year. Don't worry, when that happens, we will definitely cover it. But the answer is, okay, so these charges are related to, some of them are related directly to his trial, right? And or the evidentiary hearing subsequent to the trial. And so that's how the charges are related to the Murdaugh case, right? But will this change anything as far as the appeal goes? That, I think, is unlikely, because the real issue, as many of you guys are aware, is the split between the federal and the state courts as to the standard of review, right? And we're going to hear Chief Justice Toal discuss that at length also during this evidentiary hearing. And my personal opinion is that it's going to end up making its way into the U.S. Supreme Court. That's my personal opinion, because this is an issue that is ripe for review, to put this matter to bed, so to speak, right? Because this is something that they've not weighed in on as to the different prongs, right? So, okay. So this is, again, giving the false testimony at this evidentiary hearing that we're about to watch. And it's specifically as it pertains to the question about the sealed exhibits, right? So Chief Justice Jean Toal asked former Clerk Hill, did you allow anyone from the press to view the sealed exhibits? And she said, no, ma'am. And that was not truthful. Okay, then next we have in Colleton County. So this is the making available of the sealed evidence, right? So in Colleton County, she did release or make publicly available the sealed evidence, right? These were the crime scene photos. And we actually heard Judge Newman touch on this at the very end of after the sentencing, which we were watching last night. So the first one that we just read was for lying about making the sealed photos available to the public. The second charge here is for making them available to the public, right? So that's your first two. Then we have obstructing justice here. So having found probable cause in the above affiant, having sworn before me, you are empowered and directed to arrest. Oh, sorry, that's not what I'm looking for. Here we go. In Colleton County, she did willfully, dishonestly, and unlawfully breach her duty of accountability to the public by promoting her book Behind the Doors of Justice while using her public office to promote the book. Again, so related to the Murdaugh trial, obviously, right? But this was subsequent to that with her book, June 7th, 2023. And then the last one here has to do with the money. So she stole, and this one has nothing. This is the one charge that has literally nothing to do with the Murdaugh trial or the Murdaugh case, right? That she was taking these funds, almost $10,000. Sorry, actually more than that. So almost 10,000 plus, so about $12,000, right? That she obtained and utilized for her own financial gain. So essentially, what does that all amount to? That none of these charges have to do with tampering with the jury, right? None of these charges have to do with tampering with the jury. And that's what his appeal is based on, right? His appeal isn't based on, the book was part of it, but that was sort of to show her motive to be biased or her motive to want to tamper, quote unquote, with the jury. But in other words, she's not been charged with tampering with the jury. So there you go. Now, if she had been charged with tampering with the jury, then I think that could have a direct impact potentially on the appeal, especially as it moves through potentially to the U.S. Supreme Court. So Justice Jane is saying, do you think he will get another trial? I was thinking about this a lot last night. And like I said, I don't think it'll happen through the state court. I think it's going to go up to the U.S. Supreme Court. And as much as this pains me to say, I do think he'll get another trial. I've thought about it a lot. And I think that if indeed it does go all the way to the U.S. Supreme Court and they weigh in on this issue with the two prongs, I feel pretty confident that they are going to say that it's enough to have evidence that a public official was making these comments to the jury, and that whether or not it influenced their verdict, that first prong is enough. I think that's what they will say. I would be shocked if they didn't. And then he would be remanded back to the trial court level for a new trial. Of course, it doesn't matter in terms of his sentencing. I mean, he's got life without parole anyway due to the financial crimes, right? So regardless, and I have every confidence that it would result in another guilty verdict if he gets a new trial, right? And it's not going to change where he's held in custody. He's still going to be in the state penitentiary, McCormick, for the rest of his natural life, regardless of anything. But I guess he would still consider it a win, he pled to those financial crimes. So it's not like, and then of course he does have the federal sentence as well, which he'll never serve because again, he'll be in McCormick the rest of his life. But I think it'll go to the U.S. Supreme Court. I mean, now having said that, Poot, Dick Harpootlian, did say recently that he feels pretty confident with the recent changes that have happened in the South Carolina Supreme Court. He feels pretty confident. He said that they might go ahead and grant him a new trial. He knows the lay of the land better than I do as far as, he's in the community. He's a politician, right? But I still feel like, and actually I heard some commentary on this earlier from somebody else who's also in that circuit with, locally there and knows all the justices and whatnot. And they also echoed what I'm saying, which is that they still think it's going to get denied from the state and sent to the federal level, and it'll go up to the Supreme Court. So we'll be a long time from now, but I think they will give him a new trial. And man, will that be interesting. I don't know how they're going to make magic happen twice. But, hopefully the witnesses are all still alive. Roger Dale Davis Jr., hopefully Creighton is still prosecuting the cases, because I would be heartbroken if it's not Creighton. Like, I want it to be exactly the same if it happens again. You know what I mean? But anyway, that's just for my own personal thing. So, so Justice Jane, I take it that you have closely followed this case. Let me know, because I'm curious. If again, I haven't seen you in the chat before, so for anyone who is new, yourself included, this is my favorite trial and case of all time. So, and it's the gift that keeps on giving, right? Because it's like with the fallout of everything, right? Then you've got Russell Lafitte, his whole thing, and all this Becky Hill stuff. In other words, there could still be Murdaugh adjacent, as I call it, things going on all the way through up until if this is heard before the U.S. Supreme Court, there could still be Murdaugh shenanigans going on. It wouldn't surprise me. Welcome, Happy Annie. Also, for anyone who hadn't heard the news, Buster got married at the beginning of May to Brooklyn. And so congratulations to them. I do have, let me see if I can find this. I do have some interesting pictures of their wedding registry that I found. They had an elaborate wedding someplace on the water. Looks like they had a lovely wedding. And I have to say, shout out to Brooklyn, because she stood by her man through thick and thin this entire time. And also, apparently, she is working as an attorney now at a civil law firm, I believe. So, okay, let me show these to you guys. I'm just gonna have to unshare, reshare real quick. These are pictures literally from their wedding registry. So get ready for this, guys. This is some good tea here. Okay. All right. So first up, we've got this Lotus Garden pillow for $208. We've got this Southern Tribute Labrador Guest towel box for $136. We've got this chambray blue bobbin salt or pepper mill for $96. I don't know where these items are from. I guess those are the stores listed below. I don't know why they're so expensive. We've got this rustic rose blue and white porcelain temple jar for $150. And, the thing is that's interesting too is, I don't know who paid for the wedding. There's a lot of questions about this, right? Because weddings are expensive, but theirs looked like it was lavish. And in other words, the wedding, from the pictures I saw and the info that I was able to get, looks like it was not impacted by all of the things that have happened regarding the financial status, right, of the family. I mean, and it begs it's this whole remaining question, like, where did all the money go? I mean, did Brooklyn's family foot the bill for this? I don't know. It's just interesting, right? Oh, sorry, I forgot to text you, Twiz, but welcome. Happy you're here. So we're looking at Brooklyn and Buster's wedding registry, since they just got married at the beginning of the month. And I do have some really exciting news too. I'm gonna wait though for some more people to get here before I share it with you guys. No spoilers, Twiz. But also I have updates talking to you, Twiz. Okay, so then next we have this Double Happiness green and white medium porcelain lug vase for $125. Ew. Look at this thing though. Hand gilded dog coat hook for $95. I mean, it's not even cute, and that's hard to do with dogs. In my opinion, it's not even cute. Then you have this tray for $290. What? It's an ottoman tray? Jesus. And then this last one is crazy. So pointer box. I don't even know what it does. It's just a box with a dog on it for $648. I mean, Happy Annie says, weighing in here, he's not going to get a new trial unless it goes all the way to the top and they decide to give him a new trial without me. The thing is that, well, again, it's going to come up more in this evidentiary hearing, but the federal case law does tend to support the one prong. And you have to think about it, right? The one prong just makes sense. The one prong makes sense. That if you find that tampering occurred, that's enough. That's enough, because we don't want to, we don't want to even give the appearance of impropriety that there was fuckery going on, right? And that, you know, and plus jurors could say it didn't affect their verdict when it did. And the other thing is, like, the tampering shouldn't be happening, right? The comments shouldn't be happening. Comments from public officials at all, right? Beyond just what is necessary to do their job. So I feel really confident that, you know, the rest of his appellate issues, and we've covered the vast majority of the appeal, we still need to cover the last portion. The vast majority of his appellate issues are pointless, right? The one that matters is the one with Miss Becky, right? That's the one that matters. And as far as the federal courts are concerned, and again, according to Poot, he says the state court, he thinks the state court is likely to go ahead and grant him a new trial. But I mean, for me, I would say if it goes up to the U.S. Supreme Court, I would say 98% chance new trial, maybe 99% chance new trial. Okay, so then let's go on to the next picture here. We do have some more wedding gifts. And I do have some big news. Again, I'll share with you guys here in just a few minutes. Okay. So next up, from their wedding registry, Brooklyn and Buster's wedding registry, we have luxury microfiber bath rugs. Well, at least these prices are, well, for that is more reasonable, $23.99, Amazon. Then we have a Dyson $1,000 robot. Then we have this interesting thing, LG 27-inch class Stand By Me. I don't know. That's a TV. I've never seen a TV like that before. I don't really know what the deal is with that, but that's $1,000. Then we have Caspari Rattan wine bottle coasters, $36. Beckham Hotel collection bed pillows, $62.97. This is interesting. Tyler Gallon Glam wash laundry detergent for $70 almost. For laundry detergent? I don't even know. Yeah, everything Becky was charged with doesn't have to do with jury tampering. It doesn't have to. Doesn't have to. It's not like the validity of his appeal hinged on what she was arrested. You know, those are criminal charges, right? It doesn't hinge on that. Like, you know what I mean? And those are state charges. So in other words, it wasn't the validity of the appeal as far as the jury tampering is concerned was not hinging on whether or not she was criminally charged with jury tampering. And again, we're about to hear this evidentiary hearing, and Justice Toal makes a very thorough record of her findings, and it's clear that she spoke to the jurors and said things that she shouldn't have said. That's clear. That's not, and that's on the record. Like, that's on the record now that happened, and she lays out her findings. So whether or not she was criminally charged doesn't, you know, that's the appeal is not hinging on that. You know, like I said, it maybe it wouldn't have hurt, at least as far as the state courts are concerned, but it wouldn't have changed anything really. You know what I mean? It's just because it is a separate issue. And honestly, I don't even know. It really would be a big deal, right? For someone to be criminally charged. Like, I don't even know, has that even happened? You know, because usually the remedy, if there's, you know, public official tampering with a jury, the remedy is usually a new trial, right? In a lot of cases, depending on the state. And because South Carolina goes with the 2 prongs, that's why we have the issue before us with this whole thing. So, and we'll just pull this up. Hold on real quick here. Let me guys know when you're ready for the big news. The other thing too is that it's not out of the realm of possibility that, again, these are from the state, right? It's not out of the realm of possibility that the state, oh, by the way, welcome, Meg, if I didn't already say that. It's not out of the realm of possibility that the state did not add charges for that in order to secure their verdict on the state level. Let me see what that would even be. Let me just do a quick search here. Okay. I found it. Found it, guys. Here we go. Let's look. Let's take a look. Let's take a look. Take a look. It's not in a book. Okay. Hold on. Got it. Got it. Got it. All right. So offenses against public justice. There's perjury. Bribes. I can't zoom in, unfortunately, on this. Corrupting jurors, arbitrators, umpires, or referees. Whoever corrupts or attempts to corrupt any juror, arbiter, umpire, or referee by giving, offering, or promising any gift or gratuity, whatever, with intent to bias the opinion or influence the decision of such juror in relation to any matter pending before the court. They shall be punished by imprisonment in the state penitentiary at hard labor, not exceeding 5 years, or a fine not exceeding $1,000, and imprisonment in jail not exceeding 1 year. So this says, let's take a look again closely. So offering or promising any gift or gratuity, whatever, with intent to bias. So that's if you offer them something. So attempting to corrupt by offering something. So I don't know if that would be applicable here because she didn't offer them anything. But there might be another one. Let's see here. Accepting bribes, hold office. Interference with judicial process. Attempting to influence juror by written or oral communication. Okay, here we go. This I think would be the one. Here we go. Attempting to influence juror by written or oral communication. Communications authorized by court, not prohibited. So oral communications. Okay. Any person or who attempts personally or through third parties to influence the action or decision of any grand jury or petit jury of any court in the state or any prospective juror upon any issue or matter in which may be pending before such juror or before the jury of which he or she may become a member, by writing or sending him any written communication or making any oral communication relating to such issue in the matter, shall be deemed guilty of a misdemeanor. And this looks like this is for anybody, not just a public official, like anyone attempting. It's a misdemeanor, blah, blah, blah. And let's see if there is also one that says specific for aiding or permitting escape of prisoners. So essentially, okay, this answers the question though, right? Essentially, without reading all of this because it's also very small. That's what she said. Essentially, there's the perjury. We already have that for Miss Becky. Essentially, the answer is yes. There are criminal statutes that apply for influencing a jury. There we go. Okay. Did I see what you sent me in Discord? When did you send it? No, I didn't see it. Okay. So here's the news though, guys. Here's the news. Here's the big news. So, as of tomorrow, I will be starting to work in a law firm as a paralegal. And it's not just any law firm. It's actually two attorneys, and it'll be like just the two of them and me, because it was just the two of them and a paralegal, and their other paralegal is moving or something. So, but here's the deal though. One of the attorneys seems to it's defense attorneys. One of the attorneys primarily seems to deal with federal white-collar crimes. We're talking huge Ponzi schemes, things that deal in the millions and billions of dollars, actually. And then the other one, from what I can tell, I think also deals with federal crimes, but seems to mostly be dealing with North Carolina death penalty cases, and currently has several death penalty cases pending. And if it's not a death penalty case, it's things that are the worst of the worst in terms of the most serious possible criminal offenses in the state. And so, yeah, of all of the things like that, you guys know how passionate I am about the law in general, period, right? But specifically as it pertains to, you know, these death penalty cases, but also like white collar crimes. I mean, here we are talking about Murdaugh, right? You know, like, and basically I will be the one paralegal doing all of their things for all of their cases. I will also be the person speaking directly with the clients who call in looking for, you know, these are private attorneys, so private legal representation for these very serious crimes. I'll be doing all of the things. I'll be talking directly with the clients, the current cases, prospective clients, and preparing all of the, you know, I will learn a lot more tomorrow, but it's just going to be the two attorneys and me. And so I am beyond ecstatic because what a huge opportunity this is to learn, you know? Like I told Twiz, like, you know, I would love to go to law school. Law school is expensive, but you know what? Like, I will learn probably more working in this particular job for these particular defense attorneys with the role that I will be playing, like directly there, than I would in probably the first year or two of law school anyway. You know what I mean? Because this is going to be actually hands-on experience, and I will get to learn North Carolina law really well. I mean, I can barely like formulate the sentences because I'm so excited. And so, yeah, getting to put my, knowledge to use in addition to, you know, what we do here on YouTube, but really helping people, like real deal, you know? I never, like, I guess, really thought I could actually maybe help somebody who's facing the death penalty, like in real life. But like, I think that's what's happening now, you know? Welcome, Angel. Welcome. So yeah. And the thing is like, these guys are freaking awesome, man. They're super cool dudes. And really, like, I love that it's just going to be the two of them. Their current paralegal will be there for a week, and like training me or whatever, and then she'll be leaving, and like we're going to be like a fam. I feel that's how I picture it, right? Because it's like, that's it, right? You know, some of these law firms have a lot of staff and there's a lot of people, and it's literally just the two of them. They said they're barely ever even there because they're always at the courthouse. So I'll be doing all the stuff, guys. I'll be doing all the stuff. And I couldn't possibly feel more lucky to that. Like, I just don't even have the words. The other thing that's so wild is, again, I'll be starting tomorrow, and tomorrow is my dad's birthday. And for some of you guys who didn't know, my dad, who passed away after a 15-year battle with cancer in 2014, he was had a PhD in music, but he also went to law school and was very passionate about the law. And to be starting this job on his birthday is, and I haven't even told them that. I'm just telling, you know, that it's just crazy, right? And so yeah. My brain is like a sponge, you know? I can't even imagine, like, after just the first day, what I will come in with, how much knowledge, and like, you know what I mean? I know that initially it's going to be kind of learning like, their computer systems and just sort of how they do things there. And I mean, I don't even know. But it's like the way that I am though. It's like, if they're like, okay, you can go home, I'll be like, no, you're not getting rid of me. Like I'm staying, like, you know what I mean? Oh my gosh, it's like literally a dream come true. So basically, and the timing works out really well for me because I have a number of students who like were graduating high school and are going off to college. So like I'm able to consolidate my lesson schedule to be like 1 or 2 nights a week and then like weekends basically. And so that I could have this availability. But these guys are awesome. And they said that they're also really flexible. And I don't know. I can't wait. I can't wait. What did you miss? You missed a lot. So let me see what you sent me in Discord though, Meg. I haven't been on Discord, I don't think today. Oh, something about the rose petal. Oh, are they making a show about the rose petal murder? Wow. Interesting. Did you watch it? You know what's so funny? We'll have to watch this. Or, well, I'll probably get a copyright strike. Dang it. ABC 2020. Do they do copyrights? Probably. I was going to say, because we'll be able to fact check everything in it of like anything that's not accurate. You know what I mean? Hopefully it's accurate. And Meg, I know you were there for almost, if not all of that trial. So how was it? How'd they do? Hi, Mary. Welcome. For anyone who's just now getting here, you might want to back up a couple minutes so you can hear the big news. Someone else posted it. Oh, okay. I see what you're saying. Someone else posted it on YouTube. Okay. So you're saying it must be okay. It was interesting. Okay. Yeah, so you'll hear me say that I've got big news and then I'm telling the big news. I don't know, maybe 5 minutes or so. If you just start getting here, you might want to back it up to hear the big news. You could probably put it on 1.25 speed. So yeah, guys. Absolutely incredible opportunity. Absolutely incredible. And of all the things, I mean, it's like literally when I had my interview and I was like, asking them kind of like what they've narrowed their focus down to, because, they're very select. They're very select about what cases they take. Right. And like the way they described it to me, the first thing they said was, we only take the highest stake cases that there are, like the highest stakes. And then, I think they said that initially because a lot of people, if they hear death penalty cases, they would run for the hills. But I'm like the opposite. Like then they elaborated and said again, like the huge white collar crimes within the death penalty cases. And I'm like, oh my gosh, like I'm there. Like I'm there. I'm there for that 100%. So, and then they asked the questions like, so, you're not, some people, they might not want to, it might be troubling details that are difficult to hear. Again, I understand why they're asking these questions. I'm like, you guys, I'm not like, like, look at the cases I've covered. Nothing will surprise, you know what I mean? Anyway, it's just, they really were reiterating, like, this is not for the faint of heart. And, and some people might be disturbed or offended. I'm like, nope, not me. Anyway, so it's just perfect. It's great. So yes, anyway, so yeah, it'll be exciting, and I'll get to come back from a big day, and we'll be doing our care and read in the evenings, which we've been doing for the most part anyway. And every time we do, I'll get to share with you guys more about what I've learned. Obviously, goes without saying, there won't be anything specific, obviously. But as far as learning about the ins and outs and the case law and the rules and the just the inner, all the stuff. I mean, nobody needs specifics in order to appreciate all of the knowledge that will be had, so, So, okay. So now we will jump on over to the hearing. Okay. So what's funny is when this hearing happened, it was like exactly a year after the trial. Like the trial started, I think, mid-January of 2023, and this is January 29th, 2024. So here we are. All right. He comes in. If I remember correctly, there's oh, he's got like his leash thing there, I believe. There's Barbara. There's no court sound yet.
And what will happen all
right.
Ladies and gentlemen, and I now address these remarks to the members of the press. You have not been completely in accord with what I asked you to do last Friday, but you've all done me the great favor of obeying what I asked you to do with respect to the identity of the jurors, and I thank you very much for that. We will, the first order of business after I give some preliminary remarks will be the examination one by one of the jurors. And what will happen is I will bring all of the jurors in to begin with, and they will be seated. I will make remarks to the entire panel. I will then ask that the jury be taken to their jury room, and I will one by one call the jurors and address them. And I will address them by a letter that I have developed rather than their number. Now, yeah,
so too fast as she looks like kind of judge to whack someone's hand with a ruler. Y'all, she takes control of this courtroom. She's the boss. She's the boss. She's the goat, the boss. And the number of times when like Poot be like trying to pull some shenanigans, and she just like puts him in his place, and he like sits down. Yes, ma'am. Oh my God, it is amazing. It is. It's great. It's great. This day was everything you would hope for and more, given what the trial was like right from the get-go. I think we get like another minute in before already there's some shit going down.
I realize
Meg just gifted 20 memberships. Thank you so much, Meg. Thank you, thank you, thank you. And congratulations to all of those new members, courtesy of Meg, who's the best.
Full well that many of you who attended this trial for many, many weeks.
And by the way, on the next members only live stream, I've got to find some other stuff that we can do. But one of the things we're going to do is, because some of you guys requested it, is we're going to read the appellate brief that I wrote for the final exam to when I got my paralegal certificate, because that was a really big deal. And anyway, you guys wanted to see it. So that's one of the things we will do. Let me know if you guys have other suggestions as well.
We know these jurors.
The next members.
And I'm not making any further statement about what you do or don't do in terms of identifying the jurors. But I don't want any photographs.
Oh my God.
I don't want any photographs taken of the jurors by the media. With respect to the rest of the audience, if you have devices, cell phones, iPads, or anything of that nature, please silence them. Please do not use them. The press is allowed to use their devices in order to make notes, but the press is not making any photographs either. I have a pool photographer as well as a pool court TV arrangement, and that's what will be used to photograph, and that those materials will of course be fed and available to the press. I think if there's anything else. All right. All right, the jurors are in place in the jury room, Mr. Bailiff?
Yes, Your Honor.
Very good. Bring me the jurors.
Oh.
Sure.
So she's like, bring the jurors, and already Poot's got an issue.
Hold for a minute. Yes, sir.
Your Honor, you have a list of questions you have distributed to us, and
yes, sir.
Of course you went through those with Juror
Z or X.
X. I knew it was one of those
yeah.
last letters. Juror X. The third question, you say, did you hear Miss Becky Hill make any comments about the merits of this case before your verdict?
Yes, sir.
And clearly the juror didn't understand what the word merits meant.
I disagree with that, but you may make your record about that. I think the juror understood what was being asked. And frankly, in some of the materials that we...
So let me just preface this by saying that there was one juror who had to be questioned before this because they had a cruise booked or something like that. So out of the 12 deliberating jurors, one was already questioned. Juror X, I think, is that what they said? And the rest, we will hear all of them today. They won't show them, obviously, but we'll hear from them. So that's what he's referencing. But also, just wanted to point out, there's Ryan Kelly there, right behind Poot to his left. So shout out to Ryan Kelly of SLED. He's the one who conducted the investigation of the side of the road incident and all that. So
that I think the juror understood what was being asked, and frankly, in some of the materials that we exchanged back and forth about questions, you yourself have used the word merit. So I don't think she was confused.
Well, Your Honor, occasionally I make a mistake. I think in this case, perhaps you made a mistake.
Oh,
And if
God.
you would just respectfully use the words, did make any comment about the case before your verdict. Just leaves out their judgment about merits. They don't know if merits is a legal word.
I will take what you say into account, but I have already examined one juror using that term, and you now say that that term confused the juror. You have that on the record, and certainly would be able to argue that to any of the appellate courts that review what I do here. But my intention is to use the language that I used with the juror I've
she's
already
going to have to keep it the same for every juror.
interviewed.
But Your Honor, you went and did a follow-up question, our request, which elaborated on what that meant. And certainly after you asked that question, we think that clarified it, and you could use merits or anything else about the case and deal with both issues. I just think it's going to require us, based on statements that these jurors have given to SLED, to ask very specific questions.
Okay, I understand what you're asking. Let me ask you this, Mr. Harpootlian. Do you happen to have the transcript of Friday's proceedings?
I don't think so.
State, do you all happen to have a transcript of Friday's proceedings?
Your Honor, we're looking right now.
Belay that. I've got a copy. Let me look at it for a minute to see what I did in clarification. And so just pause for a minute. Let me...
There's Poot, there's Tim Griffin.
Yes, Your Honor.
I look at this transcript, and the only thing I know.
Wait, there's.
Hang Okay, all right. I said this. I asked the attorneys for any further commentary about the questions I asked, and I have been asked to ask one more question, and I'm going to do that. I'm going to read you a memorandum by the state to counsel for the defense and then ask you about it, all right? And then here's what I read. Per Chief Attorney Waters, please be advised that the attorney for Juror X has told us that his client says that prior to the defendant's testimony, his client did hear Clerk Hill say words to the effect of, quote, looks like the defendant is going to testify. This is an important day, close quote. Or, quote, this is an epic day, close quote. And that there was some statement that it was rare for a defendant to testify. And then I said, Juror X, can you verify that what I've read is something you heard and told your attorney? And she says, yes, ma'am. Very good. Do these statements have any impact on your verdict? No, ma'am. Very good. I will ask that question. I didn't change well, I've read you what I asked. I will be glad to do that again.
She's going to ask
Your
it
Honor,
anyway.
different jurors say different things based on the memorandums we've received.
I won't say you told your attorney or anything like that, but I will ask about that statement having been made.
Your Honor, just for the record, we believe the term merits is a term of art, just as if you asked them, was there probable cause?
Yeah, no, she's awesome.
Or anything else, we're not asking you to open Pandora's box.
I hear what you say, and I will take it into account.
Okay, thank you, Your Honor.
Mr. Waters, anything on your behalf?
I do not have anything further, Your Honor. We believe the term is self-explanatory.
Thank you, sir.
We believe it's self-explanatory. There we go. Now, don't worry. There's more issues that arise. This day is wild.
To go to my screen to do this other, but about this case before the verdict.
Yes, Your Honor.
Okay, that's what I'll ask. All right.
Okay. This day was so nerve-wracking for me, guys, when this happened. Oh my God, I'm like nervous again, even though I already know what's going to happen. Dude. There were some moments during this day, I tell you that.
Thank you very much. Good morning, ladies and gentlemen of the State versus Murdaugh jury. I wanted to make a few opening remarks to you before I question each of you about the matter. You have done absolutely nothing wrong. None of you, not any of you. You didn't ask to serve, but you served and did your duty. This was an unusually difficult trial because of its length. 6 weeks is almost unheard of in South Carolina as the length of a case. It was difficult because of the intense publicity and public interest in the case. It was difficult because of the complexity of testimony and exhibits in the case. And you acquitted yourself honorably. So this question today is not about anything you did wrong. Please be assured of that. I respect you and I respect your service. Today, I'm going to ask you to do something that's difficult. This case is unique. Most of the time, if there's some issue about improper conduct or contact with a juror, it comes up immediately. The judge puts questions to the juror and perhaps to the person who may have made an improper comment, and then you go on to verdict. Or sometimes very shortly after the verdict is rendered. And again, the judge questions the affected jurors and the supposed interference and
There's Alan Wilson,
makes a ruling right then and there on
General.
either a new trial or a mistrial.
juror.
Now here,
Yep.
we are almost a year after your beginning of service on this case. And that makes it mighty difficult for you to do something I'm going to ask you to do, and it's this. Today, I ask you to focus your attention. What is that? Mr. Bailiff, what is that noise?
Amazing. It's ghost.
Is that the sound system doing
I
that?
believe it's the court sound system.
This is the funkiest sound system in the world, so you just have to keep up with it. I've had trouble in every case I've ever tried with the sound system. So
Listen, we got to hear that on normal speed. This is amazing. Listen to her. Funky. She says, I freaking love this. I adore her.
Mr. Bailiff, what is that noise? Is that the sound system doing
I
that?
believe it's the court sound system.
This is the funkiest sound system in the world, so you just have to keep up with it. I've had trouble in every case I've ever tried with the sound system. So, jurors, if something happens and the sound system goes haywire, we'll stop for a minute until it stops. Now, as I was saying, I want you to focus your attention as you answer the questions I'm going to ask you on your 6 weeks of experience as a juror in this case, and on the point in the trial where the judge charged you, and on your verdict as you rendered it on March the 2nd, 2023. That's what I want the focus to be.
Look at her
Again, I know
handwritten
I'm asking
notes.
a
How
lot,
cute.
but you cast yourself back into that time.
Look at her handwritten notes. Oh my God, I love it.
But that's what the questions
Old
I'm
school.
asking are about that time and not about this time. There has been so much drama about this matter since the verdict was rendered. And my heart goes out to everyone, the lawyers and you who are in this trial. That I can't help. But I've been asked by the Supreme Court to take a look at this issue. The appeal is on pause until I do, and I've got to do my duty as I see it. And you do yours.
Y'all
as I
think
know you
these
see it.
jurors ever thought they'd be sitting in a room with Alex Murdaugh again? Imagine that a year later and you're sitting in the room with him again. Oh my God, what that must be like for the jurors.
So I thank you very much in advance for, again, the terrible
Judge Newman?
inconvenience of calling you all back together now. But it's very essential to
I love her.
completing the record about this case and placing it before the appellate authorities as it needs to be. So in advance, I thank you. What I'm going to do now is dismiss you.
If I remember
the
correctly,
jury.
she made history. I'm trying to remember. She made history in a lot of ways, but I think one of them was she was like the very first female Supreme Justice of the South Carolina Supreme Court, and like among other things, she's just like a boss lady.
And one by one, I will call you and I will refer to you by a letter that I have just assigned you that isn't your jury number.
I might be with you on that night. I also love Judge Newman, but she's
these
awesome.
people in the media saw y'all all through the trial. They probably know
She doesn't take no crap.
But I'm trying to do my duty as I see it when I make your appearance here anonymous.
There's Kane.
To the record.
Welcome, Kane.
And only the clerk, the court reporter will have a sealed document by me indicating what the key means in terms of your juror number and your name. So I'm doing everything I can do about this matter. But it goes without saying that your business is your own business. You don't have to interview with a soul, not lawyers, not media, not anyone after this matter. That choice is purely yours. And I will respect that and protect that to the best I can if anything comes up afterwards. All right, you may go to the jury room.
Now, if I recall, they have another issue. There's so many, it's hard to remember when they all happen. It's just wild.
Doesn't matter.
Yes,
Literally.
bring me Juror Z.
Now, Juror Z is like one of the biggest deals in this whole thing. And she's right, bring me Juror Z, but then here's Poot again. You guys, you can't make this shit up. Par for the court.
All right, Mr. Bailiff, bring me Juror Z.
One other matter.
Yes,
There
One of
he
the
is.
individuals sitting in the jury box called this, the next jury, liar publicly. I'd ask that that be Mr. Bland and his partner, cohort, not sit behind her or near her while she's testifying.
I object.
Well,
Your Honor, I object to him speaking.
One moment.
Lord have mercy.
We're gonna have a big colloquy about this.
Oh my God, the drama. Let's hear this again. Meg, are you saying Judge Werner as in the same Judge Werner from the Esther McCandless trial? Because that was a Judge Werner. There could be more than
Liar
one.
publicly. I'd ask that
Oh my God.
that be Mr. Bland and his
Wow.
partner, cohort, not sit behind her or near her while she's testifying.
Uh,
I object.
well,
Objects from the gallery. This is insane.
Your Honor, I object to him speaking.
One moment.
Unbelievable.
We're not gonna have a big colloquy about this.
Guys,
You keep your seat for a moment, Mr.
Yes.
Harpootlian.
Yes, Your Honor.
Mr. Bland, you do
it's like children. She's like, dude.
the same. Mr. Bender, is there a seat over next to you?
Oh my God.
Mr. Bland, will you go over and sit next to Mr. Bender, please? Thank you.
Thank you, Your Honor.
It's like with toddlers or siblings, like fighting. Oh my God. I adore it. She's like, let me just handle this right now. Oh.
For the record, I have some people in the jury box. Two of them are
Right.
SLED agents. One of them is the media consultant, and one of them is attorney for
I also like
several of
I also
the
liked him a lot.
jurors, Mr. Bland. And that's being done at my direction.
Hey, Justice Toal, you have Scott Mongillo, Blaine Richter, also in the jury box.
Very good. Yes, sir. That's fine. All right.
Oh God. Let's try
Bring me Juror Z.
take two. So while they're getting Juror Z, so now I'm remembering actually the judge in the Ezra McCandless trial was Judge Peterson, actually. Now I'm remembering. Yeah, Judge Werner. And I think I saw him preside over another trial, not just Letitia's. Is there another one that you guys can recall? I did really like him though. Well, yeah. Dude.
Sworn. Step over here to the clerk and she will administer the oath.
Do you swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. Please proceed.
That's awesome.
Juror Z, I will ask you some questions, and there are no right
Okay.
or wrong answers. The truth is what I seek, and that is the truth of what you experienced in relation to these questions at the State versus Murdaugh trial. You rendered a verdict on March the 2nd, 2023. That verdict was read in open court by the foreperson of the jury. And then the court said this: Madam Forelady and members of the jury, if that is your verdict of each and every juror, let it be known by raising your hand. The transcript then indicates that the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate statement about your verdict at that time?
Yes, ma'am.
Right. Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, ma'am.
Did you hear Miss Becky Hill make any comment about this case before your verdict?
Yes, ma'am.
If yes, what did Ms. Hill say?
Oh boy. To watch his actions.
To watch his actions. What else?
To watch him closely.
To watch him closely.
So nerve-wracking.
Anything else you remember?
There it is, but I can't remember.
Okay, that's fine. I
think Juror Z is also the one that
was your verdict on March the 2nd, 2023, in any way with any influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
Yes, ma'am. Yes. I literally, I'll never get over this. Like literally at this moment, I was like, I died. I die again. I was like, holy shit, he's going to be getting a new trial. Because remember, as for the South Carolina with the two prong is was the verdict influenced, right? So it's like, it wasn't the end of the world that she said something, at least at this juncture. But when that came out, and then it was like, oh my God, but they talked over each other.
Influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
Yes, ma'am. Yes, please.
All right. Was your verdict
Oh my God.
influenced in any way by the communications of the clerk of court in this case?
Yes, ma'am.
And how was it influenced?
To me, it felt like she made it seem like he was already guilty.
Right. And I understand that. That's the tenor of the remarks she made. Did that affect your finding of guilty in this case?
Yes, ma'am.
All right.
Oh my God. Oh my God. It's like at this moment I was like, dude, he's getting a new trial. But then I think there's more.
It is. Those are my questions are submitted to the juror. Are there any reactions, further questions, and so forth? If there are, and you would like to voice them, I can ask the juror to retire to the jury room. Just tell me whether I need to do that.
That's funny, Meg.
All right, sir.
So what's funny is Poot ends up stepping in it.
We need to put some things on the record. Too.
All
Right here. So here's what happened. Like literally at that point, new trial. She just said that it influenced her verdict. Given the South Carolina, the two prongs, right? Done. I mean, you don't even, I'm sure they would have still inquired as to the other jurors, but you didn't even, it doesn't matter what they say. That's new trial. And here, Poot ruins it.
Take the
I don't understand why.
juror to the jury room, please.
It is bizarre. But like at this point, I was like on the floor or something like, oh my God, oh my God, oh my God, it's over. He's getting a new trial. And then, but wait, there's more. Poot comes in like a wrecking ball.
Mr. Waters.
Yes, ma'am. Your Honor, in the affidavit that was given by this particular juror, paragraph 10 said, I have questions about Mr. Murdaugh's guilt, but I vote guilty because I felt pressured by the other jurors. We would request an inquiry as to that, which is how, when this motion was filed, she expressed the basis for her verdict, which obviously this answer is a little different now. So we would request a brief inquiry from the court as to that specific issue.
All right.
Thank you, Your Honor.
Mr. Harpootlian?
Your Honor, as to two things. The first thing is, he is correct. She gave an affidavit. We would ask Your Honor to let her read her affidavit to refresh her memory of, she said other things. They're very detailed in here. We'd ask you to, and let me hand up to the court a copy of her affidavit and ask you to have her read it before she's asked any other.
What I have here from Mr. Waters, for the record, Mr. Waters, what I've been handed for the record is something, affidavit of juror, now referred to as Z. It was taken August the 14th, 2023. It was sworn before Holly Miller, paralegal for Mr. Harpootlian, and he would like for me to give that to the juror and ask her to read it, and then
Don't go
ask
back
her
to
about
lurking.
it.
We
I'm
love your dumb
inclined
jokes.
to do
Stop
that,
them.
but I want to hear from you first.
Your Honor, again, if they want to refresh the recollection, that's fine with the state.
No kidding.
So we have no objection to that.
Very good. It will be done.
Your Honor, also, we would ask that you not ask the question that
This is the problem right here.
that Mr. Waters
So this is where he realizes that he just made a big mistake.
asked you to ask, because it violates Rule 606B, which provides, upon an inquiry into the validity of a verdict or indictment, a juror may not testify to the effect of anything upon that or any other juror's mind or emotions.
What was the question he asked?
If you look at that affidavit,
It's paragraph 10, Your Honor.
paragraph 10,
It's in the very affidavit.
she said she was influenced by other jurors.
Yeah, I'm
Okay.
gonna ask her about that. I'm gonna give her the affidavit and then I'm gonna question her about it.
And we would, for the record, indicate that we object to that under 606B.
Oh my God.
From our perspective, she's put an
Now,
issue.
you're the one that asked me to have her look at this affidavit, but you telling me I can't question about it? I deny that objection.
Your Honor, if it's something that's inadmissible, you should not ask her about it. And that's
Well, you
your
want me to admit it and have her examine
No, I
it?
want you to have her read it to refresh her memory.
We're quibbling.
This is insane. So what this is in this affidavit, the juror had said that it was the other jurors that pressured her to get to a guilty verdict or whatever, right? But the thing is that is part of the jury deliberation process. There's nothing untoward about that. And the question is, was it the other jurors that pressured her, or was it, or impacted her verdict, or was it Miss Becky's comments, right? So what's going on here is Poot is like, hang on, I want this affidavit to be made as part of the record. I want you to ask her questions about it or what have you. And I think he must have done that before he realized that that particular question was part of it, because this is a huge error on his part, because now there's going to be a question on here in this affidavit about, or rather an answer where she says it was the other jurors who influenced her. And so now he's trying to do takesies backsies. Oh boy.
David, but you telling me I can't question?
Honestly, had he not done this, probably at this very moment, on this day, new trial for Murdaugh. Like, this is, he single-handedly messed the whole thing up here, because this completely changes the outcome. It's insane.
Question about it. I deny that objection.
Talk about a roller coaster of emotions, right? Because here I was at the time, and everyone else watching, like, he's getting a new trial, and now it's like, wait, hang on, what?
have her look at this affidavit, but you telling me I can't question about it? I deny that objection.
And then she says, one.
If it's something that's inadmissible, you should not ask her about it. and that's
Well, you want me
inadmissible.
to admit it and have her examined
No, I
on it.
want you to have her read it to refresh her memory.
We're quibbling, Mr. Harpootlian, we're quibbling about things that I'm not going to take time to quibble about.
Yes,
My
ma'am.
ruling is pursuant to your request,
Oh my
I
God.
am going to allow the juror to examine her affidavit, and then I'm going to question her about it. That's my ruling. Your objection is overruled.
For the record, I just want to know, Your Honor, just for the record,
You noted 606. I hear you noted.
and in no way waiving anything or opening any door by asking you to let her
That's
examine.
for a higher court than me to decide.
I
Unbelievable.
understand that. And that's why I want to make sure when they read this transcript, there's no confusion. I'm not asking you to put that into evidence. I'm asking you to
Well,
let
I
the
don't see
jury.
how in the world I can question the
Right.
juror about something and not put it into evidence. You can't have your cake and eat it too, Mr. Harpootlian. You could.
Famous words right there. You can't, dude. Dude, look at him pointing. Wow.
Evidence. I'm asking you to
Well,
let
I
the
don't see
jury.
how in the world I can question the juror about something and not put it into evidence. You can't have your cake and eat it too, Mr. Harpootlian. You could have been very satisfied with the answers that were already given.
God.
But you have chosen to
You cannot make this up. This is pure gold. She's telling him right. She's laying it out for him right now that he just ruined this entire fucking thing. This is insane. Welcome, Kitsmits.
I'm asking you to
Well,
let
I
the
don't
jury.
see
judge.
how in the
Unbelievable.
world I can question the juror about something and not put it
You
into
ruined it.
evidence. You can't have your cake and eat it too, Mr. Harpootlian. You could have been very satisfied
You could
with
have been
the
satisfied.
answers that were already given.
Yep.
But you have chosen to
You
add,
could have been satisfied with your client getting a new trial, but no.
to ask about this.
Request.
Denied.
Your Honor, all the time we ask witnesses
Oh my
to examine a prior statement.
Mr. Harpootlian, I made my ruling. Please take your seat. All right, bring me.
This is one of the many times where he's like a little kid getting scolded or a dog with a tail between his legs. Look at this. Look at how she handles him. I adore this so much.
Time we ask witnesses to examine a prior statement.
Mr. Harpootlian, I made my ruling.
Watch.
Please take your
Watch
seat.
him. Watch him.
All right, bring me Juror Z.
And here's where the whole thing just.
Yeah.
Guess what? No new.
Yeah.
The roll, y'all. The roller coaster of this hearing is beyond. I know, right? Cue the song. Kitsmits, I had some big news earlier.
Juror, you gave
Okay.
an affidavit to a representative of Mr. Harpootlian on August the 14th, 2023. And I have this in my hand at the present time. And I'm going to hand it to you. And I'm going to ask that you read it. Tell me when you completed reading it. And then I'm going to ask you some questions. You're going to see 4 little boxes on this affidavit. They are your name and the names of 2 of the jurors. I will strike that out before it appears in the record, just so you understand.
It was big news. Big news. You may want to go back and find it. It's not, it's, what was it? Maybe 10 minutes into the stream, I start talking about my big news, and then you can probably listen to it at like 1.25 or something, because I had to do it kind of slowly because I'm still in shock. Maybe do it on 1.5 if you want to. Eventually, I'm sure I'll have to retell the news, but I don't want to like bore everybody to death by repeating it every times. So I'm trying to hold off at least a little bit before I end up having to tell that story again. Some of you guys just heard it because we haven't been streaming for that long. So.
Second paragraph.
Okay, here we go.
The first paragraph, of course, is a statement that you are a juror in the case. Second paragraph says, toward the end of the trial after the President's Day break, but before Mr. Murdaugh testified, the clerk of court, Becky Hill, told the jury, quote, not to be fooled, unquote, by the evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testifies. Is that what your recollection is of that statement?
Yes, ma'am.
Is there anything in the statement that on reflection you think is not correct?
No, ma'am.
All right. Number 3, she also instructed the jury to, quote, watch him closely, quote, immediately before he testified, including, quote, look at his actions, quote, and, quote, look at his movements, quote, which I understood to mean he was guilty. Is that an accurate recitation of your view of the matter?
Yes, ma'am.
Number 4, paragraph 4. Immediately after he testified, the foreperson said Mr. Murdaugh was crying on cue. Is that an accurate statement of what you saw and heard?
Yes, ma'am.
5, the foreperson criticized the former foreperson for handing Mr. Murdaugh a box of tissues when he was crying on the stand while testifying about his murdered son. She told the jury, we cannot interact with Mr. Murdaugh because that's what the defense wants us to do. Do you still stand by that recitation of that conversation?
Yes, ma'am.
All right. Number 6, the jury frequently discussed the case during breaks before deliberation. Is that correct?
Yes, ma'am.
All right.
Ruh-roh.
Number 7, toward the end of the trial, Ms. Hill came into the jury room a lot. Is that your recollection?
Yes, ma'am.
Ms. Hill and the foreperson had private conversations on multiple occasions. The foreperson would tell the bailiff that she needed to speak with Ms. Hill. Ms. Hill would arrive, and then she and the foreperson would go to another room for a private conversation. The conversations typically lasted 5 to 10 minutes. The foreperson never said anything about the content of the conversation. For example, she never communicated logistical information after these conversations. This happened 2 or more times, more frequently towards the end of the trial. Is that still your recollection of the interaction?
Yes, ma'am.
9, when we began deliberations, Ms. Hill told us this shouldn't take us long, quote, and if we deliberated past 11 p.m., we would be taken directly to a hotel. We had driven from our homes that morning and were not prepared to stay overnight. Additionally, smokers on the jury asked to be allowed to take smoke breaks, but they were told they could not smoke until after the deliberations were complete. Did you hear that?
Yes, ma'am.
Including the business about the smokers?
Yes, ma'am.
All right. Number 10, I had questions about Mr. Murdaugh's guilt, but voted guilty
There we go.
because I felt pressured by the other jurors. Is that an accurate statement about your verdict?
Yes, ma'am.
Okay.
After the verdict and immediately before sentencing, Ms. Hill pressured the jury to speak as a group to reporters from a television show. Is that an accurate statement of what she said?
Yes, ma'am.
And did some jurors decline to do that?
Yes, ma'am.
Yeah, let me get back. Where are my questions?
Thanks, Kidlet. Are you glad you went back and listened? I figured you probably would be.
Juror Z, I asked you previously was your verdict on March the 2nd, 2023 influenced in any way by communications from Becky Hill, the clerk of court? You answered that question, yes. In light of what you said in the affidavit, which is I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. Is that answer that I just read a more accurate statement of how you felt?
Yes.
Overruled.
Sit back down, Poot.
Yes, ma'am.
All right. So you do stand by the affidavit.
Yes, ma'am.
Very good. Thank you.
Stands by the affidavit. There
You
you
may
go.
go to the jury room.
So now at this moment, it's like, okay, so new trial question mark, but this completely changes things, and only because Poot stepped in it. Incredible.
And let me just explain to you what the procedure will be. I'm calling the rest of the jurors, of course, one by one. When I'm finished with that, I will bring you out as a group one more time, and then you're free to leave. You don't have to stay. Okay? Very good. You may go to the jury room. What's that?
Before this juror is excused, but after she steps out, I'd like to address
All
the
right.
court.
You may be excused.
Your Honor, just very quickly, I do have a redacted copy I can hand up to the court if you want to make that use of the court's exhibit for this witness.
That's good. What I'm going to try to do is redact as I did in the as you did in the document that you sent me. The identifying thing redacted now.
He has an extra copy of the redacted.
I have it
Oh,
right here.
oh, good. That's great. That would be wonderful. Show it to Mr. Harpootlian.
I've seen it.
Very good. Thank you. That's the one I will give to the court reporter, but I think you can see that I asked off of it. This is a court's exhibit.
3.
Court's exhibit 3.
Your Honor, just to be clear, that does still have the juror numbers in it. It does not have the letters.
Yes, what I'd ask you to do, Elizabeth, is take off the juror numbers, just strike them through, and then where it says affidavit of juror and gives a number, just strike that out, and you can put in pen Z. Thank you. Yes, sir. Mr. Harpootlian.
Your Honor, we objected to the questioning because this juror gave 2 statements under oath, one in an affidavit and one here to you today. The one here today was Becky Hill influenced her verdict.
Yes.
The one she gave in an affidavit 6 months ago was based on jurors.
Oh my
It
God.
could be both. Your Honor, it picked out the one in the affidavit from 6 months ago and said, is that a more accurate statement? That presupposes and suggests to her what she should say. And
Poot, it's
we
too late.
believe
You
that
ruined it.
this juror's testimony, and Your Honor, I'm afraid what you're going to say is, well, she said the affidavit was more accurate than what she testified under oath here today, and therefore I'm not going to consider her testimony. And I think that's where we're heading here. I'd ask you to bring her back in, explain to her there's nothing wrong with it both being
Oh
true.
my God. They can't
I decline to do that. And
both be true though, Poot. Thank
overrule
you,
the
Kid
objection.
Slits.
All right.
Look at him. And now's the second time. Now there could have been other times where he sat down like a kid that's being scolded, but we didn't see them. So this is the second time where we're seeing him sit down like really sad face because he's ruined it.
With it both being true.
I decline to do that and overrule the objection.
Watch him. Watch.
All right.
Wah, wah, or whatever. Play.
Mr. Bailiff.
Cue sad music. Oh, look at him. He almost stands back up, it looks like. Does he think she's going to change her mind? That's very sad. Poot.
Mr. Bailiff.
Yell it.
Yes, sir.
Perked up like she was going to be like, oh, wait, no, just kidding. Yeah, right. Work has no sound at the moment. Now, this might be when they have another issue. I think so.
Counsel, I have to report this to you, and I'm
Lord have mercy. What? Unfreaking believable. This is when it's like, what now? What now? What else could possibly go wrong?
very, very unhappy about it, but there's nothing to do but put it on the record, and then I will proceed with questioning the rest of the jurors. The jurors' cell phones were not confiscated or taken from them, and they tuned this thing in on court TV and listened to all of what just went on. So you may make whatever statement you like to make, and then I'm going to go on and question the jurors. I will tell you in advance, I am not going to stop the proceedings or do anything to interrupt them. I'm going to get the rest of this on the record. You might imagine that they no longer have their cell phones with them.
Your Honor, we have a 5-minute recess to discuss what we need to put on the record. I mean, this is.
I'm not going to take all day on this thing. I report things as they come to me. I will give you a couple of minutes, and then we're going to, they were late getting here. I didn't get to start on time like I wanted to. So I need to just calm down a little bit. But I tell you, don't take any long period of time.
So now we've learned that the jurors are in the back room or whatever that are waiting to be questioned, watching this very proceeding on court TV on their cell phones.
And then we're going to, they were late getting here. I didn't get.
And from what I recall, I'm sure they'll hear more about it again. From what I recall, it wasn't, they weren't supervised. Like, just no one was supervising them, and no one told them they couldn't do it. So it's not like they were told not to do it and they didn't. No one said anything to them, so they were just watching it on their cell phones.
All day on this thing.
Unbelievable.
I report things as they come to me. I will give you a couple of minutes, and then we're going to, they were late getting here. I didn't get to start on time like I wanted to.
She's grumpy.
So I need to just calm down a little bit, but I tell you, don't take any long period of time. Court will be in recess for 5 minutes.
I need to just calm down a little bit. Okay, court's in recess for 5 minutes. Dude. All right.
Record here, which is
Glad to hear you're back in the present, Kitsmits.
Do you swear or affirm that the testimony you're about to give today to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
We're still one sub away from 2K also. Big things happening over here.
I will address you as Juror C because
All right, new juror.
Designated from your juror number at Colleton to letters of the alphabet. I'm trying to protect the anonymity of the jurors as best I can. I can't promise you with all the time that they spent seeing you all in the trial case that they won't.
Yeah, apparently they just didn't bother appointing somebody to.
Which is all I can
Just
control.
insane.
I will address you as Juror C.
Yes, ma'am.
And before I begin, I understand that there may have been some cell phones activated in the jury room and the watching of the questioning of Juror Z. Did that take place?
I know people were on cell phones, but I'm not sure of what they were watching.
Were you on a telephone?
No, ma'am, I was not.
Very good. I don't think I have to go any further then. Thank you, sir.
Now, what's interesting is I don't actually remember what each juror says. Like, I can't remember. This will be fun to find out because I haven't watched this since last year. Like, if any of them admit to it. Like, yep, I was on my phone. I was watching it. We know it was happening, but do any of them admit? We'll see.
You rendered a verdict on March the 2nd, 2022. The verdict was read in open court, signed by the foreperson of the jury. And the court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your hand. The transcript then indicated that the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am.
Was your verdict based entirely on the testimony, evidence, and law presented to you in the case?
Yes, ma'am.
Did you hear Becky Hill, Clerk of Court of Colleton County, make any comment about this case before your verdict?
No, ma'am. I wasn't privy to any of that.
All right, sir. Was your verdict on March the 2nd, 2023, influenced in any way with any communications by the Clerk of Court, Becky Hill, in this case?
No, ma'am, it was not.
Very good. That completes my questions. You may retire to the jury room.
Okay. Next juror. I love that lady's hair color with the green blazer. It's like a really dark burgundy. Looks nice with that green. My hair used to be that color a long time ago, among other things.
Bring me Juror F.
I love how for each one she stands up. It feels very like noble, like you know, like Matt back when like I don't know, I'm thinking like medieval or Renaissance, where it's like the king stands up, or in this case the queen, and makes a big announcement. I don't know, just the way she does it. It's very regal, right? The way she stands up. Watch.
Bring me Juror F.
And she does it for each one. Now let me put it on normal speed. I just freaking adore it so much. Because we're losing some of the majesty. Okay. Here we go.
Bring me Juror F.
She doesn't have to stand up, but I'm so glad she is, because that makes it amazing. Just love it, man. Wow, look at all the people. I wish I could have gone. Oh. I guess that's court squad. That better not be a juror. Was that? Okay, phew. Sorry. I was like, wait a second. If they showed a juror on accident, did I forget about that or what? No, it wasn't a juror. So.
Good morning.
Morning.
I
Hold
have
on, what did I
designated
try?
the jurors by a letter, and that's how I will be addressing you this morning, and I will be addressing you as Juror F. Now, I realize that you folks were on the jury for a long time, over 6 weeks, and people may know who you are, despite my efforts to protect this record. But to the extent I can, I will protect this record and your anonymity as a juror in this record. So just wanted you to understand why I'm addressing you as Juror F. This morning, it was brought to my attention that some jurors were perhaps on their phones listening or looking at a broadcast of the questions to the first juror I examined, Juror Z. Is that something that you know anything about or experienced?
Yes, ma'am.
Did you activate your own phone?
Another juror did.
All right. And will what you saw and what you looked at in any way affect your testimony as you're about to give it?
No, ma'am.
Very good. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court and signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript that indicates that the juror complied. The jury was individually polled and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? Each juror answered yes. Was your answer an accurate answer about your verdict at that time?
Yes, ma'am.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Absolutely.
Did you hear Miss Becky Hill make any comment about this case before your verdict?
No, ma'am.
Was your verdict on March the 2nd, 2023 influenced in any way by any communications by the clerk of court, Becky Hill, in this case?
Absolutely not.
Very good.
Good. Good news.
That's all the questions I have.
I'd like to discuss the matter with you before we finish with this.
You may go to your jury room. and keep yourself ready. I don't know if I'm going to have any further questions, but
So
as far as I'm concerned,
Who's now got another special matter? It's like, you've got to be kidding me. I think this is one of the times he tries to get the egg lady to come in, which is, again, this is just hysterical.
the
Comical.
questions that I'm asking are at an end, but I need to consult with the attorneys before I can dismiss you. You may go to your jury room.
Your Honor, in interviewing the clerk of court for Barnwell County, who worked as an assistant to Ms. Hill during this trial, and interviewing the alternate juror who was not, wasn't needed, wasn't dismissed for any particular reason other than wasn't needed. Both of them indicate they believe that Ms. Hill transported this juror by her personal vehicle or a bailiff's vehicle.
No, we're not yet. We're not even to the egg lady juror yet. I forgot about this one. Another thing. This is insanity. This was another bombshell dropped on this day. We're at like number 11 or something. I don't even know. I've lost count. This is insane.
Wasn't needed,
God.
wasn't dismissed for any particular reason other than wasn't needed. Both of them indicate they believe that Ms. Hill transported this juror by her personal vehicle or a bailiff's vehicle at least once during the trial. So I would ask you ask her during the trial, did Becky Hill either drive or ride with you in a vehicle before or after court? If so, what, if anything, did Becky Hill and you discuss?
All right, what's your position on that, Ms. Waters?
Your Honor, I have no objection to that. Your Honor.
Yes, all right. All right, bring the juror. This is Juror C, returning to the stand. The same juror. Yes. Thank you, ma'am. Of course, you're still under oath. And I have this question for you. During the trial, did
Welcome back,
Becky Hill
Angel.
either drive or ride with you in a vehicle before or after court? If so, what, if anything, did Becky Hill and you discuss? Do you recall that at all?
Could you please ask that again?
Ma'am?
Could you please ask the question again?
Sure.
Sorry.
During the trial, did Becky Hill either drive or ride
Here,
with
because
you
we all
in a
say no,
vehicle
if I recall.
before or after court?
No, ma'am.
All right, then I don't need to ask a second question. This will conclude your testimony. You are dismissed. I'm going to ask the jurors to stay with me until I've completed this process, and then you are free to go. Thank you so much.
Okay. On to the next juror.
Exhibit number 4. As in Lima, yes.
Hey.
Thank you so much. All right. I have redesignated each of the jurors in the record for this case. And so I will be referring to you as Juror L, as in Lima. And, you know, y'all are all on this jury. If these people saw you for 6 weeks, they may know or be able to identify you, but I'm trying to, as best I can, protect your anonymity. You don't have to talk to anybody about this at all. That's purely your prerogative. Oh, yeah. Juror L, before you came to testify and were sworn, you were in the jury room with the other jurors. I understand that some may have looked at their cell phones and looked at pictures of the proceedings as they involved the first juror who was examining. Did you see any of that?
People had their phones out. Yes, ma'am.
Did you look at any of it?
No, ma'am.
All right. And I don't need to ask you anything further about that.
She also
You
said that.
rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury, and the court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was then individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? and each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, Madam Justice, yes.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, Justice. Yes, ma'am.
Did you hear Becky Hill, the clerk of court for Colleton County, make any comment about this case before your verdict?
No, ma'am.
Was your verdict on March 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
No, ma'am.
Very good.
All right.
Juror L, thank you, and you are dismissed. I will send word back by the bailiff if there are any further questions and go to the next one. This proceeding. E.
Next juror. Juror E, I believe. Okay.
Sir, I will be addressing you as Juror E this morning. I've designated the jurors by letter. I realize that you sat on this jury in Colleton County for a lengthy period of time, 6 weeks or better, and people may know who you are. But to the extent I can make this record a record that protects your anonymity, I am doing that. You don't have to speak to a soul about this matter after you're finished, and your service will be complete, as I'm sure you thought it would be when you rendered your verdict. I have these questions. You rendered a verdict. Oh, yes. It was brought to my attention that cell phones of the jurors were accessed in the jury room for a time, and that some were able to examine the broadcast of the testimony of the first juror called Juror Z. Was your cell phone one of those activated to look at the proceedings?
No, ma'am.
Did you look at the proceedings on any other cell phone?
No, ma'am.
So far, everybody said they haven't looked
You
at it.
rendered your verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
It was.
Was your verdict based entirely upon the testimony, evidence, and law presented to you in this case?
Yes.
Did you hear Miss Becky Hill make any comment about this case before your verdict?
No.
Was your verdict on March the 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
No.
Thank you, sir. That completes my questions. You may go to the jury room. I always consult with the lawyers to see if there are any further questions. If there are not, please stay with the jury until I dismiss all of you. I'm hoping that won't be too much longer. Thank you, sir.
Thank you.
All right. Anything from the state? And from the defendant? Very good. Bring me Juror P, as in Paul. Yeah.
Well, that's interesting, Kitsmits. What did they say it was? March
Affirm that the testimony you're about to give in this case to be the truth.
3rd?
Nothing but the truth, so help you God.
Forget.
Thank you.
Happy belated birthday, though.
Good morning.
Good morning, man.
I will be addressing you as Juror P, as in Paul. I tried to redesignate the jurors without their number and, of course, without their name. Now, I realize you spent 6 long weeks hearing this case in open court in Colleton, and many people may know who you are anyway. But to the extent that I can make this record such that it protects your anonymity, I'm going to do that.
Yes,
And you certainly are not obligated to talk with one soul about this matter. Did you have your cell phone?
No, ma'am.
Did you examine any cell phone broadcasts?
There was a couple people, but I have no clue what they were viewing.
Yes, sir. Okay. Did any of this activity by other people in viewing this material have any impact on you in terms of your testimony today?
No, ma'am.
All right. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was individually
For a
polled,
second.
and each was asked, was that your verdict?
Yep.
Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
It was.
Did you hear Becky Hill, clerk of court for Clarendon County, make any comment about this case before your verdict?
I did. Yes, ma'am.
What did she say?
It was the day that Mr. Murdaugh was taking the stand,
Yes, sir.
and she made a comment about watch his body language.
About watch his
body language.
body language. I see.
Yes.
One thing that's interesting is that I noticed at one point we were going through the, you know what it was? I think it was when we were watching the opening statements on this time around, that I noticed in opening statements, and I also noticed it in closing, but I didn't point it out then. But what I noticed, and I pointed out during opening statements, was that in opening statements, Creighton says, when it comes to witnesses testifying, he's not talking about Alex specifically, but he's talking about when witnesses testify and witness credibility, right? He says, when witnesses testify, watch them, watch their, he says something like almost verbatim, watch them closely. You know, you can tell if they're being truthful or not, things along those lines. And then in closing, he actually brings it up as it pertains to Alex, because at that point, Alex has testified, right? And he references how Alex was on the stand, which he's allowed to do. And it was interesting because I was like, you know. Anyway, and I feel like there were maybe some other times it was said also. But in other words, it made me think, could it be that, you know, because some of the jurors remember that and others don't, as far as Becky's concerned, right? And could it be that, not blaming the jurors, but could it be that some of them are remembering that because maybe when he testified, she did say, this is a big day, maybe she says some of that, right? But that in their minds, you know, a year later or whatever, it's like she said to watch. I mean, I don't know. She may have said it, but it's just interesting that not everybody heard it. And it is also interesting that that was said multiple times at different points during the trial. And I just wanted to make sure to note that because when I heard it, I was like, this time around watching the opening, I was like, and I was like, did y'all hear that? And I was like, that's like verbatim what they said Becky said, but it was like an opening. And then again, he says it again in closing pertaining to Alex. And that's before they deliberated. So, right, exactly, Kitsmans. Makes you wonder if the jurors conflated it. It certainly does, which is not, again, because like more jurors heard Becky say something that was more innocuous. But like, what is it? I think maybe 3 jurors total here. I should have been counting at this point, but I wasn't counting. But like, I think it's 3 jurors say that they heard that specific thing. So, yeah. Considering there was so much talk about watching body language from the witness stand, it would be an easy thing to do when what Miss Becky said about him testifying is the thing that is at issue, and it's a year later. You know what I mean?
Yes, ma'am.
And what else?
That's all I can recall.
All right, sir. Was your verdict
We
on
were
March?
split into 2 rooms, but my recollection is that people from either room heard it. And then I feel like at one point it came out, this was all from the investigation prior to this hearing, right? This is my memory from a long ass time ago at this point. But when like there was the affidavits, and we covered all this again, this a long time ago. But like my recollection is that some of them said it was like in the hallway or when they were being brought into the courtroom, like while they were walking. Like I feel like at least one juror said that was when it was said, which would mean that all the jurors were present. Because I remember thinking that was a point that was fascinating. Do you guys remember? I wonder if I could find those documents at this juncture.
The 2nd, 2023, influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
No.
All right. That completes my questions, Juror E. Or
P.
P, Juror P. You may go to your jury room. You are free to refuse to discuss this with anybody. That's your prerogative. You're not required to talk about this anymore. That's your business. I've tried to do the best I could to confine this thing, but I appreciate your service. Thank you, sir, and you may go to your jury room.
Thank you, ma'am.
Any questions by the state?
Nothing from the state, Your Honor.
All right, by the defendant.
Nothing, Your Honor.
All right. Bring me Juror O.
I'm trying to remember too, like if they did have a hearing before this, didn't they? Maybe 2 hearings, I'm remembering. It might be worth going back and watching those because that's where I think some of those details get hashed out. That might be the way to do it versus trying to find it in those affidavits. I see my memory's coming back. I'm like, yeah, that's right. They had hearings, at least 1 or 2 hearings where they laid out the ground rules for this whole thing. So like, I think one where the issues were first raised and then another one where they discussed what to do about it. And it would have been at the end of 2023. That's right. Okay. That might be a good thing to check out maybe after we finish this. Even though we'll be going in reverse chronological order, but I forgot that.
Good morning, Juror O. I have designated the jurors by letter.
Okay, we know about that. We're going to go ahead.
Let's see, from any disclosure. Several jurors may have activated their cell phone during the testimony of the first juror and looked at the proceedings. Are you aware of that?
Yes, ma'am.
Did you activate your cell phone?
No, ma'am, I did not.
Did you watch any of the other cell phones?
No, ma'am, I did not.
Very good. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was individually polled and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am, it was.
Did you hear Miss Becky Hill make any comment about this case before your verdict?
No, ma'am, I did not.
Was your verdict on March the 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this matter?
No, ma'am, it was not.
Very good. That concludes my questions. You may return to your jury room. I ask that you stay until I comply.
Okay.
Very quickly, I think question 2. I don't know that we did question 2.
Okay. Resume your seat.
Resume your seat.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, ma'am, it was.
Very good. You're excused.
I'll help you, God.
Or so as to preserve your anonymity record of this case, I have tried to do so. You are completely free not to talk to a soul about this matter. That's always your prerogative. I understand that before you came out here, when the first juror to be examined was being examined, that some jurors may have activated their cell phones. Were you one who activated your cell phone?
No, ma'am.
Were you aware that some cell phones might have been activated?
I was aware of that.
All right. So, did you hear anything about the examination of the first juror?
No, ma'am.
Thank you, sir. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was individually polled and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, ma'am.
Did you hear Miss Becky Hill make any comment about this case before your verdict?
Not to me, ma'am.
Did you hear her make a comment to anybody else?
Not that I'm aware, ma'am.
All right, sir. So you don't remember any details of any conversation?
No, ma'am.
All right, sir. Was your verdict on March the 2nd, 2023, influenced in any way by any communications by the clerk of court, Becky Hill, in this case?
No, ma'am.
Thank you, sir. That completes my questions. I am going to excuse you. Stay together with the other jurors until I've completed my examination, and then you will be free to go. Thank you so much.
Thank you.
Designated by letter, and you sat on this jury for 6 long weeks, and I'm sure that those who were there in the trial for a long period of time may know who you are. I'm just doing the very best I can to make your participation in this matter anonymous, and I will preserve that anonymity. You are free to not talk to one single soul about this if you don't want to. That's purely your prerogative.
Yes, ma'am.
I understand that when the first juror was being questioned, some members of the jury, as you were back in the jury room, may have activated their cell phones. Were you one who activated your cell phone?
No, ma'am. I left my phone in the car.
And did you hear any information coming from anybody else's cell phones about that examination?
I did.
All right. Does that have any impact on the testimony you are going to give today?
No, ma'am.
Very good. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? Each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am.
All right. Was your verdict based entirely on the testimony, evidence, and law presented to you in this matter?
Yes, ma'am.
Did you hear Miss Becky Hill, the clerk of court for Clarendon County, make any comment about this case before your verdict?
No, ma'am.
Was your verdict on March the 2nd, 2023, influenced in any way with any communications by the clerk of court, Becky Hill, in this matter?
No, ma'am.
Very good. That is the end of my questions, Madam Juror. You may go to the jury room, stay with the jury until I've completed the questioning, and then you're free to go, and you're free not to say anything you don't want to say. And if anybody upsets you or bothers you in any way about that, you just let the court know. Thank you. Any further questions from the state? Any further questions?
Nothing for the bench, Your Honor.
Very good. All right. Bring me Juror Q.
We're almost done with the jurors here, guys.
I'm trying to protect, but I'm trying to protect. So if it hassles you about anything, the court stands ready to assist.
She's like, I'll handle it.
You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your hand. Transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? Each juror answered yes. Was that an accurate answer
Yes, ma'am, it was.
about your verdict at the time?
Yes.
All right. Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, it was.
Did you hear Miss Becky Hill make any comment about this case before your verdict?
No, ma'am.
Was your verdict on March the 2nd, 2023 influenced in any way with any communication by the clerk of court, Becky Hill, in this case?
No, ma'am, it was not.
Very good. You may be excused, and if you'll just stay in the jury room until we've completed examination of all the jurors. Thank you, sir.
Thank you.
Very briefly, I know we were doing cell phone inquiry.
Yes.
With various jurors.
Yes.
I don't know if you wanted to have that with this particular juror as well.
Sure. I understand that before I began questioning you or the other jurors on the questioning of the first jurors, some jurors in the assembly room may have activated their cell phones. Were you one of the jurors that activated your cell phone?
Yes, ma'am.
All right. And was anything that you heard at that time something that has any influence or effect on the testimony you now give under oath?
No, ma'am.
Welcome official.
Thank you. Anything further? You may go to the jury room. Each of us I can. Now, I realize you sat for 6 long weeks on this case in Carlton County, and many folk may know who you are. But on the record of this matter, as best I can, I'm trying to preserve you.
I
And
believe this is the last
please
juror.
know that you don't have to answer anybody's questions about this matter in any way, shape, or form. Purely up to you. And if anything is done that you feel is harassing or makes you uncomfortable, you contact the court. We'll try to do as best I can to help in that situation.
Yes, sir.
All right. I understand that during the testimony of the first juror, some opened their cell phones in the jury room, in our jury assembly room here. Were you one who opened her cell phone?
Yes, ma'am.
Did you listen to or watch the broadcast of that first juror's examination?
It was on Facebook.
Ma'am?
It was on Facebook.
It's on Facebook, and you watched it.
We closed it.
All right. Did anything that you heard in that Facebook cell phone access impact or influence your testimony in this matter in any way?
No.
All right. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was individually
Yes, so after this,
polled,
Becky takes a
and
stand,
each
and
was
that's when
asked,
she got
was
charged
that
for
your
perjury.
verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? Each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes.
Did you hear Miss Becky Hill, clerk of court for Carlton County, make any comment about this case before your verdict?
No.
Was your verdict on March the 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
No.
Thank you, ma'am. That completes my questions. I'll let you go to the jury room now. I'll then ask the attorneys whether there are any further questions. If there are not, please just stay in the jury assembly room until I give you the word. State.
Nothing for the state, Your Honor.
Nothing for the bench, Your Honor.
Very good. This then completes the questioning of the jurors. I will ask the jurors to come into the open courtroom again, thank them and dismiss them. Anything further before I do that?
Nothing from the state, Your Honor.
Move for the record that I be able to question Juror Z to follow up on what I believe the court is confused about.
And again.
Very good. I deny the request. Anything further? All right, bring me the jury.
Bring the jury.
The jury, that completes the court's examination of the jurors in this matter. I can only deeply apologize to you for having to inconvenience you so long after the trial of this case to come here, and I very much appreciate your candor. There are no right or wrong answers to the questions I asked you, but I think each of you, to the best of your ability, answer the questions, and I am deeply grateful for that, as is the state of South Carolina, as is the defendant. You don't have to speak to a soul about this matter if you don't want to. That's purely your prerogative. If there's any difficulty you encounter about this hearing that I can help with, please contact the court, and I'll be happy to do so. You are dismissed at this time. You may go. Thank you for your service. Excuse the jurors. All right, Mr. Waters, is the clerk of court available?
Yes, ma'am. It's my understanding she is.
My God.
When the court is ready.
All right.
I believe she's at a location. Mr. Lewis is here just a block or two away. So if we take a brief recess, we'll be prepared to present her after that.
Well, I will entertain going on and taking an early lunch break. I don't know how long Ms. Hill's testimony is going to take, but if that might be a better thing than hanging around here, I think that's what I would prefer to do. Mr. Harpootlian?
Your Honor, I need sustenance.
Okay. Well, good. I think I will join you in that. What I will do is I will recess court until 1:15. Please return at 1:15.
All right, here comes Becky.
Is the state ready to proceed?
Ready to proceed. I think they're still getting the defendant ready to sit down. But
Very good. We certainly will wait on that, Mr. Harpootlian.
Your Honor, once he's seated, I have a matter I need to put on the record.
All right, sure. Yes, sir.
Your Honor, we last week discussed the standard by which you would proceed
Oh,
during this
Lord.
proceeding and evaluate the evidence. We argued that you should use a case called Bremer. You rejected that. But under any standard, as I understand it, the burden of proof is on the defendant to show certain statements were made or certain conduct happened. So far, Your Honor has called as court witnesses 12 witnesses. We were not offered the opportunity to cross-examine them. And so we've not had the opportunity to present any evidence whatsoever. And before the state presents evidence, I believe that we should be able to call witnesses. And I would ask the court to allow us to present some evidence before the state comes up with rebuttal. And by the way, under the cases you cited, they have no affirmative obligation to present anything at this point. There's no requirement they present anything. So I would ask you to allow us to call a witness or two before you make a decision as to whether or not they need to call a witness.
State?
Your Honor, we obviously have argued very extensively some of the cases, and I think the South Carolina jurisprudence is very clear that while an evidentiary hearing is appropriate, and that's what we're doing here, that manner of inquiry is purely within the discretion as the trial judge sees fit. This is not a criminal trial where we're here with a jury to present the normal criminal trial process. This is a inquiry that is very much directed by the trial court and what the trial court thinks is appropriate. And so the state certainly is comfortable with the inquiry the court is conducting. And my understanding is, as far as putting up Ms. Hill, this is the manner in which the court wanted that evidence presented. And so we're happy to comply in that regard. But we think that this inquiry is within your discretion, and we have no issue with the manner in which Your Honor is proposed to conduct it.
Please, Court, Your Honor. Certainly, the conduct of this hearing is within your discretion. What is not is who has the burden of proof. We do. And we can't meet that burden if we can't call witnesses. And so I'd ask the court to allow us to call witnesses. And if at the conclusion of us presenting those, you believe the state is required to present evidence to contradict that evidence, or in some way, I'm not quite sure, since Bremer is not the standard, I'm not quite sure what they have to prove, but that's an argument down the line. I believe we ought to be able to call witnesses now. And we have witnesses which would substantiate the burden we have to show you that statements were made by the clerk of court, that those statements had impact on a juror or jurors.
All right. I've got a couple of reactions to that. Number one, the pretrial was the time to figure out exactly what we were going to do here. And I think it comes at the last minute for you to now come and say, we want to present witnesses. You briefed the matter of witnesses. We had a long pretrial. After I made my rulings on what I thought the scenario was that should be used based on State versus Green, you lodged objections to that, but you did not offer at that time any information about who you wanted to call, other than this lengthy filing in one of your briefs. It comes pretty late in time for, in my view, for you to do that now. Second thing is, I gave the defense a big break when I allowed you to be the cross-examiner and the state to be the presenter of Becky Hill. She's really a witness that each side needs to prove their view of what happened in this matter. The state puts her up to try to show that there was no impact by anything she said, and that some of the things your witnesses say were said, she says were not. So there's a conflict in the evidence there. I'm not going to rearrange the situation and go to any witnesses of yours right now. I'm going to see what Ms. Hill has to say. And then afterwards, we can talk about whether there's any need for any other witnesses.
Your Honor, just factually argue this with you. We did not understand. We assumed you to Doc Remmer because that was.
Well, I don't know why you assumed that. When the South Carolina Supreme Court said very clearly that we do not go by the guidance of the 1950s case of USB Remmer.
We do not believe that's what Justice Kittredge has said.
He said it straight out, as clear as a bell can be, but I've ruled on that.
Yes, ma'am.
And, the South Carolina Supreme Court's going to have plenty of chances to decide that they will modify Green.
Well, when we were somewhat taken aback by a ruling as a result, and that ruling came at a point where we didn't know what these witnesses were going to testify to. So we now, and by the way, you've set aside 3 days for this. What's the hurry? This gentleman is facing life with no parole. We should take this in a very deliberate way. He's got a 14th Amendment right to ensure that he had a fair trial.
Arguments should have been made before this time, Mr. Harpootlian. I've told you how I'm going to handle this thing. Your objections are noted and they're on the record. But right now, what I'm going to do is what I said I would do. We're going to call Ms. Hill and see what she has to say. I have no idea who all you want to call as witnesses or whether they're here in the courtroom at the present time. But we'll get to that after Ms. Hill testifies.
Yes, Your Honor.
All right.
And there's number 3, where he gets scolded like a child. Put it down. All right. Here she comes, guys. I believe, unless there's another disruption.
A little something here that I'm just getting an email on.
Oh my God, that's right. Another
record right now. I have a communication from Mr. McCullough that's only that is copied to Mr. Harpootlian, Mr. Griffin, Mr. Waters, and Attorney General Wilson, and basically says his client Juror Z wants to enhance the testimony she gave with some sort of affidavit that he wants me to look at. And I have looked at. I want to hear from the state and the defense, but I can tell you, I'm not inclined to get back into the testimony that's already been taken by these jurors. Her inconsistencies, whatever they are in the record, and she now wants to have another bite at the apple. I'm not at all enthusiastic about that, but I will hear from you, Mr. Waters, first.
Your Honor, the jurors testified. The court conducted the inquiry that needed to be conducted. She answered the questions. I would agree with Your Honor that multiple bites at the apple are not warranted. So we believe we should proceed forward as the court's indicated.
All right. Mr. Harpootlian?
Your Honor, I'd note 2 things. The first thing is we asked to be able to examine this juror. You denied that request. Number 2, she's not our witness. She's not Mr. Waters' witness. She was the court's witness and a juror and you commended all of them on their honesty. She's attempting to be honest. This process we're going through is an effort to seek the truth. This is the truth. I don't understand why it can't come in.
I think I understand what your position is.
So we'd ask you to make it a part of the record. You can say you're going to consider it. You're not going to consider it, but it should be a part of the record.
Well, I'll give some thought.
Oh my Lord.
This thing should be a part of the record, but I can tell you this. Witnesses don't get to get on the stand and testify under oath and then seek to add or change or deal in any way with their testimony. Those questions were very open-ended questions that asked for her responses, and she gave them. If they're inconsistent, she can't come up now and try to close the loop of consistency by some additional.
Yeah, and that's troublesome, right? Given they just had that lunch break, and now we have to
allowing that to be done.
Your Honor, we believe, and we said at the time, the way you questioned her put her in the position of saying, yes, that was my verdict then. We think, and we couldn't examine her. And Your Honor, To say now that this affidavit doesn't accurately depict her position is to deny fact, the truth.
You've already said that once. I know your position on that matter, but I decline to adopt it. All right.
We'd make this an exhibit as a proffer for our case. This affidavit, we proffer it for our case. We have the burden.
I'll give some thought to it. I'm not ready to deal with that right now. I had looked at it just in the moment right before I put it on the record. I'll do some research about that, and we'll close that loop before the end of the day.
Your Honor, again, okay, we have 2 more days. We don't have to wrap everything up today.
Oh, Poot.
Yes, sir. All right. Mr. Waters.
Thank you, Your Honor. The state calls Rebecca Hill.
Here we go. Miss Becky. Okay.
Do you swear or affirm that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
That's right, Liz. Remember, this is one of her
Good afternoon.
charges
How are you?
because of what
I'm
she
fine.
says here today.
I want to get started, if you would, if you could state your full name for the record and spell it for the court reporter, please.
My name is Becky Hill. Last name Hill, Hill.
Oh my God.
And if you would, just give us, you're currently the clerk of court for Colleton County, is that correct?
That's correct.
And just very quickly, if you would, what year were you elected as clerk of court?
At the end of 2020.
At the end of 2020?
Yes.
And prior to that, did you have any involvement or experience with the state judicial system?
I did.
And could you tell the court what that was, please?
I was a South Carolina official court reporter for about 14 years.
All right. And were you, in being an official court reporter, you would serve in the courtroom, which is Ms. Harris is here today, is that correct?
That's
what
correct.
Was your, and was that primarily in the 14th Circuit?
It was primarily in the 14th Circuit. However, I did travel throughout the state.
Did you have any other experience in professional experience prior to becoming a court reporter or clerk of court?
I was a court reporter freelance for 2 years before that.
Okay. And then any other professional pursuits you've had over the course of your career?
I was able to be a middle school teacher, and I worked for the Board of Disabilities for a few years as well.
Let me go ahead and just kind of get straight to it. In your capacity as clerk of court and in your previous experience being a court reporter, were you familiar with the rules that apply to court staff as it comes to interactions with jurors in the course of a criminal trial or a civil trial for that matter?
Yes.
All right. And could you tell the court generally what those rules are as far as what contact is permissible and what contact is not permissible, just very quickly?
The judge gives the law and gives the instructions for a jury, and the attorneys will state their opening argument, their opening statements, their closing arguments, and basically the clerk of court and anyone else, court reporter, we're there to, my understanding would be to make sure that everyone's taken care of. Do you need some Kleenex? Do you need some water? Different things like that, just to make sure that they're taken care of.
Is it common for clerks of court to have interaction with jurors during the course of a trial to see to those various logistical needs that you just described?
Yes.
And did that happen in the Murdaugh case?
It did.
And can you give us an example of some of the logistical things that you or other things that you would see to deal with any needs that the jurors may have? I mean, did you provide them food, coffee, make sure they were comfortable, things like that?
Yes, all of that.
Provide blankets for them if they were cold?
Our courtroom was very cold in Colleton County. Yes.
Did you provide them with aspirin or Tylenol if they needed, make sure coffee and snacks were available?
Yes.
Did you take lunch orders for them so that they were fed each day?
Yes.
All that is normal.
At any time, did you interact with any juror in an attempt to influence their view of the facts in the State v. Murdaugh case?
No.
All right. Now I want to ask you some specifics about that and some allegations that have been raised. At any time, did you tell the jury not to be fooled by evidence presented by Mr. Murdaugh's attorneys?
I did not.
At any time, did you instruct the jury to watch him closely and look at his actions?
I did not.
At any time, did you instruct the jury or tell the jury to look at his movements?
No.
At any time, as the jury moved to deliberate, did you tell the jury this shouldn't take long?
No.
That's what she said.
At any time, did you tell the jury that the defense case, watch out for the defense case, they're going to try to throw you off, or anything along those lines that was meant to influence the jurors against Mr. Murdaugh?
No.
Let me ask you if you ever made any comment to the jurors about the fact that the defendant was going to testify. Did you have a conversation in the presence of the jurors prior to the defendant testifying about the fact that he was about to testify?
It wasn't directly related to the jurors. I was talking to Mr. Bill, who was our bailiff foreman, our bailiff over the jury, and I was talking to him about that.
Right. And what did you say?
I told him what I had just come from downstairs telling my security and bailiff office, that Judge Newman had allowed more testimony in regarding the financials, and that also the defendant had decided that he may testify.
All right. And where were the jurors at the point that that conversation occurred?
There were a few jurors standing in line, and there were some in the bathroom, I'm sure, because they said they were waiting on jurors to get out of the bathroom. And there were some in the jury room just milling around from what I could see, looking down the hallway.
And again, what were the words that you said during that conversation? What were the effect of them?
To Mr. Bill.
Yeah. And what did you say?
I told him that that Judge Newman was allowing more of the financial evidence in, which would prolong the testimony in the trial a little bit, and also that the defendant had decided that he was going to testify.
Did you say anything about this being an important day? Pay attention. We'll get coffee for you. Things like that during that?
I usually give a little pep talk to the jurors.
Shouldn't be doing a pep talk.
It's sometimes hard sitting a long time, but my usual, and I do remember saying, pay attention. It's a big day today. Whatever you need, let Mr. Bill know, or one of the other bailiffs.
Pay attention, big day today. Shouldn't be saying that. Shouldn't be saying that.
They'll be glad to get it for you.
Did your comments, or were your comments in any way phrased in favor of one side or against another side? Or were they more of a neutral comment about paying attention?
No, it was not for one side or the other.
Be saying that. Oh. Was, I believe, Alex before her. Yeah, that's saying a lot, isn't it? Just kidding. Yeah, I mean, that is that. The two of them get a liars contest. Lying liar who lies.
Were you present when the jury went to the Moselle property to conduct the jury view?
I was.
All right. And was Judge Newman there as well?
He was.
During the time that you were on the property, traveling there, traveling back, did you have any conversation with the jurors where you made any comment about the substance of any testimony or any comment about the merits or the strength of the case?
No, no.
Did you have a quick comment to the forelady about how the property was beautiful and there were tea olive trees there that bloom and smell good, or words to that effect?
I did.
All right. And was there any other conversation related that you had where you made any comment about the case or the merits or anything like that?
Oh, no, no.
During the course of this trial, did you have a bailiff employee whose primary job it was to see to the jury and their security and keep them separate from everyone else that was involved in this trial?
I did.
And who was that?
Mr. Bill Polk.
All right. And he was ultimately the jury coordinator in this particular case?
That's correct.
During the course of the the deliberations, once the jury went back there, did you have any contact with the juries or have any substantive discussion with them?
Not at all.
Did you have any discussion with them about logistics, about staying in a hotel or anything like that?
I did not.
Did you have any interaction with the jurors or anything to do with them having smoke breaks or anything like that?
I did not.
So y'all, when they get to the part about her plagiarizing part of her book, which I think comes up in this hearing, my recollection is that was from the lady from the Wall Street Journal. And if that's who it is, that lady is sitting right there. Can you guys see my mouse? Under the word live up the top left, that lady with the short hair is that author who wrote a book or whatever and was writing for the Wall Street Journal and covered this trial. I believe that is exactly who she copied or plagiarized from, if I recall. She did come out of retirement for this. Yep. No, she did.
During the course of the trial, did you have any discussion or interaction with the jurors about them giving any interviews to the media or making themselves available to the media? I'm asking during the course of the trial itself.
No, not during the course of the trial.
After the verdict had been reached and the case was in sentencing, did you have any conversation with any jurors at that time after they had already entered their verdict and been individually polled?
Yes, after the sentencing.
All right, and tell the court what that interaction was at that time.
There were several outlets, news outlets, that wanted to interview the jury as a whole and really wanted to get them up to New York. And so I was trying to get a hold of all the jurors to talk about that. That was something we had not prepared for.
Did you at all pressure the jurors to speak, or did you just tell them that it was their option to speak or not, and here's the contact information?
I did not pressure the jury to speak. No.
Did you advise them that it was their decision and their decision alone whether or not they wish to speak to the media?
It was totally their decision.
That I
Did
don't
you advise them?
true either.
Yes, yes.
I'm going to ask it again, but I just want to be sure. At any time, did you make any comment to any juror or in the presence of any juror in which you at all tried to influence them in favor of one side or against another?
I did not.
I think he's done in that.
Did you understand, being a longtime court employee and clerk of court, that that is outside the boundaries of what is appropriate interactions with the jurors during the course of the trial?
Absolutely.
And at any time did you violate that rule that you understood?
I did not.
Court's indulgence, 1 moment. Nothing further this time, Your Honor.
All right, cross exam, guys.
Ms. Hill, we spent 6 weeks together, didn't we?
We did.
Oh boy.
And during those 6 weeks, you were as helpful to me as you could be, correct?
I was.
Accommodated just about every request I made.
Yes, sir.
Wait. Where were we? Oh yeah, we're old friends.
Oh Lord.
Heard, that was the microphone that was supposed to, you're fine where you are, absolutely fine.
It's a stage microphone that was obscuring my ability to question a witness.
Yeah, well, what I'm wondering is whether you can be heard without a microphone. Do we need to try to get a microphone up on this podium? Yeah, that would be good.
I don't know who's supposed to hear this other than you, but I assume they can hear us. The court reporter, I'm sorry. She's more important, not as important as you.
Yes. Oh, well, I agree.
Oh yeah, we're old friends, right?
God.
We spent 6 weeks together in a very pressure-filled situation, correct?
It was a long 6 weeks.
It
Oh
was
my
a long
God.
6 weeks. And
Oh God.
during those 6 weeks, you were helpful to me in a number of different ways. Accommodating friends that I had that wanted to come watch the trial, for instance, correct?
That's correct.
You even allowed me to use the private restroom down on the first floor so I didn't have to stand in line with the rest of the people trying to get breaks, correct?
Correct.
So we have no animosity towards each other. You
Oh,
didn't
God.
do something to me and I didn't do something to you during that trial, right?
Absolutely.
Okay. Now, given that, I'm going to ask you some
God.
questions today that may indicate to you that I have some antagonism towards you. Let me disabuse you of that. I'm here doing a job representing my client, and you've been around the court system for decades, correct?
Yes, sir.
So you understand what we're doing here today.
Yes.
Now, let me understand a couple of things. I think, and I've read your book, some editions of your book. There's several. We got a bunch of emails in which you have drafts that you forwarded to your co-author, correct?
Correct.
Objection. I believe I would object to relevance. I believe any draft you sent to her co-author with the book is beyond the scope of this inquiry here today.
Overruled. You may proceed.
Thank you, Your Honor. And in those drafts, you say certain things about the trial, about the process, which you later did not include in the final version. It's called editing. Is that correct?
I would agree with that.
Okay.
Oh dear.
Now, let's talk about this book for just a second. When did you first decide you were going to write a book?
I think a thought was there, a very fleeting thought before the trial.
Did you take any steps before the trial or at the initiation of the trial to begin writing this book or working with somebody on this book?
Oh, no, sir.
When did you and your co-author get together?
It was several weeks after the trial.
Okay. Did you talk to anybody about the fact you were going to write a book before the trial?
There were several anchors and several journalists that I did speak with about the possibility of writing a book.
I'm so disorganized. I apologize.
Oh, Poot.
Did you seek assistance in this trial from other clerks of court?
Yes, sir, I did.
And who were they?
Rhonda McElveen, who is the Barnwell County Clerk of Court, and Renee Elvis from the Horry County Clerk of Court.
And were they there with you the entire 6 weeks?
No,
I mean, how long were they there? Or how often were they there?
Rhonda McElveen was there as often as she could be, probably several times a week. Renee Elvis helped me during the jury selection.
Right? I mean, he's got his paralegal. Not her fault. He's a mess. Hot mess.
And did she begin, that is, Ms. McElveen, did she begin working with you prior to jury selection?
Can you repeat that question?
We began jury selection, I think, on January 23rd, correct?
Correct.
Was she working with you or consulting with you prior to the 23rd?
No, sir.
Did you have any conversation with her about the trial?
Not until she got to the trial on what, I can't remember the exact day she came.
Okay. Now, is she a friend of yours?
She was a friend, yes.
Was?
Well, she is a friend,
Okay.
yes.
She's done nothing to make you any less a friend.
No, sir.
Now, did you tell her about the time of the trial that you were going to write a book? That you had thought about and were going to write a book?
I can't remember exactly.
Ruh-roh.
I I think we did have a conversation about a book possibly in the future.
And did you tell her you're going to write a book because you thought it would make a lot of money?
Oh, no, sir.
You never said that.
No, sir.
And did you tell her that you were going to write a book to make a bunch of money so you could buy a lake lot and build a house on it?
No, sir.
Okay. Now, did you ever tell her that you had given a juror a ride home, that you had accompanied Mr. Bill, what's his last name?
Bill Polk.
You're right. That you and he took a juror home one night? Did you tell her that? Did you take a juror home one night?
I didn't take a juror home one night.
Did
No,
Mr.
sir.
Polk and you take a juror home one night?
No, sir, we
Okay, you
didn't.
never gave a juror a ride in a car with Mr. Polk or without?
No, sir.
Okay. Now, also, during the trial, your daughter ended up on the venire, is that right?
She did.
And she was coming up, and did you talk to me and Mr. Waters about putting her on the jury if at all possible?
I'm not sure that we wanted her to be on the jury if at all possible, but I think the question was, would she make a good juror? And I said, she sure would.
Now, I don't think we asked you. I think you told us she would make a great juror. Did you not?
I remember you asking.
Oh, boy.
Okay. I was considering putting your daughter on the jury.
Yes, sir.
And who does she work for?
She works for Compass South.
Did she work for the sheriff's department at some point?
No, sir.
Okay. Did she work in law enforcement at all?
No, sir.
Okay. Now, let me ask you this. How many jury rooms were there?
We have 2 jury rooms in Colleton.
In this trial, how many jury rooms did you have? How many?
2.
Okay, so the entire jury wasn't together at any one time? They were separated into 2 rooms?
Yes.
Okay. And when they're separated into 2 jury rooms like that, are they next door to each other? Are they down the hall from each other?
They are next door to each other.
Okay, so but if you close the door to one, can they hear what's going on in the other one?
Some women probably have very good hearing, and men too, but I would say probably not.
Okay, are there restrooms in both of the jury's rooms?
There are.
Okay, are there 2 restrooms or just one?
There's 1 restroom in each jury room.
Okay, were either one of those restrooms designated men and women, or did everybody use the same one?
They were unisex.
They were unisex. Okay, now, prior to your testimony here today, have you met with the Attorney General's office in Swed?
I have.
On how many occasions?
I want to say twice.
Okay, and remember when the first time was?
I think the first time was in September.
Okay, and the second time was last week?
Yes, sir.
And that was in Walterboro?
Yes, right.
And y'all spent about 4.5 hours together?
I want to say maybe 2 hours together.
Okay. And in those 2 hours, you went over your testimony here today?
They asked me questions.
Did they ever correct your answers or suggest you answered differently?
Oh, no.
No.
Oh,
So
no.
you just went through what you went through in 20 minutes here.
Oh, my
It took
God.
2 hours to go through when you were with them.
There were times when I would step out of the room and come back in. But I would say we were there for about 2 hours.
Now, you have described in your book your role as Switzerland. Is that correct?
Correct.
Okay. And that is that you should not be in any way opinionated about what's going on in the trial. Is that correct?
That's true.
Okay. Yet in your book, you indicated a number of different points during the trial you had concluded he was guilty. Is that correct?
I think,
Your Honor, I object at this point. I don't know if her conclusions in the book are in any way relevant to what occurred during the trial and whether or not there was any communications with the jurors, which is the sole issue that we're here for today, is whether or not Ms. Hill had any extraneous influence on the jurors. And so I think this is going a little far afield. We object to the relevance, Your Honor.
You rules all these, which I think is the
Let me
right.
give you an example. You indicate writing back from Moselle that you and 3 other people were in a car and you all decided adamantly, I think was the word you used, that he was guilty, that he had killed his wife and son. Is that what you put in the book?
I can't remember if I put that in the book, but if you say I did, then I will
Did
agree
that
with
happen?
you. We did have a conversation about what each of us thought,
And all 4 agreed that he was guilty, correct?
and none of us were jurors.
No, trust me, I know that. But you had an abiding conviction, at least by the time of the Moselle visit, that he was guilty. And the other people in the car with you were bailiffs, were they not?
No.
Who were they?
Some were not bailiffs. One was a court reporter. One was our security officer, head security, and another was a deputy sheriff.
Okay. But the 4 of y'all rode out there, and based on what, and I mean, you want me to read to you how chilled you were and how you felt that poor Paul and Maggie had been executed by him on that scene? That visiting the scene convinced you that he was a horrible, horrible murderer? You want me to read that to you, or you will concede that's what you wrote?
I will concede that's what I wrote, but if I may, I would say that a lot of that is poetic license in writing a book and in making it sound like that.
Okay, so some of it's poetic license, and some of it you just stole. You purloined it from that BBC writer, right?
Right, again, I object to not only the relevance, but the scope cross. I would object.
Oh, it was
also
BBC,
under,
not Wall Street. Okay, so it wasn't that
608,
lady.
8, I don't believe that's appropriate cross-examination.
Overruled. You may continue, Mr. Harpootlian.
Did you steal part of the book?
I did plagiarize,
Okay,
Mr.
so
Harpootlian.
that's stealing, isn't it?
And it is, and for
Okay.
that, I'm very sorry, and I have apologized.
Okay. And that makes it okay?
What I did, and I
Okay.
apologized for
Okay.
that.
And part of the book is, you say, literary license, exaggeration?
I wouldn't call it exaggeration.
Okay. Now, let me ask you this. Is Switzerland, and this is, you're saying this is happening while you're supposed to be Switzerland, you decided the defendant's guilty. And if Ms. McElveen says that it's going to make you more money if he's found guilty, don't you think it's reasonable to assume that you may have crossed the line from time to time?
Your Honor, I object to the form of the question, assuming facts not in evidence.
Overruled.
Can you repeat that question one more time,
I'm
Mr.
not going to
Harpootlian?
repeat it. Let me just move on to something else.
Yikes.
Let me ask you, you had interactions with some jurors, and I believe in a conference in the judges' chambers, you indicated that you had seen a post on, is it Walterboro Word of Mouth?
Your Honor, again, I object. I think he's delving now into the Facebook inquiry. We believe, again, that that's irrelevant to the inquiry for Your Honor.
Look at the finger.
I will allow limited, he's, as I understand it, trying to impeach her testimony.
Look at his
and, explore her credibility. And I think I've
His
already
hand is
told
stuck
Mr.
like that.
Harpootlian that I don't want a whole trial about the business of Facebook and the egg juror, but I will allow limited examination on this point. You may proceed, Mr. Harpootlian.
Am I oversimplifying that? I mean, it's in your book. You saw something on Walterboro Word of Mouth, which appeared to you to be from the ex-husband of one of your jurors. Is that correct? Am I oversimplifying that?
I remember reading one night something on Walterboro Word of Mouth, and when I was in the courtroom on a Monday morning listening to the judge and the attorneys talking about a matter, it sounded like it was relevant to each other.
Okay. And you became aware somehow that this juror had a restraining order out for her ex-husband?
She told me that herself.
Okay. And tell me how it came for her to tell you about that. Where did she tell you?
She was very talkative, and when I was instructed by Judge Newman to go and get her from out of the jury room with a deputy following me, she was talking to me all the way back to the judge's chambers, and she mentioned that there were restraining orders out when they had divorced.
So how did the judge who brought it to the judge's attention about this Walterboro word of mouth thing?
I let the judge know, thinking that it could be related,
Okay, and you let the judge know what?
that I had read something on Walterboro word of mouth.
Okay, and that you knew it was tied to that juror?
I didn't know that it was. I wasn't sure at
Who
all.
do you think it was tied to?
From what y'all were talking about at the bench, I felt like I needed to let him know, just in case it was related. There was something about an ex-husband and an ex-wife and somebody being on the jury.
You didn't tell the judge that you had found what we call the apology post? You didn't tell the judge that?
I didn't call it that, no.
You don't remember producing it, saying that producing it to the judge, saying this is a post in which the guy that posted it on Friday night says the devil got in him and drinking and he apologized for what he posted? You didn't produce that?
My staff did, one of my staff.
But you gave that to the judge and gave it to us, did you not?
Yes, we did.
As if it were from that juror's ex-husband, correct?
Correct.
And you know it wasn't?
I don't know that, Mr. Harpootlian, no.
So, and this, you did not take that juror out and talk to her before you took her to the judge? Is that
I never talked to that juror about stuff like that.
Okay. Did you ever talk to the forelady of the jury, separate from the jury?
I did.
Okay. And tell us, where did that occur?
No, it's not good either.
When I would go into the jury room and I would speak with the forelady, we would be in like the hallway in the two jury rooms were side by side, and the opening to the jury room went out into the hallway, and we would be surrounded by the jurors at all times. Mr. Bill would be very, very nearby, or another bailiff as well, when we would speak.
And what did you speak to her about?
There were several instances. One was there was a juror who needed some feminine products. There was another time when Band-Aids were needed. There were times when Tylenol would be needed.
Other than items that were needed by the jury's health object, did you ever discuss, did she ever discuss with you, is some issues jurors had emotionally or some issues with dissension in the jury room?
She only told me that there were some loud jurors, and it made some of the other jurors a little upset. But other than that,
What did you tell her to do?
I told her if it got out of hand to write a note to the judge, and that she could sign the note and get Mr. Bill to give it to the judge, and the judge would handle that for her.
Okay. Now, you did publish a book after this trial, is that correct?
We did.
And you went to New York and took some of the jurors to the Today Show?
The Today Show did invite us, yes.
Now, one of those jurors that went up there with you, the day of the verdict, wore, for the first time I can remember, wore a suit to court. Do you remember that?
Your Honor, again, I would object to discussion of the jurors wearing a suit or a post-trial trip to the Today Show. I don't believe there's any connection to the inquiry that's focused for Your Honor, and that is whether or not there was any extraneous influence during the course of the trial.
All right, overruled. You may continue, Mr. Harpootlian.
Did you text, email, or communicate on the morning before final arguments were completed that to people that this was on a Thursday, that they probably, if they're going to see the trial, should come on that Thursday because it'd be over by the next day? It would be, the jury would not be out very long. Did you ever communicate that, email, text, or verbally?
I do remember saying that, yes.
And why did you think the jury would not be out very long? Had you communicated with jurors?
I had not communicated with jurors about anything related to this trial at all. I've been a court reporter for at least 14 years. I was clerk of court for 3. And you just get to where you kind of see things happen as they progress. And it's a gut feeling.
I will say, I do think that is plausible. right? That if you've been doing it a long time, even if you, let's just pretend she never did any talking to the jury or whatever, right? I think that could be plausible. I would be interested to hear from other clerks of court or court reporters or whatever, if they feel like they get a gut feeling. Because I mean, we hear from, well, having said that, we hear from attorneys all the time, right? Juries are completely unpredictable in every way. You never know, But I don't know, maybe it's different if you're a court reporter or a clerk of court. I'd be interested to see if other people share that same sentiment. But I mean, the other thing is we know that juries usually come back guilty, so there's that. But as far as the length of time to deliberate, I mean, if you're going off of like statistics, usually the longer the trial, the longer the deliberation. So I don't know. Let me know what you guys think. Do you think she's lying about this, or do you think that this is legitimate, that she could have had this gut feeling?
That's all that I meant by that.
Well, why are you telling this young man who wanted passes for the next day in an email, you know, it won't be happening tomorrow? That was your, or did you say, you didn't say, I don't think, you just said, you better come today if you're coming.
And maybe, you know, and maybe it varies by the case, right? In some cases, you probably can get a stronger sense than others, potentially.
Yeah.
Maybe.
But, you know, if he wanted to come, I knew that the trial would be ending shortly as far as testimony. So if he wanted to come, he needed to come.
Why wouldn't the jury have been out a week on a 6-week trial?
They could have.
But
They could have.
you apparently were telling the press and others that there'd be a quick verdict. Were you not?
That was just a gut feeling that I had.
Okay.
And that was my opinion.
Your opinion, you were right. Jury was out 3 hours on a 6-week trial, correct?
That's true.
How much money did you make off that book?
There was not a whole lot of money made off of the book after paying different things and paying for some expenses that went along with that. But I want to say roughly around $100,000.
Okay. That's not a lot of money.
No, especially when you publish your own book.
But that was $100,000 you made.
With my co-author.
Okay. In what period of time? 6 months?
I would say 6 months, yes.
When was the book published?
August 1st.
Okay. The trial was over. That's 6 months after the trial's over, you've published a book, correct?
Correct.
And then I believe you've recently stopped selling the book because of the plagiarism you've admitted to, correct?
Correct.
And so there's no more money?
Correct.
Now, you also indicate in the book that the Murdaughs had a reputation of criminality, I think, is kind of what you put. Did you not?
Well, Mr. Harpootlian, my grandfather and Old Man Buster were very close.
Well, were they criminals?
I wouldn't know.
You wouldn't know.
How crazy is it, guys, that in addition to all the other issues that she had going on, even just as it pertains to the book, there was also the plagiarism? Like, it's wild to me.
But you believed and you published that the Murdaugh family had run that part of the state and they'd been participated in criminal conduct, correct?
Your Honor, again, I would object to general testimony about the alleged criminality of this family. I'm not sure how that has any bearing on the focused inquiry before the court.
He's asking about what she said in the book. I'm going to allow it.
Yes, sir. Did you say that in the book, that they were criminals?
In the book, that was more of the literary ease that we take, I think, to make a story a little more interesting for the reader.
By calling people criminals? I guess what I'm saying is this. Were they criminals?
Your Honor, again, I object to that particular question.
Overruled.
Were they criminals?
I wouldn't know that.
Okay, so you either made it up or you're lying about it? About the reputation of people that can't defend themselves? They're dead? You're going to call them criminals? You did that in the book so you could sell a book?
No, I didn't do that to sell a book.
What'd you do it for? Made it more readable, you said? Which sells books.
Literary ease. Yeah.
What?
Literary.
Literary what?
the literary ease that you can take with when writing a book.
Literary ease you can take with writing a book. You can make stuff up. You can lie. You can lie about people.
Not with that. I think the public perception was one that it was very interesting during this time.
So you're feeding the monster out there that wants to believe bad things about the Murdaughs, and you'll make stuff up to do it. Let me give you another example. I read your book, and I found this somewhat humorous. My co-counsel did not. In describing myself and Mr. Griffin, in the book you say that I neutered him. We've both been very interested in what you meant by that. What you mean by me neutering Jim Griffin?
Mr. Harpootlian,
Lord.
It was a book.
Did you make it up? I know it was a book. The Bible's a book.
Right.
I mean, just because it's a book doesn't mean you can lie in it.
That's one of my favorite parts. The Bible's a book. Oh my God, you guys.
It was a book. The Bible's a book. I mean, just because it's a book doesn't mean you can lie in it.
It's just a word that was used.
Nature of that.
No lake house, to my
I
knowledge.
don't argue with the witness, but the witness, Ms. Hill, you're instructed to answer his questions. You may proceed, Mr. Harpootlian.
So let me get this straight. The book, and I'll see if I can cut to the chase on this. I could read you chapter after chapter,
Oh, boy.
verse after verse, which is not true. Okay, not true based on my experience of being in a courtroom, and not true based on knowing some of the people you describe. You say that is
Mr. Harpootlian.
Creighton objects and he just keeps talking.
described. You say that is.
Mr. Harpootlian.
I object. The counsel's just testifying right now as to his
Yeah.
observations about the book.
Question, Mr. Harpootlian, please.
You have conceded there are things in the book that you don't know to be true, correct?
Correct.
Okay. You would concede then that you have lied in the book.
It's only because I wasn't there at the time. I can't interview my dead grandfather. I can't interview Mr. Buster. There's just things that we can't interview them on. We can go by what was written in a newspaper and get facts from that.
And take the inference that one of the Murdaughs was a pedophile. You could have printed that, and they're not here to contradict it. You could have printed anything you wanted and made it up to sell books. That's what this whole scheme was about, selling books. As you told Rhonda McElveen, if him being found guilty would sell more books.
Your Honor,
Isn't that true?
I'd object to the argumentative nature of the question, the compound question, and assuming facts not
It is compound.
What you're asking.
I literally was just saying it is a compound question. Then Justice Toal said the same thing. That's oops, sorry. No, big. We want it big. Okay.
Is what she told Ms. McElveen. Go on and ask that, but don't precede it with
Yes, Your Honor.
testimony.
Beg the court's indulgence for just a moment.
So by the way, when she said 100,000, that wasn't net profit. So that was like the total proceeds of the book or whatever. And again, it's like split with her co-author and then minus the costs. So I don't think they actually made that much money off of it, to be honest with you. I have heard that it is expensive to self-publish and usually comes with a loss.
A book about a juror whose ex-husband had posted something we now know probably wasn't her ex-husband. Did she have any other ex-husbands that you found out about?
I have no idea.
Well, you wrote, we learned later the ex-spouses hadn't seen each other in 14 years and she had 3 restraining orders against him. Did she have 3 restraining orders against him?
I don't know. That's what she said.
Okay. Did you tell jurors at the end of the trial after President's Day break? President's Day break would have been a Monday, correct?
Correct.
But before Mr. Murdaugh testified, did you tell the jury not to be fooled by the evidence presented by Mr. Murdaugh's lawyers?
Mr. Harpootlian, I never talked to the jurors about any of the evidence.
Okay, the
in
answer
this
would be
case.
yes or no, then you can explain. Did you say that?
No.
Okay. Did you ever instruct the jury to watch him closely immediately before he testified, looking at his actions, looking at his movements? Did you ever tell a jury to do that?
No.
Did you ever tell the jury to pay attention to Mr. Murdaugh's testimony?
To pay attention, not specifically to his testimony. I did tell the jury to pay attention.
To what?
Just generally in the hallway when I was speaking.
Not to him?
No.
Just to any witness?
Right.
Okay. Did you
You shouldn't even be saying that, though.
ever warn the jurors the defense is about to do their side? This is right before, right at the beginning of the defense case. They are going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off. Did you ever tell the jury that?
No, sir.
Okay. Did you ever tell the jury, if you get emotional, we want to see your face because that is what they want to see? You ever tell them that?
No, sir.
Did you ever tell the jury that Mr. Murdaugh was about to testify?
I didn't tell the jurors that.
Now, did you tell the jury that if they didn't reach a verdict by 10 o'clock, they were going to have to spend the night?
No, sir, I did not.
Did you ever tell them they were going to have to spend the night at
No,
some
sir.
point? Did you ever tell them that they couldn't smoke?
No, sir.
Okay. You got any other books in the works?
Poot?
No, sir.
I mean, doesn't this make a good book?
Oh, come on, dude. Rude. Yikes.
Thank you.
So I believe up next is Justice Toal's questioning, which is the most brutal of all of it.
A few matters came up on cross, obviously, that I'd objected to.
You won't waive your right. You may reserve your rights to object to the entire line of testimony, but you may offer cross-examination subject to the assertion of your objection about the testimony.
Thank you, Your Honor. One of the things you were asked about is finding this Facebook post, and you brought that to the court's attention after a different issue had already arisen related to a juror. Is that correct?
Correct.
All right. And are you technically capable of manufacturing a Facebook post? Is that anything that you have any capability to do?
I'm not.
All right. And did you ask your staff member to go see if she could find this post?
I did.
Did you tell her just generally what you recalled reviewing?
Yes.
And did you give her any further instruction other than that?
No.
Were you sitting behind her as she was doing this particular search or anything like that? Or did she eventually report back to you?
She is very, very techy. And then she reported back to me.
All right. So you weren't there when she was searching anything like that?
No.
She was like, I couldn't find that post, but I did find this, and handed you the Facebook post. Is that correct?
Correct.
And then you provided that to Judge Newman, and ultimately it was provided to the parties. Is that correct?
Right. Correct.
You were asked about conversations that you had with the forelady. Did those involve logistical issues and things like that for the jury?
The conversations with the forelady was everything. There was nothing regarding the defendant and this trial.
All right. So they were logistical issues, not anything to do with the substance of the trial. Is that correct?
Absolutely. Yes.
You were asked about whether or not you had texted some people, this won't be long. Was that at all in any way based on any conversation you had with a juror as to their internal thinking or anything like that? Or was that just your assessment being an experienced person in the court?
Absolutely not.
It was based on just your assessment?
Just my assessments, yes.
Did you ever communicate with the jurors on how long they would be, or did any juror ever tell you how long they thought they would be?
I never talked to any jurors about anything like that.
You were asked about your book, and I don't want to get into too much detail about that, but you were asked about some of the assertions that you made in the book. And you were asked if these were lies. Were they lies, or were they ultimately things that were based on inferences from newspapers and community stories?
You are leading by, this is your witness, Mr. Waters, so please ask a direct question.
Thank you. Some of the statements that you were asked about in your book, were they lies, or were they based on your inferences from just general community knowledge and things that you had researched and knew?
Still leading, but I'm not going to object.
All right.
Thank you.
He's
Mr.
right
Officer.
about that, Mr. Waters. Just ask a direct question.
Did you lie in your book?
No, I did not.
Thank you. You were asked about when you told the jury to pay attention. When you asked that question, did you also mention anything about we got coffee for you or things like that?
I knew that Mr. Bill would take care of that. And the jurors knew too. Coffee, we had done some Dunkin' Donut runs. We had provided coffee, different other things to help stay awake in the cold courtroom that we found ourselves in. And so I knew anything that they needed, Mr. Bill would see that they got, because that's what he did.
At any time, did you have any conversation with any juror in which you tried to influence their decision?
I did not have a conversation with any juror about anything related to this case.
Point emphatic. What do you guys think?
Nothing further on.
All right.
Okay, here she comes. Here comes Justice Toal.
Ms. Hill,
Here for annihilation.
I want you to turn your attention to a hearing that
Oh,
Judge Newman had about the alternate who was dismissed, sometimes called the egg juror. Do you recall that hearing?
Yes, ma'am.
only in this trial would there be an egg juror, and everyone knows exactly who you're talking about. Correct the full name.
In the hearing, Judge Newman expressed his unhappiness with you for questioning that juror before he questioned her. Do you recall that?
I do remember seeing that.
Well, then let's go back and talk about that juror. You on examination in this courtroom, you said that she talked about a lot of things to you, but you didn't ask her any questions. But that's not completely accurate, is it?
Oh, Lord.
Yes, ma'am, that is true.
Well, you asked her direct questions, and that came out in the hearing that Judge Newman had. You asked her questions before she was even examined by the judge, did you not?
Your Honor, I did not ask her any questions.
Oh, God. The pauses are deadly here. Oh, man. Yikes.
The juror was examined by the judge in a hearing. Do you recall that hearing? It's the second hearing on this matter.
I do recall that hearing, yes.
And the court asked you about, the court asked this juror about postings on Facebook, did he not?
Correct.
And the juror said she gave Miss Becky my full access to my Facebook. And I put positive posts on it. I've done that for the past 3 years. Do you recall her testifying in that regard?
I do remember reading that.
And the judge said, has anyone posted anything on Facebook about you? And the juror answered, I was not aware of it until Miss Becky told me today. Do you recall that?
I do remember her saying that.
And do you recall the judge saying, what did she tell me? And the juror said, she asked me if I had an ex-husband, and I said, yeah. Did you ask her that?
I remember her saying this, Your Honor, but I did not ask her any of these questions.
And she further says, she asked me if I had talked to him about the case or being on jury duty, and I said no. I had questioned her about why she was asking me that. I haven't seen my husband since 2014.
Wow.
Do you recall her testifying to that?
I do remember that, yes.
And with that, having jarred your memory, do you recall asking her about her husband and his post?
Your Honor, I don't remember saying anything about that.
Well, what was the post that you read in the Walterboro Word of Mouth? What was the nature? You read that, did you not?
I did.
What did it say?
Wow.
My memory is a little fuzzy with that, but it was about a ex-husband who found out that his ex-wife was on a jury, and he didn't think that she would be a good juror. And it just sounded very similar to what I had heard the judge and the attorneys speaking
So
about.
you then went to that juror and questioned her about that, did you not?
I did not, Your Honor.
Well, she says in this testimony that she didn't know about the Facebook until Miss Becky told me. Was that incorrect?
I'm not saying
Some kind of conversation went between the two of her for her to know about that post, correct?
that's true. And I'm thinking that it could have been someone, it wasn't me. I just know that it's not me that she talked to about that.
Dying defense.
Well, when the judge, the judge was questioning the juror about this, she also said that she had 3 restraining orders against him. And she also said, I was very upset after she told me that. Like I said, I have 3 restraining orders against him, and I wouldn't have anything to do with him if I didn't have a child with him. But I haven't seen him since 2014. Y'all didn't discuss that, the restraining orders?
On the way from the jury room to the back chambers where the judge was, she was very scared. She was talking about the 3 restraining orders that she had out on her husband at the time that they were divorcing. And she was scared that he would be trying to get back in contact with her again.
Well, how do you know that? Did she tell you that?
She was talking about that on the way to the jury room. The
thing is like Miss Becky's the one that scared her by telling her about this post, dude.
With the judge.
Like on top of all of it, right? How dare you even do that? Like someone's got an unruly ex-husband and they've got 3 restraining orders out against him, and they're terrified that this person's going to break those and come after him or whatever. And then you tell the juror that that ex-husband is out here talking about you. The poor juror must have been scared out of her mind, dude. Craziness.
And in the court, in this hearing now that I'm looking at, that the court is conducting, she said they're asking about this Facebook post, and she said Miss Becky said she had went to look for the post again and that it had been deleted. I don't know who she talked to or anything else, but she said apparently, do you recall her saying that?
I do remember her saying that.
And the court then said, what did she tell you about that? And the juror said, it was after you let us go on the last break. I was very upset. This is what you're talking about. And she came down and talked to me and said that apparently, I don't know who talked to him, but he said he was drunk and he removed the post. Do you recall that?
Well, she didn't tell me that, And I didn't talk with her about that.
Well, you saw that post, the so-called apology post, did you not?
Right, I did.
And you assumed that was a post from her husband, did you not?
Right.
And then you talked to the juror about that, did you not?
I did not talk with the juror about that.
Well, who did you talk to about it? Did you bring it to the judge's attention?
No, we didn't get a chance to talk to the judge about that.
The court asked this juror, has the clerk discussed anything about the case with anyone on the jury? The juror said, not that I'm aware of. The judge said, okay, she was just discussing with juror. She pulled me aside when we went downstairs after the last break. I want to say it was after lunch, and we came back. And that's when she first told me about it, about this, what we now know was not a post from her husband.
Right.
But you assumed it was a post at the time, and y'all had a conversation about it, correct? Don't that just nod, answer the question.
Yes, sir. Yes, ma'am. I believe that it was one of my staff that she talked to, and but it was not me that she talked to.
You'll just not answer the question.
But the juror says, and I want to say it was after lunch we came back, and that's when she first told me about it. She's talking about you.
Correct.
Then we went back into the court, and I never even got to sit on the jury. The judge says, the judge then stops the questioning and she exits the room. Mr. Griffin, Your Honor, I think that satisfies it. She hadn't talked to anybody, hadn't expressed an opinion, hadn't made up an opinion. She's got an ex-husband and she has 3 restraining orders against him. The court said, Mr. Waters, just obviously we're all invested in this. My main concern, I certainly would love to, but not love to, but want to hear, what one of these individuals said. But, she answered the questions as she did, talking about the juror. They then have a colloquy about this juror and whether this was really her husband that put this post in that you talked to her about and apparently talked with the court about at some point. Am I right?
That's right.
And then at the end, the judge said that he was not too happy with your having talked to the juror before you talked to him. Do you recall the judge saying that?
Yes, ma'am, I do.
And did you pop right up there and say what you're saying now, that you never talked to her?
We never talked about it after that. I wasn't in the room when he said that.
Everybody's lying so Becky.
The judge brought up another thing right after sentencing that I want to explore with you briefly.
Okay. He's competing with Lori Vallow.
One of the big responsibilities of the clerk of court is to take control of the exhibits that are presented in court. Isn't that correct?
Yes, ma'am.
And here we go.
And there were sealed exhibits presented in this case that were photographs of the 2 decedents at Moselle when the law enforcement authorities first investigated the murders. You recall that?
Yes, ma'am.
And those photographs were sealed by the judge, were they not?
Correct.
And when the testimony about them was completed, they were under your control as the clerk of court, were they not?
That's correct.
How was it that those photographs came into public view?
Are you talking about after the?
I'm talking about the fact he alluded to it on sentencing, and said that he was frustrated about it and was going to try to look into it. Those photographs that were sealed court exhibits under your control found their way into the public media, did they not?
I believe they did. And I think what happened, it was someone from the gallery took a picture from a screen that had some of the pictures on it, if I'm remembering correctly.
Did you ever allow anyone from the press to view these sealed exhibits?
No, ma'am.
Did you allow Netflix to ever examine the exhibits for trial?
No, ma'am.
How did you handle exhibits? Because you did have the press have great access to the exhibits, and you say several times in your book that you had to stay after to be sure that you interacted with the press about these exhibits. That's true, is it not?
That is true. We had Mr. J. Bender, and then we had the pool photographers and someone from maybe the state, I believe, or the Posting Courier, along with the court reporters, someone from court administration, and then someone from the clerk's office every night that would go over the exhibits to make sure everything was correct and within our domain.
Were any press people ever allowed to view the exhibits, even the sealed exhibits that you had on file?
No, ma'am. No, ma'am.
What was the methodology for allowing them to examine the exhibits? How'd you handle that?
I wasn't there a whole lot when we did this every night, but it's my understanding that the people that were involved with the exhibits, and especially the court reporters, and there was a certain time frame that they were allowed to take their pictures, and everything was, all of the pictures were looked at by the court reporters that were there and the lady from court administration, along with someone from my office and Mr. J. Bender, to make sure that everything was done correctly.
What I'm asking is how you handled having them, the press, view these exhibits.
If I remember correctly, the press, we had certain designated photographers and then someone, I think, from the state or the Posting Courier, and they were responsible for putting it out on a stream for the rest of the media to
And would
access.
they do that by photographing the exhibits as they were in your possession after court was over that day?
That is correct.
All right. And how did you handle the sealed exhibits in terms of their availability when these press people are there photographing exhibits?
They stayed sealed.
And so you think that you're aware of the fact that some of these on the scene photographs of the two decedents found their way into the public press. You're aware of that, are you not?
Yes, ma'am, I am. Yes.
And you contend that they photographed them in the courtroom?
That is what I heard.
All right.
Right here. Right there. Right there. That's the moment right there. She's like, yeah, you're in trouble, lady. Watch this, guys. Hold on.
That is what I heard.
All right.
Wow.
Finally, you have indicated about your book that some things that you put in there were, you called it literary license, not literally true, correct?
Correct.
Did you ever, by any kind of email communication or in any way, shape, or form, indicate or state that you wanted a guilty verdict because it would increase the sales of the book. Did you ever say that in an email or verbally or in any other way?
No, ma'am, I did not. It didn't matter to me if it was guilty, not guilty, or a mistrial.
Well, in your book, you suggest that the guilty verdict was what you wanted, and you were fearful that that a guilty verdict would not be rendered. You say that a lot about your feeling about wanting a guilty verdict, do you not?
I do agree that that is said in the book, and part of that is because I think it was a guilty verdict.
Well, this is that you were describing a time way before the verdict was rendered. When you wrote about those things in the book. Isn't that correct?
It is, yes.
And you even have something where you say your eyes met with jurors and others at Moselle, and y'all have an understanding, unspoken, that he was guilty. You said that in the book, did you not?
I did say that in the book, and I would consider that part of the literary, the word that we just said. But there was nothing spoken with a juror at all at Moselle or anywhere else at the courthouse or anywhere. I think that's part of that poetic license that we write to make something more apparent. But at no time did I read or try to read someone else's eyes, and that was just one of those gut feelings that I wrote in the book.
I mean, looking at someone else's eyes is the least of anybody's problems here, I feel like.
You wrote in the book, speaking of a time before the jury verdict was rendered, I was conflicted about knowing the Murdaugh family and about having so many people watching and listening to me as I read the verdict. I was mostly concerned about Alex being found innocent when I knew in my heart he was guilty. I had this fear that the goodwill of the Murdaughs had built up in the community would influence the jury.
Well, influence the jury. Well, what I will say is that does show she wasn't certain about what the verdict would be, right? She's like, I was worried he would be found not guilty. So she gets a 0.5% back on that one, like knowing ahead of time what the verdict would be.
You wrote that, did you not?
Yes, ma'am.
With that.
So you had those feelings well before the verdict was announced in this case. You had some definite opinions and feelings about what the verdict should be, did you not?
I did have a certain way that I felt.
But I would never... that's not any poetic license, what was said there. That's how you felt, correct?
Correct.
All right. Those are my questions. Anything further from the state, Mr. Waters?
Very briefly, Your Honor.
Yes, sir.
You were asked a number of questions about the interactions during the in-camera proceedings with the juror who was excluded. Were you in the room during the entirety of those interactions, or just were brought in here or there?
I forgot Creighton comes back.
No, I was only brought in for my asking of my questions from Judge Newman.
And you were asked a little bit about sealed exhibits and about Judge Newman's comments at sentencing at the end of trial. And just to clarify, those were not pictures of any sealed exhibits. It was a picture that someone had taken in the gallery that had actually been disclosed. And that's what Judge Newman was talking about, to your understanding?
That was my understanding. Yes.
And then after the trial, there was even a post-trial hearing or some discussion about the fact that some body cam videos had not been sealed, and Judge Newman fixed that problem after the trial. Is that correct?
Correct.
Nothing further, Your Honor.
Just a couple questions.
Mr. Harpootlian?
Let me understand this correctly. You would agree that you did release all of the exhibits in this case, sealed and unsealed, to the Texas film crew. Is that correct?
No, sir.
Hmm?
No, sir. I did not release the sealed exhibits.
What about to Netflix? Didn't you indicate to the judge they'd been mistakenly released and you're getting them back?
As an error before, when we realized everything, yes, those two did go, and Netflix had not even, they said they had not even looked at them.
Did you get them back?
We did get them back, yes.
And what about a Japanese film crew? Did they get exhibits, the sealed exhibits?
They did not get any sealed exhibits.
What about NBC Universal?
No sealed exhibits.
But you do concede that Netflix did get sealed exhibits.
They did it as an error. It wasn't
Who's
listed.
there?
Well, I would say the court reporter didn't mark it on the listing.
Well, why were you so accommodating to these national documentary folks? I mean, is this good for the book? I mean, the more documentaries out there about the Murdaugh thing, the better your book sales are.
The Murdaugh
I mean,
thing.
there was money in this for you, right? Again, it's about the money, right?
What's your question now?
Isn't it financially beneficial to you at the time to get more of these photographs out, more publicity, more Netflix, more HBOs, more Japanese? Doesn't that sell books for you? Didn't you see a financial
More Japanese.
Not at all.
Okay. Thank you. No further questions.
Ms. Hill, you may step down.
Testimony that will live in infamy.
Let's hang on for a moment. Mr. Lewis.
She's using her subpoena. I just wanted to make sure she's not.
Well, I wanted to step down. Yes, she's still under subpoena. I haven't heard what's going to be said. Mr. Harpootlian still has some things he wants to raise about other witnesses and so forth. So what I would prefer is that she remain with you, Mr. Lewis,
Okay.
Until we see what else is going to happen. You may step
So
down.
next they take a break and then they bring in Rhonda McElveen.
Do you swear or affirm that the testimony you're about
ELVEEN.
Y'all might remember her from the trial.
I'm gonna make sure I'm gonna stay here. Yes, sir.
Say your name for the record, please, so I can make sure I can hear
She's
you.
awesome, dude.
Rhonda McElveen.
Your Honor, can you hear? Okay.
Hi.
I can hear you great, Dick. I can hear you, but
You got a great sense of humor, too.
I would doubt that anybody posted
that
lawyers
better?
would hear you.
Is that better? No?
Is that thing on, Mr. Bailey?
I think it's a mic for the other courtroom. It's a mic for the next door.
I don't want to get into the thing going.
Well, I can speak up.
Haywire, man.
I'll just speak up. How about that? I have a big voice. I'll use it.
It's just not on at all, though.
No, it's all right.
Is it on?
This one.
Okay. All right, Mr. Harpootlian, you may proceed.
I'll speak a little louder if that helps. Say your name again for the record, please.
Rhonda McElveen,
And Miss McElveen, what do you do for a living?
clerk of court and ROD for Barnwell County.
Clerk of court in what?
Register of deeds. I have 2 titles.
2 titles. And is that an appointed or an elected position?
Elected.
So you're elected by the people of Barnwell County.
Yes, sir.
And how long have you been the clerk of court of Barnwell County?
This is my 16th year,
16 years. And
and I'm running again, sir.
you're up this year, 24 is?
Yes, sir.
All right. Don't think I'm allowed to plug that, but you have been the clerk for 16 years. You're up again this year. Now, do you know the clerk of, well, back up for just a second. Do you hold any position with, is there a state organization of clerks of court?
Yes, sir. I'm actually the president of the South Carolina Clerks of Court and Registry of Deeds.
Okay. And that means that of the 46, there are 46 of y'all, is that
Yes,
right?
sir. Yes, sir.
And you were elected to be the chairman of that group,
President of that group.
president of that group.
Yes, sir.
Now, are there certain rules and constraints that clerks should operate under in terms of dealing with juries?
Yes, sir.
And is there training for that, or is there a book for that, or how do you learn that?
You have the Clerk of Court manual for one that's on the judicial website. You also have the law books that have it in there. There's actually two separate forms, SCCA 237 and 238 maybe, that has regulations on it. And then we also have in the handbook that, or not handbook, but in the program within the CMS system, they actually have rules and stuff there you can go by as well.
Now, as a clerk of court, are part of your duties to deal with juries?
Yes, sir.
We understand there's a jury venire that's brought in at the beginning of a term, and then individual juries are picked for both civil and criminal cases. Is that correct? That
is correct, unless it's a non-jury trial.
And then there's just a judge, like we're doing here, right?
Yes, sir.
And in the process of picking juries, do you assist as clerk of court? When I say assist, who actually picks the jurors out of a hat, or however, whatever the process is?
Well, actually, the first process is you draw a jury by computers through the CMS
Hi,
system.
Cat Randall,
And then
welcome.
summons are sent out, and then once we come to court, we usually do a roll call. We see what everybody's doing, what the jobs and everything, to help the attorneys to decide which jurors they would like to get. They have so many strikes, etc. And then you call the names, and they have the strikes, and then that's your jury pool.
And then the judge will seat a jury in a jury box, like, although I've never quite seen a jury box that looks like that, but a jury box in a courtroom, right?
That is correct.
Your jury box in Barnwell County is a little, like 2 rows of 7 or 8 people.
Well, I actually have a jury box on both sides of the courtroom, because I have the grand jury on one side when they convene, and then I have the petit juries on the other side when they convene.
Okay. And the jury, they're sworn by the judge, and then they're put in the jury box, and they begin to hear arguments and testimony and jury charges by the judge. Is that correct?
Well, actually, sir, where we do it, the clerk of court usually swears them in with the judge presiding over the whole deal.
Okay. Once that jury is sworn in, what is your role in terms of dealing with those jurors individually or as a group? Are you allowed to talk to them individually, to pull them out, to converse with them about your opinion about the case?
To pull them out of the trial while we're going on?
Yes, ma'am.
No, sir, we're not. If they're on a break, et cetera, or if they request to see someone, then we manage to, I'll go in the door open. I'll say, which one of you needs to see someone? It might be the judge. And I said, hold on. And then I go get my judge. And so we've got a juror that needs to speak with you.
Do you converse with jurors about the merits of the case? By the merits, whether someone's guilty or innocent, or whether a plaintiff or a defendant should win in a civil case? Do you ever do that?
No, sir. About the most, only thing I ever do is go in and count them and tell them I can count up to 14 without even using my toes. And then I might get their lunch order. That's it. And the doors are usually open when I'm doing that.
And you have bailiffs that sit with the jury or sit outside the jury room?
They sit outside the jury room, and usually there's one beside them in the courtroom in case somebody needs something. But usually they'll catch my eye, or they'll catch the judge's eye, and we'll get something handled.
Okay. So did you have any contact with the clerk of court of Colleton County prior to her being elected the clerk of court of Colleton County? Did you know her before she was clerk of court?
No, I did not.
Did you come to know her once she was elected clerk of court?
Yes, I did.
And was it a pleasant relationship?
It was.
And how did you come to be, and to cut to the chase, you ended up being in the courtroom during the Murdaugh trial for part of those 6 weeks. Is that correct?
Yes, sir.
How did you come to be there?
When Becky and I met each other at a conference, clerk of court's conference, where she was discussing that she had that trial coming up, and I knew that she was relatively new, and I said, I'll offer to come help you if you would like. And I think she ended up talking to Judge Newman about it, and they both said, yes, it would be good that I was there.
Okay, because you tried a murder case, two in the past, correct?
Yes, sir.
Okay. And did you go and help Becky Hill try that murder case?
I did. I couldn't go for the first 3 days because I had court in Barnwell, and I told both of them if I had court going on in Barnwell, I could not be in Collin County.
Okay.
Looking for something here?
To your knowledge, had Ms. Hill ever been the clerk of court that managed a murder trial prior to this?
Not that I'm aware of, sir.
So this was her first murder trial, as far as you know?
As far as I know of this magnitude, I don't know if they had one before then or not.
Okay. Now, when did y'all, I mean, initially, what were you talking about in terms of logistics and how you did it and all those sorts of things?
Yes, sir.
During that, before the trial, before we ever picked a jury, did she ever discuss with you that she was going to write a book?
Yes, sir.
And
She
did
wanted to write a book. Yes,
wanted
sir.
to write a book. Did she indicate what the book was going to be about?
About the trial?
About the Murdaugh trial?
Yes, sir.
And did she discuss with you, what, if anything, did she discuss with you about how she felt the verdict should turn out to be in the Murdaugh trial, vis-a-vis in reference to the book? What would help the book?
A guilty verdict.
And tell the judge and me what exactly she said to you that you remember. This is prior to the trial.
Okay. Well, first of all, she said we might want to write a book because she needed a lake house and I needed to retire. And then,
I mean, I love her, right? But that sounds like a joke, right? Between two ladies at the courthouse, you know? I feel like.
That you remember. This is prior to the trial.
Okay. Well, first of all, she said we might want to write a book because she needed a lake house and I needed to retire. And then further conversations, a guilty
Kits, you probably saw
verdict would sell more books.
Cat Randall was in Runkle's chat the other night. You might have seen him there. That was one where we had a live stream actually redirect into Runkle. So there were several squirrel friends there, and Cat Randall was. It was when Runkle had Mark Betterow on, and Cat Randall sent in like a bunch of super chats and gifted a bunch of memberships, and so Runkle actually said thank you, Cat Randall, a whole bunch and stuff. It was really cool.
And we left it at that. This was before, even in December.
And when did she ever say that again to you during the weeks you spent there?
Several times. It could be said it was, amongst friends in her office, or we might be having dinner, that kind of stuff, but that's about it.
That she needed a guilty verdict to sell more books.
That would be the best way to sell books, yes, sir.
The best way to sell books. Now, during this process, did she ever express to you an opinion on whether or not, in fact, was Mr. Murdaugh guilty of the murders of his son and his wife?
Yes, sir.
Tell me what she said, and if you remember when.
I don't exactly remember when. I know it's over half of the trial had already happened, but the evidence was coming forth that it looked like he might be guilty, and she made a comment that guilty verdict would be better for the sale of books.
Okay. Now, as a result of a conversation you had sometime during the trial, I don't want you to relay to me what was told you. Did you have a discussion with the clerk, Becky Hill, about her being with jurors on her own?
Yes, sir, I did. One morning I showed up to Collin County, and I was told that she had taken a juror home the night before. And I was in the courtroom and I saw.
It's so weird, right? Because all the jurors denied it. And I mean, who knows, man?
Her, it was between the pews and where the back row pews are. And I mentioned to Miss Becky, I said, please tell me you didn't take a juror home last night. And she told me, she says, I did, but I didn't talk about the case. I had a bailiff with me. Mr. Bill was with me. I said, Becky, you don't do things like that. I thought we had stopped everything. It wasn't far enough along to really cause a major problem, or I would have told Judge Newman. But I thought we had to understand that you did not spend time alone with the jurors.
Okay. Now, I'm going to.
Did y'all notice that her shirt matches Poot's tie?
Spend time alone with the jurors.
Okay. Now, I'm going to read you some statements. Well, first of all, did you ever hear her say anything in front of you to a juror about whether or not, on the merits of the case, that is, whether or not he was guilty or innocent, or what you should pay attention to? Did you ever hear her? What, if anything, did you ever hear her say to a juror or in the presence of a juror? Anything?
No, sir.
Okay. But let me ask you if you've ever heard her say these statements, and if so, to who? Don't be fooled by the evidence presented by Mr. Murdaugh's attorneys, which I understand. Do not be fooled by the evidence presented by Mr. Murdaugh's attorneys. You ever heard her say that?
Your Honor, this time I would object. This witness was specifically called as a Rule 16.3B extrinsic evidence. I think we've covered the two grounds that would be permissible for her to testify to, and I believe that should be the extent of her testimony. So we would object any further extrinsic evidence as improper impeachment and also irrelevant. I think that the issues that were raised with the prior witness have been covered, and that was the express reason that this witness was called, and Your Honor allowed the testimony.
Overruled. You may continue.
Thank you. Did you ever hear her say that?
Can you repeat the verbiage?
Don't be fooled by the evidence presented by Mr. Murdaugh's attorneys.
Yes, I did.
And who was it said to?
It was said to me.
Okay.
And sometimes it might be a staff member in our office or someone from the media there. But other than that, I didn't hear her say it out there in front of any jurors.
Did she ever say to you or to other people around you, I'm not talking about jurors, watch him closely, talking about Mr. Murdaugh. This is just before he testified. Look at his actions. Look at his movements. Did you ever hear her say that?
Yes, sir.
Okay. Did you ever have any conversations with the bailiff, Mr. Bill?
Yes, sir.
Did he ever discuss with you the clerk's contact with jurors?
No, sir.
Okay. Did you ever hear her say that the defense is going to try to confuse the jurors? Did you ever hear her say that?
No, sir, I don't think so.
Okay. Now, let me deal with one last area. Let me see if I can simplify this. There was a setup in the courtroom. Pardon me, I've got a little frog in my throat. And I'm fine, thank you.
I think I'll share my bottle over here if he wants part of it.
Once a cork, always a cork, Your Honor. So, and I was there, you were there, this judge was not there. And prosecution tables over here, defense tables over here, judges up here. And then there's a rail behind which the clerk was. And because of all the massive electronic equipment we had there with big screens, there was an area over on my right facing the judge. And then I think you were located in that area right between the judge and that area. Is that correct?
Talking about in the well area?
Yes, ma'am.
Okay, yes, sir.
Now-
For the most part, sometimes I was out there with the screen
Right,
in the gallery.
right. But there was a screen on which you could see not only what the gallery back there could see, but the images that only the jury was supposed to see that were under seal. Is that correct?
That is correct.
Now, there's a woman named Rhonda, the writer, correct?
Rich.
Rich. And tell me who she is.
At the time, we did not know who she was. The first time they were there, we didn't know. Then she came in Miss Becky's office the night before, and she asked if she could have another seat in the courtroom for the next day. And Miss Becky said yes. And she says, and what's your name again? And the only reason why I remember Rhonda, because of course my name being Rhonda. And the next day, Miss Rich was sitting I don't know how to tell you, but she was sitting. Do you know where Doug was sitting?
Yes, ma'am.
All right. I know, Judge, you don't know where Doug was sitting, but anyhow.
But Doug was the audiovisual guy, and he had access to the unscreened, the unsealed images, correct?
Yes, sir.
And she was sitting right next to him, right?
Yes, sir.
Okay.
In that little part. And
So she could see the body cam, she could see the unredacted corpse pictures, the autopsy pictures, all the photos that the judge had sealed, correct?
well, no, the only thing she could see was what was being put up at the time.
Right. But
Okay.
as they were put up, she could see them.
Right. But they tried their best to seal it where you couldn't, but you could still see it there. I didn't see any of those.
Right.
Okay.
But she could see them.
Right. And Doug was really having a problem with that. And I can also tell you that our court reporters didn't know who she was either. Okay.
And she turns out to be a writer, correct?
Yes, sir. After I found out. Yes, sir.
And her name is Rhonda Rich.
Correct.
She was given access to areas that only court personnel should have had access
Right.
to.
But then we broke, and then she moved her in the well with me. She was about on my left, and either Elizabeth or Mike was on my right. And I noticed she was taking notes. And I asked her what was she doing, taking notes. She says, "I'm a Sunday school teacher." Well, I immediately covered up everything I had.
You don't trust Sunday school teachers?
So,
You don't trust Sunday school teachers?
let me just, there's too many preachers in my family on both sides, okay?
So you determined she was not a Sunday school teacher, and later learned that she was a writer writing about the Murdaugh case, correct?
Now, I don't know if she's ever a Sunday school teacher or not. There's just, I don't even know where she goes to church or anything, so I can't tell you that answer. But I did find out that she was a writer because shortly after she was put there, and evidently after I covered everything up, shortly after that, Judge Newman asked for a recess so we could find where people were going to be working. And that's when she put Miss Rich out in the gallery in control of that screen.
And she ended up writing the foreword to Becky's book. Is that correct?
Yes, sir.
Okay. And Becky gave her access to area only court personnel should have had. Is that correct?
That is true. But now I'll be honest with you, sir. There's been a couple times when we had other people that were sitting on that side where we weren't planning on seeing sealed documents that day.
Right.
But there were some other people that sat there, but nobody that actually sat in the well that wasn't court people.
Okay. Thank you, court's indulgence.
Mr. Waters, on cross-examination.
Thank you, Your Honor. Just about that, 1 second.
Oh, okay.
Judge, do you have an extra bottle of water up there by any chance you're willing to share? Oh, Miss Elizabeth's got one. Thank you.
Great.
Miss McElveen, how you doing today?
I'm good, sir. Please call me Rhonda.
I always called you Miss Rhonda. I've known you for a long time as well. In fact,
Yes, sir.
I tried one of those murder cases in front of you years ago. It didn't right.
Yes, sir.
Wanted to ask a couple things. I won't be that long. One of the things that you said earlier is you said when you initially were talking to Miss Hill, she said something like, "We ought to write a book" or something.
That is correct.
Okay. And so did y'all have any further discussion about you writing the book or participating with the book?
Oh,
or anything
no,
like
sir.
that?
I'm crazy enough not to write one.
Okay. During the course of after the trial, she did send you like chapters and things like that to take a look at.
I did get to see a couple of drafts of the manual.
Okay, so she did send you those to take a look at and review and that sort of thing. Is
Correct.
that correct? Okay. All right. And you were asked and again, Your Honor, just to be clear, I'd made some objections.
You do not waive any objections by cross-examination. They are all preserved. May proceed.
Thank you. You mentioned, some statements that you attributed to Miss Hill, during the course of conversations during the course of the trial. Is that correct? Just things like watching closely, watches mannerisms, things like that. And where were those conversations? Were those conversations taking place back in the clerk's offices with clerk staff and people like that?
Yes, sir. In the clerk's office. It might have been downstairs in the bathroom.
Okay.
Some of us had privilege to go to.
All right. So you and Miss Becky and other court staff, maybe just discussing the case and that sort of thing. Is that correct?
That is correct.
And people were expressing their opinions about what was going on and that sort of thing. Is that correct?
Now, when we were having those discussions, there weren't more than one or two, maybe three people there.
Okay, but just a few people there just talking back behind the scenes. That's what I'm
Correct.
driving at.
Yes, sir. Behind
It was behind the scenes, and it's not uncommon for, clerk staff behind the scenes, not to the parties, not to the litigants, not to the jurors, but among themselves back in, in the hallways back there to talk about the day's activities and things like that. Is that fair?
That's correct.
Okay. And that's a big difference between the natural conversations that people that work together, court staff and the like, have with each other, and actually having those conversations in front of the jurors, right? There's a big difference between those two, correct?
Yes, sir.
Okay. And it's not uncommon for you. You're a clerk of court. You got people that work for you. Y'all are going to have private conversations about what's going on that are not to be shared, particularly with jurors, but with the public as well. Is that fair?
That is true.
Okay. All right. And so there were conversations like that going on that you were privy to and part of. Is that correct?
That is correct.
Okay. All right. And you mentioned a little bit about, well, let me ask you this. So there are all these conversations going on, and that's natural. That happens, private conversations with court staff behind closed doors. But you never once saw or observed or had anyone tell you that any of those conversations were being shared by Miss Becky with any juror. Is that right?
That is correct.
All right. And if that had happened, if you had observed anything untoward or improper going on at this particular trial, you would have immediately gone to Judge Newman as part of your obligation. Is that correct?
That is correct.
And you never did that because you never observed anything like that. Is that correct?
That is correct.
Okay. All right. Now, you were asked a little bit about Rhonda Rich, who was a member of the media, and how she was placed kind of back where the defense IT guy was. Is that correct?
I didn't say she was part of the media, sir.
Okay. Well, she was a writer.
Yes, sir.
Okay. All right. And then you said that eventually, though, Judge Newman stepped in, and then she was moved out into the gallery in charge of the screen out there.
Right, but I don't know. I thought Miss Becky moved. I'm not saying Judge Newman did.
Okay. All right. And over there in that area of the, if we look in the courtroom, there was sort of the grand jury box over here, and that was where court TV was and media was stationed and that sort of thing. Is that correct?
That is correct.
All right. And inevitably, there were media members that could view some of the images that were being shown. They were just not able to report those just because of the nature of where the courtroom was. Is that accurate?
Well, I was told they couldn't see it, so I don't know what they actually saw because I didn't discuss it with the media.
All right. You never had a conversation with court TV or anything like that?
Other than the fact that be careful what they put on my front page of the New York Times on me.
All right. All right. And you're not aware of any image or confidential information or sealed image or anything like that that was ever made privy to Miss Rich that was put in any sort of publication or anything like that. Is that correct?
Not I'm aware of, sir.
Okay. Because if you had found out about that too, you would have immediately gone and reported that to Judge Newman because you would have said, that's improper. That I need to go report to the judge, correct?
Correct.
And you never once saw anything during the entire course of this trial that caused you to say, you know what, I got to go talk to Judge Newman. Something ain't right about what's going on here. Is that correct?
That is correct.
And you would have done that without a doubt if you had seen that, correct?
Yes, sir.
All right. Now, in looking at, back at this trial, you mentioned that there was a few days at the beginning of trial that you weren't there because you had your own court to take care of back in Barnwell County, correct?
Correct.
All right. And then pretty much after that, I guess you were pretty much present the majority of the remainder of the time. Is that fair to say?
I was. I had one medical procedure done. I missed 2 days, but basically other than that, I was there every day.
All right. And there was a period of time, though, during the middle of the trial where Miss Becky had a medical issue and had to be absent from the courtroom for about a week or something like that.
That is correct.
Okay. And during that period of time, you were present and functioning as the lead clerk of court during that period of time.
That is correct.
All right. So the reality is that you were present for probably as much, if not more than anyone in the clerk's function during the course of this trial. Is that fair?
Yes, sir.
Okay. And again, just to reiterate, there was not one time that you observed or came in possession of any information that you were like, I got to go talk to Judge Newman about this.
No, sir.
Court's indulgent. 1 minute.
Do they have any more follow-up? Oh, is this the discussion?
Very good. Mr. Harpootlian?
Half
sir.
half a question.
All right.
Half a question.
Mr. Waters indicated to you that you were not aware of whether or not, and you agreed that you never witnessed her talking to a juror about the evidence. Is that correct? We
That is
agree on
correct.
that. Do you know, but she did admit to you that she had been with a juror alone in a car for some period of time when you confronted her with that. Is that correct?
Yes, sir.
And did she indicate to you what she talked to that juror about while they're alone in the car?
No, sir. She told me, the only thing she told me was that she did not discuss the case, that she had Mr. Bill, the bailiff, with her, and he could tell her that. Tell her that.
And when she said she didn't discuss the case, did you bring that up or did she bring that up?
She brought that up.
You didn't say shouldn't be with him because it's frowned upon?
I did tell her that I would caution her on doing that because the perception of dealing with the jurors one-on-one is not tolerated.
Is not tolerated. Thank you.
Thank you, Ms. McElveen. You may be excused. All right, Mr. Harpootlian, call your next witness.
Your Honor, we would call Juror 741.
I know you're not going to. Well, that's right. She's an alternate. That's all right.
I forgot about this.
We're not going to sign her a letter. We're just going to 741.
I got you.
Unlimited to 4 questions.
This testimony.
The background about her getting picked for the jury and how long she was on the jury. And
That's fine.
She asked.
He will definitely open the door.
He's just telling me that's what he intends to do. Sometimes you can hold lawyers to that and sometimes you can't, Mr. Miller.
Yes, ma'am. Thank you.
I intend on only asking her those 4 questions.
That's fine.
Hey, Juror 741.
I'll talk with the lawyer.
Do you swear or affirm that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please have a seat. Please stand.
Your Honor, I assume the same rules apply to her that apply to the other jurors in terms of her image appearing.
That's correct. There'll be no photograph made of this particular witness who was an alternate juror in the matter. Thank you.
I'm going to refer to you as Juror 741. It's what we got to do here, so we don't use your name, so people don't know who you are. Is that okay with you?
That's fine.
And you and I have met before.
Correct.
I came to your home one Sunday afternoon. I believe you're cooking Sunday dinner, and we talked. Is that correct?
Correct.
And then you were interviewed by SLED,
Oh, is that your?
and you gave them a recorded statement. And then this morning you came here and you gave me an affidavit that you signed, and you're here with your lawyer. Is that correct?
Correct.
Now, just for purposes of the record, you were a juror. You were selected to be a juror on the State versus Alec Murdaugh murder charge, correct?
Correct.
And you sat in the courtroom for 6 weeks and listened to all the testimony.
Correct.
And you were the alternate.
Correct.
And so when the jury went out to deliberate, you were excused. Is that correct? Now, I'm going to go through a series of questions based on your affidavit, okay?
Okay.
Which you signed this morning, which was based on our initial interview with you and your interview with SLED. This is basically the same thing you told SLED. Is that correct?
Correct.
In your affidavit, you say before the defense put up their case.
Leave.
Sir?
Leave.
Go
ahead.
Thank you. In your affidavit, you said before the defense put up their case, Ms. Hill told the jurors, quote, the defense is about to do their side. They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off, unquote. Is this true? Did Ms. Hill say
That's
that?
exactly what she told us.
I'm sorry?
That's exactly what she told us.
Okay. The next thing you say is Ms. Hill made the above statement warning the defense would try to confuse us in the presence of all the jurors as we assembled in the same jury room. Is that correct?
Correct.
Now, y'all were initially in two
We was
jury.
in 2 separate rooms, and when she came in, we all went in 1 room.
Okay. Paragraph number 5, Ms. Hill said, if you get emotional, we want to see your face because that is what they want to see. What
She
does that
said,
mean?
She said, don't get nervous. Be afraid to show your emotions because that's what they want to see.
Who wants to see?
I don't know who she was speaking of. I'm assuming the court.
Okay. And then number 6, Ms. Hill also informed us Alex Murdaugh was going to testify, but I don't recall
no
exactly what
idea.
she said. All the jurors were assembled in one room when she made that comment.
Exactly.
She told you that Alex Murdaugh was going to testify.
Exactly.
Did you know before that he was going to testify?
I think we knew that he was going to come up. I think he was supposed to do it the day before, but he didn't. And I knew he was going to be the last person that afternoon.
Okay. During the visit to Moselle, juror number 826 and I walked to the scene together. Then juror 826 began walking with the clerk of court. Becky Hill, I could tell they were talking. I could not hear what was said between them. Is that correct?
Correct.
Is what you put in this affidavit truthful?
Yes, sir.
And this is what you told us back in
I don't remember the
August,
months
I
ago.
believe. I think I interrupted you cooking Sunday dinner.
Right.
All right, thank you. Please answer any questions.
I think that was actually the first juror they spoke with, as in they being the defense that tipped them off to anything. Because I remember when that video came out.
Orders. All right, Mr. Meadows.
Thank you, Ms. Please, Your Honor. Good afternoon, Ms.
Good
741.
afternoon.
It's nice to see you again.
Yeah.
I think it's the first time you talked to Mr. Harpootlian or Mr. Griffin or any other attorney.
I can't tell you exactly. It's been months. It's probably been September, August. It's been months.
Okay. And were they the first attorney to talk to you, or was there somebody else that talked to you prior to them? Any other attorney?
No, I think he was the first person I talked to.
Are you sure?
I think it was so many people trying to call me, and I was trying not to be involved, so I can't quite remember. But he's the first person I've seen.
First person in person?
Yes.
Okay. So when he came to your house?
Yes.
Mr. Harpootlian came to your house?
Yes.
Okay. And at that point, was Miss Holly with him? Holly, you mind raising your hand? You see Miss Holly?
Yes.
Okay. And was anybody else with him?
Yes. He was.
Mr. Griffin?
Mr. Griffin.
Thank you. And you gave them a statement then, right?
Right.
And did they record you? I mean, were they audio or video recording you? Did they say we might record this?
No.
They didn't?
But neither did the people that came out. They didn't. I didn't know I was being recorded by them either.
I'm not trying to.
Oh, okay.
That's what they did.
Is
They
there an
had
audio
to
recording
her out.
your conversation with them that you know of?
No.
Did they say?
Not that I know of. No.
Okay. So you don't remember saying?
No audio recording. We're required to tell her if we're recording her under rules. We didn't record her.
He was on cross-examination.
Right. Like I said, she was recorded. So that is the same juror with that video, because we saw that when that came out.
That you know of?
No.
Did they say?
Not that I know of. No.
Okay. So you don't remember saying?
No audio recording. We're required to tell her if we're recording her under rules. We didn't record her.
He was on cross-examination.
Thank you. And at that point, and that was again, do you remember, you said you think, was that around the end of August, 1st of September when they first came and talked to you? Roughly.
Roughly. I don't want to.
And you told them basically everything that you've told us now, right?
Yes.
Exact same thing.
Exact same thing that I told them.
Nothing less, nothing more.
Yes.
So Mr. Harpootlian, just, and you didn't sign an affidavit back in September or when you talked to him the first time?
No.
And why not?
Because he was just coming out to talk to me. He just was asking questions. It wasn't nothing officially. He had, so.
When you say nothing officially, I don't know what you mean.
He was just coming out to he was just asking questions about what went on during the trial. It wasn't.
Well, did they ask you to sign an affidavit that day?
No.
Okay. Did they ask you to sign an affidavit anytime right after that?
No.
They never asked you to sign an affidavit until this week?
No, I was supposed to meet with them a couple of occasions, but I was having my own personal issues and I couldn't come.
Okay. Well, I'm sorry about that.
No problem.
So you told them at this first meeting back at the end of August, 1st of September, that y'all going to hear some things that will throw you off. Don't let it distract you or mislead you. Is that what you said?
That's what I didn't say that. That's what the clerk of court told.
Yeah, I'm saying that's what you said to them. I'm sorry. Okay. And where did that take place?
She would always stay like on the outside of the jury room, like in between, like on the outside. She would never really come inside the jury room.
So there were two rooms, right?
Yeah.
Okay. One room and then the other room separated, right?
Right.
And you couldn't hear people talk in the other room, could you?
No, that's why when she came, everybody came in one room.
Okay. So this comment you said she made, did she bring everybody out in the hallway?
Some people was in the hall. That's why I said she was standing right at the head of the door.
Standing at the head of the door.
Right.
Was Mr. Bill there? Your bailiff?
Yeah, he would be standing in the hallway.
He's all out there, right?
Right.
And then she said in front of everybody, the defense is about to do their side. They're going to say things that will confuse you. Don't let them confuse you or convince you or throw you off. She said that to everybody.
She said that to everybody.
Everybody could have heard.
Everybody could hear it.
Huh. Hi, James. Welcome.
And you said you were all in the same jury room.
Yeah, we would all be in the same. When she came, she was standing in front of the door with the jury room that I was in, and everybody would come over. They would let us know before she came. They'll let us know after lunch she gonna come talk to y'all, and we all would gather together.
So would you go from 2 rooms into 1 room?
Some would be standing out. She was standing in front of the door. Some would be standing around her.
Was this Happy Annie? Was it you that we were talking about this earlier? Well, there's some of you. Some of us were talking about this earlier. The idea of where the jurors all together. This might be the part I was actually thinking of where they talk about the hallway versus the room. So this is important as to was everybody there when she said certain things.
And you said you were all in the same jury room.
Yeah, we would all be in the same. When she came, she was standing in front of the door with the jury room that I was in, and everybody would come over. They would let us know before she came. They'll let us know after lunch she gonna come talk to y'all, and we all would gather together.
So would you go from 2
Interesting.
rooms into 1 room?
Some would be standing out. She was standing in front of the door. Some would be standing around her outside the door, and some would be in the room. But it was clear enough for us to hear and see her.
And Mr. Harpootlian led you, and Ms. Hill made the above statement warning that the defense would try to confuse us in the presence of all of the jurors as we had assembled in the same jury room.
We was all in the same jury room. She would be on outside the door, and we would be in the room, and someone would be standing beside her. We was always all together when she came.
And do you think that was unusual?
No, because I guess she didn't want to walk back and forth from room to room.
No, in fact of what she said. Do you think that was unusual?
Yeah, I did.
And if you get emotional and see his face, they want people to see your face?
Because some of the jurors was getting emotional, and I guess she noticed it, so she commented on it.
And you said you did not. The statement he read, she informed you that the defendant was going to testify, but don't recall exactly what was said. When was that?
That was I think he came in the afternoon, at 2:33. So that was before he testified, I think.
Where was it?
Oh, in the jury room. Where we were all, like I said, we were all meet.
And I guess what I'm saying is you're in 2 different rooms for a while, right? And y'all get up there, you split. Don't you?
She's sitting there walking.
Yeah.
The people that talk loud in one room and the others in the other. Pretty much.
No, it's not like that. It was just they just split it off. They just asked us what room we wanted to go to.
Oh, by the way, right behind Miss Becky, that's Stephen Smith's mom right there. By the way, Sandy Smith, right behind Miss Becky.
To the box. Mm-hmm. You tell us you'd all go into one jury room together?
Only when she came to speak to us.
And Mr. Harpootlian asked you about
Becky was on the stand.
I believe number 7 on the affidavit. And when did you sign this affidavit?
This morning.
And when's the last time you had talked to Mr. Harpootlian?
No, I haven't talked to him since he came to my house.
Or any of them before today?
No, I haven't talked to him since he came to my house.
Talked to anybody else involved in this case before today, since then?
No, he was talking to my lawyer.
Okay, and who was that?
Sean Wilson.
Okay, and when had Sean Wilson talked to you?
He's been my lawyer.
Since when?
Since 2021.
When Mr. Wilson talked to you about this case and what you told Mr. Harpootlian prior to.
All right. They apparently don't object to this, but I am very uncomfortable with your asking what her lawyer told her.
I wasn't going to content. I was just looking for timing.
Well, she's told you a couple of times that he was her lawyer since 2021.
Well, see your lawyer for this.
For what you mean for this?
Well, like being a juror.
For being a juror?
Yes, sir.
I didn't have he was always my lawyer.
You didn't hire him for this?
No, I didn't hire him for this.
But he had talked to Mr. Harpootlian about your affidavit and your testimony today, hadn't he? Is that a yes?
Yes, he was looking over the paperwork. He was looking out for me because he's my attorney.
And when was he looking over the paperwork?
No, I guess ever since September, October. I wasn't really keeping up with it to be honest, because I'm.
So do you know if he's talking to Mr. Harpootlian?
She's like, I'm trying to move on.
Yeah, he talked to him today.
Talked to him today?
We was together.
Who was together?
Me and my lawyer.
And Mr. Harpootlian?
Yes, when I went to go sign the affidavit.
Okay. Where did you sign it?
At his office.
At whose office?
Mr. Harpootlian. Office.
I was supposed to. I would object, Commissioner.
Okay.
This meandering. I mean, there's no jury here. It's you. And I don't know what.
Wow. I think we got all the information. Yeah. All right. I think he's going to move on. Yeah.
Wow. So those two have bad blood for anyone who's not as familiar with their whole thing. Apparently it goes way back.
And that's the last question Mr. Harpootlian asked you about this affidavit.
What was the last question?
during the visit to Moselle jury, say the number, whatever the letter is, it doesn't matter. You saw a juror, and I walked the scene together, then the juror began talking with the clerk of court. I could tell they were talking, but I couldn't hear what they were said between them. That's the last question he asked, right?
Correct.
So, and you have no idea what that conversation was about?
No, I don't.
Now, the next, number 8, he didn't ask you about, was I also overheard discussions in the jury room that Mr. Hill drove a juror home. I believe it was a juror whose nickname was Boston. Now, he didn't ask you that a minute ago, did he?
No, but, okay, no.
And you didn't include that in the first conversation you had with him back in August and September in this affidavit. Miss Holly did you? You didn't tell him about that.
I can't remember.
Have you seen the affidavit Miss Holly did for you back in September 1st,
Yes, Your Honor,
2022?
Ms. Holly did not do an affidavit. Ms.
Here's
Holly
the thing.
did an affidavit.
Anyone who thinks, why is he going hard at this juror? He's not going hard at this juror. He's going hard at Poot. Because the thing is that she hadn't talked to Poot for like months and months and months. She can't even remember how long, right? Poot calls her to this hearing, right? She shows up, hasn't spoken to him in forever. And Poot shows up there and meets with her without anyone's knowledge and is like, I guess she's with her attorney. I mean, and then she's like, Poot. Anyway, and so he's like, here, sign this affidavit. And there's like, the point being, there's new information in the affidavit. Now, there's been some funny shenanigans going on too, right? Because the whole thing over the lunch break, and then you have this lunch break go by. And now all of a sudden, we've got, Juror Z piping back up through her attorney, who, by the way, sat at the trial every single day and is also good friends with Poot and everything. And I'm blanking on his name at the moment for some reason. But anyway, and it's sort of like wanting to correct her statement, which why would she even know there was need for correction unless somebody said something to her? I don't know. It's a I will just say this much. To the extent there's any weaselry going on here, right? At least it's coming from the defense trying to get different statements in and changing juror statements or whatever, right? At least it's from the defense, not from a public official like the clerk of court or from the state. So anyway, I think he's trying to point out that what are the odds here, with Poot meeting with her, and now there's new things in this affidavit and what have you. So
her affidavit, her notes of what this young lady said to her, and what she included and didn't include was based on what Miss Holly thought was relevant at the time. But she can't be cross-examined.
Okay, let me back it up to get this whole scenario.
They did you? You didn't tell them about that.
I can't remember.
And you didn't include that in the first conversation you had with him back in August and September in this affidavit. Miss Holly did you? You didn't tell them about that.
I can't remember.
Have you seen the affidavit Miss Holly did for you back in September 1st,
Yes, Your Honor,
2022?
Ms. Holly did not do an affidavit. Ms. Holly
She
did
just
her affidavit, her notes of what this young lady said to her, and what she included and didn't include was based on what Miss Holly thought was relevant at the time. But she can't be cross-examined.
That's not in evidence, Mr. Meadows, so I think you need
Get
to
over
move.
it, John.
Sir,
Offer it. Just to-
well, how is this thing going to be authenticated?
Even more importantly, he said, you can't question her. I'm sorry.
Can't talk at one time. I don't even have the affidavit. Let me see what you're talking. You talking about the one that was just offered today?
This is one Holly did when he first talked to her back in August, and she's referring back to
Miss Miller. Okay, Miss Miller.
This is Ms. Miller's affidavit about what she thinks this juror said.
Yes.
I'm not going to allow this, Mr. Meadows. I don't see a whole lot of difference between this and what's been said in the affidavit that has been offered by Mr. Waters, but I'm not going to allow that.
You did not tell them about hearing that Miss Hill had driven a juror home back when you met with them in September.
I can't remember.
Who is Boston?
She was a juror on on the trial. I don't know her, but that was the nickname they gave her. I don't know her first name.
And what, if anything, did you know or convey about Boston?
She was a juror on the cases like everybody else.
Anything else?
Nothing.
Ma'am?
No.
So again, Ms. Harpootlian didn't ask you, but when you, in the affidavit of today, I also overheard discussions in the jury room that Miss Hill drove a juror home. I believe it was a juror whose nickname was Boston. Is that something was added after your lawyer was with Mr. Harpootlian today?
I don't know if I added. We talked about it today, but I don't know if I mentioned it in September or not. But I know it.
You've ever talked about it, wasn't it?
No, it's not.
To raise objection.
The first thing is, Mr. Meadows, I'm going to caution you one more time about this. You cannot talk over a witness. The second thing is, you don't need to be marching all back around. You talking only to me, not the jury or anything else. So let's slow down. And, this is repetitive of questions that have been asked before. If you want to take this tone with her, I don't know exactly what you're trying to accomplish.
I'm not trying to take tone. I apologize. She knows that, and I'm sorry.
Well, you're just talking to me. This is not some drama thing for the jury.
I know. I'm sorry.
All right. Well, let's finish this thing up.
Only reason I did what he hadn't asked about it, and it to me is the key issue here. They're trying to say was different.
Mr. Meadows, I mean, you lecturing to the witness or to me or what? Please don't do that. Strike that from the record, please.
Don't strike. Don't strike.
Let's
I'm sorry.
Let's line this up.
Thank you.
All right.
So you don't take no
In number
tomfoolery.
9 in the affidavit that before the jury began deliberating, I heard a member of the court staff say the deliberation shouldn't take long. I don't remember specifically who made it, but it was made in the presence of the entire jury right after closing arguments in the jury room.
Correct.
Then I think you said something, Judge Newman came to see you afterwards, but after the jury went to their room, you were in a separate.
No. When we first left out the courtroom, we all went in the same jury room, and then they separated me. Oh, that's okay. That's fine.
But when they started deliberating, were you in a separate room?
Yeah, when they started deliberating.
So you had no involvement in the deliberations or verdict of Richard Alexander Murdaugh?
No, sir. No, sir.
You didn't get to come back to the verdict, did you?
No, sir.
Have you read Miss Hill's book?
No.
Okay. And I noticed you interviewed, I did watch it. I think Mr. Radford back there, would you raise your hand, Kyle Radford? I think came to your place and interviewed you.
Yeah, she went.
At some point during the trial, I think there was some
She went to New
discussion that
York.
somebody might have wanted to do an interview with you.
Yeah, that's what she said.
And then after the trial, I think there was some discussion, somebody, since you weren't on the jury, they may not have wanted to interview you. You remember that, roughly telling officer that?
Yeah, that's not what she said. She came to me, roughly in the middle of the trial, and she said, I have a few people who would like to interview. She said, she didn't say a few. She said, I have a lot of people that's inquiring to interview with you. She said, but I'll have to get with you after the trial. But after the trial, she came back in the jury room and she started handing out cards. And she handed everybody cards but me. And she was like, I don't have any cards for you for interview because no
Oh,
one
never
wants to
mind.
speak.
She didn't go.
That's what was said.
And did, I mean, you weren't happy with that for you.
Yes, I was.
You were happy with
I don't need to be interviewed.
Stay course adult.
Briefly, Your Honor. Series of questions that I'm not sure I've heard before.
Who approached you during the trial and indicated the media would want to interview you?
Miss Hill.
Miss Hill?
Miss Hill herself.
Just you or all the jurors?
They had, I think it's the day they had the bomb threat. And I think that was the day. And she approached me.
You?
Me, by myself.
By yourself. And where were you?
That's the day in the lunchroom when they had the bomb threat. We went to the middle school. I believe that was the day.
The middle school. And she came over to you and said what?
That she had some reporters that was reaching out to her that wanted to speak with me.
To you?
Yeah.
Not the whole jury, to you. Was there anybody with you at that time?
No. It was
Did she indicate why they wanted to speak with you? Just you?
No.
Did she indicate what reporters?
No.
And did she ever talk to you about doing interviews with the media after that?
No.
But you indicated she brought some cards at some point?
She brought cards in the hand to the jurors.
Before?
After.
After?
The verdict was read.
Cards of media people?
Yes, sir.
Did she tell you she was writing a book?
No.
Did she indicate to you why it might be good for her if you did media interviews?
No.
But she had a conversation with you in the lunchroom of the
I
middle
believe it was the
school.
lunchroom. I
by-
think the day of the bomb threat.
the day
But
of the
I'm 100% sure she came to me and she told me that in the middle of the trial.
Was there a bailiff with her or just
No,
her?
it was just her.
Pulled you over and said, "Hey, I can make you famous. I can put you on TV."
She said she had media that wanted to talk to me. That's what she said.
Okay. I hyperbolized. I apologize, Your Honor.
Yes, sir.
That's all I have.
All right, no further questions, Mr. Harpootlian?
No, Your Honor.
Very good. Thank you
Taking
very
poetic
much, ma'am,
what
for-
liberties like
are
Miss
excused.
Becky.
All right, Mr. Harpootlian, that it?
I need to put one matter on the record, Your Honor, and that is it.
All right,
We'll just put on the record.
all right.
Um, Earlier today, you received a very short affidavit from Juror Z. We'd like to proffer that and make it part of the record.
Right, I did not admit it, but I'll accept a written proffer, and if you would give the thing to me, I saw it on the screen on my law clerk's computer, but I don't have a printed out copy.
We don't either, but would you allow us to do that?
I will allow, before I close the record with Ms. Harris, if you can get it to us. When can you get it to us?
We could email it this afternoon.
Very well. How about do this? How about email it to Mr. Waters, to me, to Ms. Diaz, and to Ms. Harris, the court reporter. And I will say now that it's offered as a proffer, and I will receive it as a proffer. I have not admitted it into evidence. All right.
Your Honor, we referred to earlier on a email to the Japanese television folks. I do have copies of that. I'd like to make that part of the record.
All right, but hand it up to me and let me see it. And also, of course, Ms. Waters.
That's the court fee that's frozen.
All right.
Your Honor, for the record, the hearing before Judge Newman to seal the body cam videos was on May 26, 2023. This email is in July, just to give you the context of
All
what's
right,
going
and
on.
this is being offered as a after the fact email to Rebecca Hill, and her replies garnered from the emails that were released by Cotton County at a certain point. And it addresses the issue I raised with Ms. Hill relative to the security of sealed records.
Exactly, Your
All
Honor.
right, I'll admit it. Mr. Waters?
As to this specific exhibit, Your Honor?
Yeah.
Your Honor, I mean, we don't have any objection other than the ones we've raised just generally to the testimony. But I have no further objection to
Very
Your
good.
Honor.
All right.
Your Honor, that's all we have.
All right, hang on. All right, you got a copy of it there? I got it. Here's the next exhibit. Proffer is one. Right, the proffer is your exhibit one, Mr. Harpootlian, and this, which I have admitted, is your exhibit two.
Thank you, Your Honor.
Right. All right, now we proceed to closing. You prepared? Very good. Mr. Waters?
Thank you, Your Honor. Just to go back and reiterate as to the standard. And ultimately, we've of course argued that the defendant has the burden. We've also discussed that the standard for Your Honor, of course, is first of all, was there any misconduct that occurred? And then regardless of that, whether or not there was any effect on the verdict. And the standard has been expressed in multiple cases is whether the verdict is solely the product of honest deliberation or the product of outside influence. And that inquiry fundamentally, as the court recognized from the very beginning, focuses on the jurors themselves, because it doesn't necessarily matter what was said as much or what was intended or what was inadvertent, even assuming that those existed. What matters is what the jurors heard, what they perceived, and whether or not it had any sort of effect on the verdict. And Your Honor went through that inquiry with these jurors. 11 of those jurors were clear and unequivocal that there was no effect on their verdict, and also clear and unequivocal that nothing was said that could in any way be inferred as any sort of attempt to influence them. And I think that's very important, Your Honor, because, there can be sometimes behind the doors, as we've talked about, I think some of the cases recognize this, that some conversations can go on and things like that can happen. But ultimately, and while I think there were some cases cited in some of the various South Carolina decisions, that's unrealistic and not surprising to think that sometimes things like that can happen, an untoward comment or something was said. But that was an Aldrich, Your Honor, in the 1999 Supreme Court case. But the mere fact that something like that may be stated, that could be stated in a neutral reason, is not enough to undermine the verdict, because the inquiry ultimately boils down to what was it that those jurors heard, and in the end, though, did they listen to the instructions from the trial judge? Did they come to a fair and honest verdict? And Your Honor, the evidence here is overwhelming, I would say, from the people that matter, and that's those jurors. And that is, there was no effect on the jurors. And you saw every single one of them very clearly and strongly looked you in the eye, all 11 at least, and I'll get to the 12th one in a second, but looked you in the eye and said, no, that didn't happen. No, I didn't hear anything like that. No, there was no effect on our verdict. No, this was our verdict, and it was based solely, which was Your Honor's question, solely on the evidence and the law and the testimony at trial. And I think that carries the day. We have one juror, and I want to make sure, because I'm about to say the number and I don't want to do that. Let me go back to Juror Z. And let's look at Juror Z and what she said, because Juror Z also said that, yes, I said this was my verdict. I was polled and said this was my verdict. Juror C also said that my verdict was solely based on the evidence in the law of the testimony at trial. Answered question number 2, yes. Absolutely yes. But then goes on after that to say she heard some communications from the clerk and then says, well, it had an effect on my verdict. Even after she had already answered question number 2 when she said her verdict was based solely on the evidence in the law and the testimony at trial. And beyond that then, Your Honor, I think that it's very telling that the affidavit that was submitted from this particular juror, and we've been pointing this out from the beginning because it's very crucial and very telling, because despite the things that she alleges that happened, even though the other jurors say it didn't, despite the things that she alleges that happened, she says that she voted guilty because she felt pressure from other jurors.
So Justin Bamberg has a different thing on his lapel. Over there on the far left, Justin Bamberg has the curly hair. He's got a different thing on his lapel. And he's not SLED. He's an attorney. Interesting. There are a number of SLED people there that worked on the case. And, oh, by the way, there's Anjanette Levy in the back. But they're seated on the other side. So when it pans over to the other side of the gallery, we can see if they've got any things on their lapels. So
it's not that her verdict was in any way affected from some supposed external influence. In the affidavit that was filed with the defense motion from day one, that is what she says, that she felt pressure from other jurors. And Your Honor, we've cited the cases over and over again that the internal mechanics of the jury room, the fact that one juror feels pressured by others, as long as there's not violence or things that go beyond the pale, that is not a basis for undermining a verdict. That is part of the deliberative process, and it's expected, and it occurs. But I think it's very telling that we have those conflicting answers. And Your Honor, without waiving any objection to the latest affidavit that we were just discussing from this juror, I think that's very telling, because now we have answer number 3 as it relates to this particular juror. And of course, it is clearly manufactured and rehabilitated, recognized after the fact. She, of course, this juror is represented by Joe McCullough. And ultimately, we've got now a third version of events from this very juror. So we have this juror who's given answers all over the place that are inconsistent with 11 other jurors who were very strong and unequivocal that, yes, this was our verdict. It was based solely on the evidence, the law, and the testimony, that there were no communications from Becky Hill that influenced that verdict. And I think ultimately, when you look at the case law, in the end, it's up to Your Honor to make that ultimate determination and looking at all that law together. We cited a number of decisions, including, as we discussed, the questions to be had. I sent an email where we set out some questions that it's not uncommon, perhaps, for a juror to have a second thought. But the law is very clear that it does not recognize that, because what that would do would be to consistently and constantly put every verdict that occurs in any courtroom in this state or in the nation at risk. Jurors don't have to vote in perpetuity. They vote on one day and one day only. And here, Your Honor, the evidence is overwhelming that those jurors' verdict was the product of honest deliberation. And the only bit of contrary evidence to that effect is from a juror who, frankly, not only said that it was purely the result of honest deliberation, but then has answers all over the place. And Your Honor, I would say that the other 11 jurors are credible. They were strong. They were clear with Your Honor. And I think that ultimately that carries the day.
By the way,
We've had testimony.
he next to Becky Hill there in the gallery is her attorney on this day. Still her attorney. He was the one who was representing her there at the bond hearing.
From other people since the jurors were here. We've had testimony, obviously, from Ms. Hill. We've had testimony from Ms. Rhonda, and we've had testimony from this alternate juror. But again, none of that testimony at all goes to what is the ultimate test for Your Honor, and that is whether or not this verdict was the product of honest deliberation. And on that, again, the evidence is overwhelming and strong and clear that it was the product of honest deliberation. It's very interesting as we look at some of the testimony from the other witnesses. And obviously we have Miss Becky, and as Your Honor has pointed out, we're not here to go through some of the issues that have been alleged or are percolating out there. That's not the point of this proceeding here today. But Miss Becky is a court reporter and then became a clerk, and was clear to you that she never made any comment in an attempt to sway the jury one way or the other. We have Miss Rhonda. And Miss Rhonda came in and testified, but I would submit to Your Honor that this is kind of a red herring, because what Miss Rhonda described were conversations that she herself admitted are just the kind of conversations that go on. And that's the reality of it. The conversations that go on among a trial team when we're not in open court, where we're discussing things, the kind of conversations that go on among court staff behind the doors, those types of conversations go on. But that does not mean, nor does that necessarily indicate that somebody's not going to come out here and do their job fairly and understand the distinction between influencing a jury and not doing that. And one thing that I think is very important is Miss Rhonda was at that trial more than Miss Becky was. And she was very clear. And I probably was as repetitive as anyone here today in asking that question over and over again, because I didn't want that point to be lost. That Miss Rhonda said, I was there more than anyone else, and I never saw anything or observed anything or had anything happen that would cause me independently to go to Judge Newman, because that's what I would have done, to go to Judge Newman and say, something's not right about this. This needs to be fixed. Something's going on that's improper. And I think that that is an extremely crucial fact, because Miss Rhonda admitted and said, of course, as she would, that if something had happened that the judge needed to know about, she would have been the first one to do it. And it never happened. And she was here more than Miss Becky was. It never happened. When we look at the balance of those facts, when we have the clerk of court come in and testify that, you know, maybe I did this or maybe I did that, maybe I plagiarized the book, a portion of it, maybe I did this, maybe I wrote in things in there that are based on community knowledge or newspapers or poetic license or whatever you want to call it. I don't care about the book. And I would submit that Your Honor doesn't need to care about the book either, because the book and what happened with the book afterwards is not what is relevant to the inquiry. But she was clear that she did not have any attempt to influence that jury. She was clear about that. And Miss Rhonda was clear that she was not aware of anything like that either. And what does that do but corroborate the most important witnesses here? The defense, I think in one of their letters, tried to say that Miss Becky was the state star witness, and that's not what this inquiry is about. It's not what this inquiry is about at all, because as I've said from day one, if there were not facts to be litigated, if we had not done an investigation and had those 11 jurors say, that didn't happen, there was no effect on our verdict, this was the product of honest deliberation, we would be the first ones here standing here to say that. But what we do know, Your Honor, is that what Miss Becky said and ultimately what Miss Rhonda said corroborates who are the true, if you want to say it, and I'm only using this term because the defense accused us of Miss Becky being our star witness. There are no star witnesses here. This isn't about stars. But what Miss Becky and Miss Rhonda do is corroborate who are the most important witnesses. And that are those jurors. And you have 11 of them strong as a rock saying this verdict was not influenced. Nobody tried to influence. And regardless, it was the product of our honest deliberation. And you have one juror who said that too, but then has answers that are all over the place. And if you go back to her original statement, what she says is not external influence anyway. It's not sufficient under the law. So I think that the proof here is overwhelming. I think the proof here corroborates what those jurors say. I think the only juror that we have to contend with, her testimony is compromised. And I'm not saying that that person is in here maliciously lying. I just think that this process is a lot. But it's clear that if there was any attempt to influence this jury, those jurors who sat in that box, every single one of them, you saw them, and we saw them for 6 weeks. They are conscientious. They take their obligations seriously. They were not here to reward friends or punish enemies. They were here to do their job appropriately and fairly. You saw that in their eyes. You saw that in their mannerisms. You saw that in their demeanor. And they were strong and clear that this verdict was fair. Your Honor, we would submit that the motion for new trial be denied.
So before we hear from Poot, there's a new thing from StreamYard. It's like a beta thing. I don't know if all people have access to it, but it's a thing that says show comments on stage. I just toggled it on, so I don't know what it'll do, but we'll see when you guys say stuff in the chat what happens. And I can also toggle it back off. It's dumb.
Mr. Harpootlian.
Mr. Griffin,
All right.
Oh, Tim's going to argue, not Poot. Okay, there you go. So that's what it does. Interesting.
That way I won't be interrupted by Mr. Harpootlian as I'm trying to make my points. Your Honor, I want to first start with State v. Green because I understand that that's the guidance. That's what we're following here. And reading, excerpts from State v. Green, first, it is absolutely clear in State v. Green that we find ourselves, and the issue is whether there's a defendant's right to a fair and impartial jury under the Sixth Amendment has been violated. Reading from the opinion, it says in the Sixth Amendment's context, the Supreme Court of the United States has held that, quote, any private communication, contact, or tampering with a jury during a trial about the matter pending before the jury is deemed presumptively prejudicial. Now, Green goes on to say that we are not going to categorically apply the presumption whenever there is a contact with the juror. But
do y'all see the comments on the screen? Let me know if you guys like it. I don't know. It might be it might interfere with being able to see stuff.
the question is it prejudicial? Not whether the verdict would have been different. It is it prejudicial? And I'll keep reading. The court says we're not persuaded that the Rimmer presumption of prejudice, we're talking about prejudice, not is the verdict different? It was their prejudice. Was this tainted process? Was it prejudice to the defendant? Was the process prejudicial to the defendant because of extraneous communications? Not whether the verdict would have been different, but whether there's prejudice involved in the process of the trial.
So this is one of the points of dispute here, that he's saying it's not, as far as the two prongs, right? One being, was there statements made? Two being, did it impact the verdict? This is where they're saying, or where the defense is arguing that she misread the opinion from Justice Kittredge. And she's saying, no, I didn't. I think she even says she was there, but he's saying it just has to be prejudicial, not impact the verdict. So that's a good point. Happy Annie's saying it puts the comments in the corners to memorialize the live comments for replay crew. So I guess we don't need that because I also have replay crew toggled on. So I guess we'll get rid of that.
The court goes on to say, our unwillingness to categorically apply the Rimmer presumption of prejudice stems from our view that not every inappropriate comment by bailiff to a juror rises to the level of constitutional error. Goes on to say the attempted bribery of the jury in Rimmer conduct, which goes to the heart of the merits of the case, is a far cry from the circumstances presented in this case. The bailiff's actions here, though improper, did not touch the merits, but only dealt with the procedural question of how the judge might handle a jury impasse that apparently never materialized. The court says, while we decline to adopt the Rimmer presumption of prejudice in every instance of inappropriate bailiff communication to a juror, the occasion of this case presents an opportunity for our clerks of court and circuit judges to ensure that all bailiffs are properly trained. Now, the only thing the Green did was reject the presumption of prejudice in every case. And Your Honor, I just want to preserve for the record that our position is that the comments that you heard in this case go to the merits, go to the heart of the defense. And if you find that those comments were made, and I'm going to establish for the record, we clearly have proven that then we do get the Rimmer presumption,
So Happy Annie, if you're not able to see the comments on replay crew, I've noticed that sometimes when streams have just recently ended, when YouTube is still like processing them and I see it on my end, it's like still processing. It won't have the live replay like chat replay available yet. So it might just be a timing thing. And different videos, it seems to vary. Sometimes they get processed pretty quickly. Other times it takes 24 hours. It just seems pretty random. So that could be why, but I always have that toggled on. So that might be why though. And that would be true for any stream, right? If it's, I think it's a YouTube thing, not a StreamYard thing. Like if it's still uploading to YouTube, it says like still processing. Then that's gotta be why, because you should be able to see them.
If we have proven these comments were made.
Interesting.
But I'm going to argue that we prove prejudice also in this case. So to start with, let's go to the evidence that was presented since Friday. And Your Honor, we have 12 deliberating jurors. In this case, what you've heard, 3 of the 12 have testified under oath that they heard Ms. Hill make comments about the case, whether it's, how they categorize it as merits or not. But Juror X on Friday acknowledged that Ms. Hill made a comment about Alex was going to testify, that it was going to be epic or some words like that, and that defendants don't normally testify. That's what Juror X said on Friday. Today, so that's one who says Ms. Hill made a comment about Alex's testimony, how it's going to be a big deal, and defendants don't normally testify. Juror Z today says that first she says, Ms. Hill said to watch his actions, to watch him closely. And then she said there are other things that he said I don't remember. And then we were allowed to show her, and with Your Honor, I asked her questions about her affidavit. And she says, confirm what was in her affidavit, that Rebecca Hill told the jury not to be fooled by evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testified. She also acknowledged, this is a truthful statement, that she instructed the jury to, quote, watch him closely, close quote, immediately before he testified, including look at his actions and look at his movements, which I understand to mean he was guilty. And she also said and confirmed that Ms. Hill said when they began deliberations that this, quote, this shouldn't take us long, close quote, and that if we deliberated past 11 p.m., that we'd be taken to a hotel. Those statements go to the merits. Those statements go to the heart of the defense. Those statements go to what Mr. Murdaugh, his credibility. So that's 2 deliberating jurors down. The 3rd deliberating juror who testified today is Juror P. And he says, you were asked, Juror P, did Ms. Hill make any comments about the case? And he says, yes. She said the day that Alex was taking the stand, Juror P is a he, but he is saying that she, Ms. Hill, said the day Alex was taking the stand, that she, Ms. Hill, made the comment about watch his body language. That's all I recall. So 3 of the 12 deliberating jurors heard Ms. Hill speak about Alex Murdaugh's testimony. 3 of the 12. And then we get the alternate juror came in and basically corroborated what those 3 of the 12 heard. And she had additional things that she had heard, but she corroborated what those 3 of the 12 heard. And then you've got Ms. Hill who gets on the stand and denies it all. And Your Honor, I couldn't agree with you more that you're able to judge the credibility of witnesses. And on this record, there's no way to find Ms. Hill credible. There's no way to credit her statements that she did not make these statements about his testimony. She crossed herself up as Your Honor is questioning her about the transcript involving the egg lady and how the egg lady learned that there's some Facebook post that was allegedly attributed to her husband. There's no way the egg lady would have known that unless Ms. Hill told her. And that pretty much came out there. So, and I know this is not a jury argument, but if someone misrepresents a fact to you once, I don't think you should go back and credit anything beyond that. What we hear from Ms. McElveen is that she heard these almost identical statements from Ms. Hill that Ms. Hill told that 3 of the 12 deliberating jurors heard and the 4th alternate heard. And Ms. McElveen heard her make very similar statements about the defense's case, about Mr. Murdaugh's testimony. So you got to put Ms. McElveen's testimony in our category. And Ms. Hill gets out there and says, never drove a juror home. Ms. McElveen's got no dog in this fight. And she says, she goes to court one day, she hears that Ms. Hill took a juror home the night before and went and talked to her and said, you can't do that. And Ms. Hill said, I didn't talk to her about the case. Well, she gets on the stand under oath here and tells you, I never took a juror home. It's totally inconsistent. And for her to say, I never made these statements, You know, she tried, I mean, she kind of gave herself a little wiggle room at the end. Well, when they were lining up, I may have said he's going to testify today or something, but these jurors heard this information. And the question under Green and Rimmer, was it prejudicial? Now, what we got from Juror Z today, the question was, did these comments influence your verdict? And Juror Z says, yes. Then you ask how? And Juror Z says, to me, it felt like she made it seem like he was already guilty. Then you said, did it affect your finding of guilt in this case? And the answer was yes. And so that's prejudice, Your Honor. That is prejudice from one of the 12 deliberating jurors. Was your verdict influenced by what Ms. Hill said? And good grief, how could it not be? How could it not be? And to ask all these other jurors who heard the same thing, was it influenced? It's really an impossible task because you don't know what's influencing a jury. And frankly, that's why the Rimmer presumption is there. But let's try to sort this out. And Your Honor, I think it was a State v. Kelly case where the deputies went out and they were investigating the jurors' beliefs on the death penalty. And there was really no testimony about did that affect your verdict, but it was just so wrong. The conduct was so wrongful that the Supreme Court says that's prejudicial and we're granting a new trial. I mean, this is prejudice. And this has been proven. I mean, Ms. Hill is not credible. Ms. Hill is not credible. And she's talking about her book, talking about taking a literary license to lie. Literary license to lie is that's what she thinks a literary license is. So her testimony should not be credited. We have proven, we have met our burden of proving that there was extraneous contact with these jurors. 3 of the 12 deliberating jurors have testified to that. 1 of the 12 says it influenced my verdict. How is that not prejudice? And that's all we have to prove. We believe, for the record, there is a presumption of prejudice that they have to overcome, but we have proven prejudice. And Your Honor, we respectfully request that a new trial should be granted based on the record developed today. Thank you.
All right. The arguments are closed.
Right.
I will take until 5 of the hour to examine my notes, and then I will come and make a ruling from the bench on this matter.
Love
it. Easy.
Rules from the bench. All right. And here we go, guys. Very thorough record.
In the matter of the state of South Carolina against Richard Alexander Murdaugh.
Happy Annie. So that sounds like you're at comments. Make sure you toggle it to the right where it says live chat reek. So because comments are different, right? There's usually like 2 dots, and on the left, that dot will show you comments, and then you just slide it to the right to go to the chat. See if that helps, if you didn't try that.
2022 GS 15 592, 593, 594, and 595. The following constitutes my ruling on this matter from the bench. This order will be supplemented, as I will explain, after proposed formal orders are received from each side in this matter. This case is unique in my 20 years of experience as a lawyer and my 35 years of experience as an active justice of the Supreme Court and a senior active trial.
It is quite unique.
Usually matters involving possible improper contact with or conduct of a juror arise during or shortly after the trial. The judge then puts the affected juror or jurors under oath, conducts an examination, and rules on the request for a new trial or a mistrial. In this case, I was appointed almost 9 months after the trial to replace the trial judge who was recused. It is now almost 10 months after the verdict was rendered and sentence imposed in this matter. It is now on appeal to the Court of Appeals. Several months after the appeal was filed, the defendant moved that his appeal be suspended and this matter be remanded to the trial court to consider his motion for a new trial on a charge that the clerk of court for Colleton County tampered with the jury by expressing her opinion to the jurors about what their verdict should be and about the credibility of the defendant who had elected to take the stand and testify on his own behalf. Since this matter has been remanded to me, I have set the matter for a pretrial and a final hearing, conducted a telephonic status conference with the attorneys for the parties on December the 21st, 2023. I have received briefs from the parties. I conducted a pretrial proceeding on January the 16th, 2024, in which I invited briefs and arguments by the parties and by the attorneys for certain of the jurors and for the clerk of court, Rebecca Hill. On Friday, January the 26th, 2024, I conducted a hearing on this matter in which I took testimony from one of the jurors. The conduct of the examination conducted solely by me. I received further argument from the attorneys for the state and for the defendant. Today, January the 29th, 2024, I have taken sworn testimony from the remaining 11 jurors who rendered a verdict in this case. This examination was conducted solely by me. I have found no case that provides otherwise in the many cases I have read on the subject of a motion for a new trial on the basis of after discovered evidence of jury tampering or misconduct. I have also received sworn testimony from the clerk of court, Rebecca Hill. Direct examination was conducted by Deputy Attorney General Creighton Waters. Cross-examination was conducted by defendant attorney Richard Harpootlian. I have also propounded questions myself to the clerk of court. I also received testimony from the clerk of court for Barnwell County, Rhonda McElveen, who attended most of the trial and assisted the clerk of court for Colleton County. I've also received testimony from the remaining alternate juror who was, when the matter was deliberated, dismissed from further service. The following is my ruling on the defendant's motion. The standard of proof. The state contends that in order to prevail, the defendant must show, one, that the clerk of court made an improper comment or propounded an improper question to the member of the jury, to a member of the jury who rendered the verdict. Two, defendant must further show that Ms. Hill's improper comment or question actually influenced the juror's verdict.
There it is on the verdict.
Citing State v. Green, State v. Olivet, and other opinions of our Supreme Court and other authorities. Defendant contends that he must show only that an improper question or comment was propounded to any juror by clerk of court Hill. If so proved, the defendant contends that the motion for the new trial must be granted. Defendant relies on United States v. Rimmer and many other cases. My ruling is this. On the law, the defendant has the burden of proving both the fact of the improper comment or question by the clerk of court, Rebecca Hill, to a juror or jurors, and two, prejudice suffered by the defendant, specifically that the Hill improper comments to the juror or jurors influenced the juror to vote to convict defendant Murdaugh. The facts. Did clerk of court Hill make comments to any juror which expressed her opinion of what the verdict would be? Ms. Hill denies A, and so the question becomes, was her denial credible? I find that the clerk of court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the.
That's one of the best parts right there, man. The siren call of celebrity.
I find that the clerk of court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed that as early as November 2022, long before the trial began. She denies that this is so, but I find that she stated to the clerk of court, Rhonda McElveen, and others, her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified, and she made some of those comments before he testified to at least one and maybe more jurors. Did clerk of court Hill's comments have any impact on the verdict of the jury? I find that the answer to this question is no. Each member of this jury took their involuntary assignment very seriously. They obeyed the instructions of the court. They obeyed their oath. These good and decent citizens of Colleton County stood to their duty and rendered their verdict without fear or favor. It was a difficult task. 11 of the jurors very unconditionally said they either heard no comment or if they heard a comment, it had no effect. One juror was ambivalent in her testimony. She was then examined on her previous affidavit in which she said the effect, if any, that she had was pressure she felt from other jurors. The cases are myriad that pressure from fellow jurors is a part of the normal give and take of jury deliberations. The court is not to inquire in any way about what is said in those deliberations. But the juror, who was somewhat ambivalent, said on her oath at the time of trial twice, and said on her oath before me in these proceedings that she stood to her oath. The clerk of court allowed public attention of the moment to overcome her duty. I have read the entire transcript of this lengthy trial, not an easy task. I have studied in detail all of the authorities cited. I have independently researched the case law, learned treatises, and scholarly articles on the subject.
I have to also say that I just pulled up U.S. v. Remmer here, which is from 1954, and I'll just read real quick the important part of the opinion here. So held, the case is remanded to the district court with discretions to hold a hearing to determine whether the incident complained of was harmful to the petitioner, and if found to have been harmful, to grant a new trial. So here's the prongs. So it says subsection A, in a criminal case, any private communication, contact, with a juror is a matter pending, is presumptively prejudicial. And then part B says, the presumption is not conclusive, but the burden rests heavily upon the government to establish after notice to and hearing of the defendant that such contact to the juror was harmless to the defendant. So in other words, it's not, this is what the defense is citing, right? That was the case they are relying on, which again, it's a federal case, but it's remanding it back to the trial court for them to determine if it was harmless or harmful. So it's not even saying it's definitively, if there was tampering, it's a done deal, which is why you have this issue, right? That the U.S. Supreme Court itself has not ruled on this. In other words, because here, this is a U.S. Supreme Court case, but what they're saying is you have to remand it back to the trial court and let them determine if it was harmful or not. So the U.S. Supreme Court itself has not made an opinion. Does that make sense to you guys? Like, for example, if there was a U.S. Supreme Court case that came to the U.S. Supreme Court and they said, okay, there was talking to the jury, therefore it's presumptively prejudicial, and we hold that new trial should be granted, right? Or that we remand it back to the trial court for a new trial. That's different than remand it back to the trial court for them to then determine, them being the trial court, if it was harmless or harmful contact, which essentially is what they're doing here with this evidentiary hearing, is trying to determine if it influenced the juror's verdict. So, yeah.
Although there is certainly a split in the federal circuits and in the states on the standard of review, I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial in a very lengthy trial such as this on the strength of some fleeting and foolish comments by a publicity influenced clerk of court. This is a matter within the discretion of the trial judge.
Right.
And I am the trial judge at this moment. I do not.
And that is in line with what the Remmer case says.
I feel that I abuse my discretion when I find the defendant's motion for a new trial on the factual record before me must be denied.
So I think that the bigger point here is looking at Remmer, like what Jim Griffin was arguing. He's saying harmful doesn't necessarily mean it impacts the verdict, right? Now, the South Carolina Supreme Court cases do articulate that it has to affect the verdict. And so, and again, it was Justice Kittredge who weighed in on this from the South Carolina State Supreme Court, and said that we do not go by that standard. We have to show that it did influence the verdict. So there was another reason I was going to say, right? It's a matter for discretion of the trial court. And right now, what else was
trial judge? And I am the trial judge at this moment. I do not feel that I abuse my discretion when I find the defendant's motion for a
right. So in other words, it's the interpretation of the word harmful, right? If it happened at all, is it harmful? And that's the thing that is missing from a U.S. Supreme Court opinion. Because again, it just sends it right back to the trial court to let them determine. So essentially, in my view, even going by that federal case law and the state Supreme Court case law, she's in the right here in the sense that let's just pretend that that's exactly why I think this will go all the way up to the U.S. Supreme Court. Because what will happen is one of two things, right? Either it'll go up to the U.S. Supreme Court if it does, right? And then they'll say, well, we're following Remmer, so we send it right back to the trial court and let them determine, and then sends it right back to this court here. I mean, who knows who will be around, by then. But I mean, just to be funny, wouldn't it be funny if it was sent right back and Justice Toal's pulled out of retirement again? And you know what I mean? Or they will say, nope, we're going to make a decision on this here. And because again, that's a 1954 case, they could take another look and make their own and make their own holding. And then that would apply to every court in the land. So very interesting.
New trial.
Welcome, Truth Seeker.
On the factual record before me must be denied, and it is so ordered. I will file a fuller order which denies this motion on the grounds I have recited on the record before me as a trial judge and the authorities that have been cited by all parties in this matter.
And to that end, again, Poot seems to think that it has a good chance to get for him to get a new trial when it goes to the U.S. Supreme Court, the South Carolina Supreme Court. But the thing is we all know how it goes with case law, right? They have to follow precedent, and the precedent in the state all points to no new trial for you, right? So unless they, for some reason, shirk their own case law, what I'll do is when she gets to the end, I'll go back to where she cites the cases specifically and see if I can find the holdings on those to see if there's something that could be factually different to where they could find differently. But okay, let me keep
to that end. I will hold the record open. I direct that within 4 business days of receipt by the attorneys in this matter of a transcript of these proceedings, a proposed order by the state denying the defendant's motion for a new trial with citations be sent to me and to opposing counsel. I will allow the defendant 4 business days from receipt of the state's proposed order to lodge objections and or submit an alternative proposed order. Upon receipt by the court of all proposed orders, I will finalize this record, submit a written order, and I will at that time transmit the written order to the Court of Appeals, the court which has remanded this matter to me. This hearing is adjourned.
Okay. Yeah, Happy Annie. I don't know. It should work on every device. I was just curious if you've ever tried it. Gotcha. Yeah, I don't know why you're having issues with that. Okay, I'm going to go back just a smidgen here to the part where she talks about the different cases relied on by the different parties.
4 and 5 matter 35 or the judge then in this case who was sentenced that his appeal for a new trial on a charge by expressing her. Since this matter has been in a final hearing, the first 20 proceeding on by the attorneys for the 26th of the nation, state and sworn testifies otherwise and discovered evidence of jury tampering or misconduct. I have also received sworn testimony from the clerk. I also received testimony from the clerk, and the defendant must show one standard of proof.
Okay.
The state contends that in order to prevail, the defendant must show one, that the clerk of court made an improper comment or propounded an improper question to the member of the jury, to a member of the jury who rendered the verdict. 2, defendant must further show that Ms. Hill's improper comment or question actually influenced the juror's verdict, citing State v. Green, State v. Albright, and other opinions of our Supreme Court and other authorities. Defendant.
Okay, that's what I wanted. So it's State v. Green. So give me just a second here, guys, and I'll just show you all this real quick here. So South Carolina v. Green. I think there's actually more than one. Hold on. Can I make this bigger? How do I, okay, hang on. All right, let's see here. Okay, so here's the one that they're talking about, State v. Green with Justice Kittredge. Okay, this is the one. So, okay, and issue number 2, the trial court's denial of petitioner's motion for mistrial based on an alleged improper communication between a bailiff and a member of the jury. Finding no abuse of discretion by the trial court in either issue, the Court of Appeals affirmed. Okay, any private tampering, Oh, and they actually quote Remmer here. The court in Remmer concluded, quote, the presumption is not conclusive. This is what I was just reading to you guys. But the burden rests heavily upon the government to establish that such contact the juror was harmless to the defendant. Now, remember, this is the one that Poot kept saying she was misunderstanding or whatever, right? Our Court of Appeals found the comments by the bailiff here triggered Remmer. We are not persuaded that the Remmer presumption of prejudice applied here. So what they found was it didn't even meet the first prong in Remmer, because the first prong in Remmer is presumption of prejudice. The second prong in Remmer was send it back to the trial court to determine if it was harmful. We readily agree with the Court of Appeals that the state overthrew any presumption of prejudice if it applied. The trial court questioned each juror and bailiff, which proved there was no possibility that the bailiff's comments influenced the verdict. Okay, so I don't know how Poot is saying that she's misunderstanding, because literally that's their standard. That's the standard in State v. Green, which is the case that the state's relying on here, right? Following, and she's following precedent, as she should. Chief Justice Toal, I mean. There was no reasonable possibility that the bailiff's comments influenced the verdict. And then the second prong from Remmer is the harmful part. Ultimately, the Supreme Court recognized the presumption of prejudice from the highly improper juror contact. That's prong 1 from Remmer, and remanded to the federal district court to hold a hearing to determine whether the incident complained of was harmful to the defendant. Interesting. So, remanded to the federal district court. Hold on. Lawrence County. Circuit Court. Does it have the previous? Interesting. Remanded back. I'm just trying to think here because it says, oops. Where'd it go? So your jury, The court decision of the Court of Appeals is affirmed as modified. Huh. The federal district court, without holding a hearing, denied the defendant's motion for a new trial. Let me pull up Remmer again here where you guys can see this. Um, there it is. So the case is remanded to the district court. Okay, so it sounds like even if it's a state case, for example, like in State v. Green, it's remanded back. So let me just be clear. I'm going to correct something for the record. Earlier, I was saying it's remanded back to the trial court. What I was saying that for is with the assumption that if it's a state case, it would be remanded back to their initial trial court level in the state. But if it was a federal case to begin with, it would be remanded back to the district court federally, right? But the holding here doesn't make that distinction. It just says the case is remanded to the district court, which would explain why in State v. Green, which is a state case, it wasn't remanded back to the trial court level of the state. It was remanded to the federal district court. That's why. Interesting. So in other words, for Murdaugh, what would happen if the South Carolina Supreme Court says no new trial for you, and then they appeal on the federal level? What will happen is it'll go to, okay, wow. It'll go to the circuit court, which is the Federal Court of Appeals, right? It'll go to the circuit court level. My understanding of this. And then they would say, following the holding in Remmer, we remand it to the district court. So that would be a federal district court. Crazy, which is the trial court level when it comes to federal cases, right? Remand it to the federal district court for them to determine if it was harmful or not. And then they would and then it would go from there. Wow. The long road ahead on this, guys, if for anything confirming potentially that he gets a new trial. So I haven't even been looking at the chat, but it looks like we've got a new friend. Court Jester, welcome, new scroll friend, unless you're somebody with a change their name, but also offering some advice to Happy Annie here. But welcome. Meg P is back. So interesting. So again, we're looking here at State v. Green, right? And here's the holding from Kittredge. And I don't know why Poot is saying that Justice Toal got it wrong. Of course he's wrong when he's saying that she misunderstands it. But it's clear, because we just read it, that the holding is because the comments did not influence the verdict. Right there, point blank. So here's the deal. Even if you go by the federal case law that the defense is relying on, it doesn't work in the defense's favor, right? In this case, right? It does not work in their favor. So that's why it would be ripe for the Supreme Court. It would be a situation for setting precedent there, right? If they want to actually have a holding like from the U.S. Supreme Court level. That's why this is interesting, right? Because I kept thinking to myself, well, this is a U.S. Supreme Court case, so how come the holding here isn't applicable? But it's because the holding, they don't, in other words, it's kind of like, what's the word that they say? It's kind of like kicking the can along, right? Instead of the U.S. Supreme Court, sorry, I'm on the wrong case. Here we go. Here's Remmer. Instead of the U.S. Supreme Court justices at the time making the decision, right? They essentially, again, kicking the can, so to speak, by just sending it back to the district court and saying, well, you guys first have to determine if it was harmful or not. Now, having said that, there's another Remmer. Let me pull this up from 2 years later. Let me just see if this has anything different. It cannot be said that the juror was not affected in his freedom of action as a juror. Okay, so on the 2 years later, he was entitled to a new trial. Okay, hold on. So, okay, so remember in 1954, so it went back to the district court level. Interesting. Well, let's take a look. This should explain it. Okay. So, hang on. Okay, hold the phone, guys. Okay. petitioner's motion, affidavit supporting the motion. During the trial, one juror had been approached by somebody, doesn't matter who, with the suggestion that juror could make easy money if they made a deal, Somebody called in the FBI, Okay, here's what matters. We sent the case back to the district court. That's the opinion we were just reading, with directions to hold a hearing with the petitioner and counsel present to determine from the facts whether or not communication with the juror by the outsider and the events that followed were prejudicial and therefore harmful to the petitioner, and if so, to grant a new trial. Okay. On remand, the district court held a hearing and found the incidents to be free of harm. No harm. Thereafter, this court remanded the entire record of the Court of Appeals for the Ninth Circuit to consider the whole case in light of our recent net worth decisions. The Court of Appeals reviewed the whole record and affirmed the petitioner's petitioner's conviction. The case is here again on certiorari. Oh my God, I don't know how to pronounce that. Limited to the question of the effect of the extraneous communications. How do you say that? Extraneous communications with the juror upon the petitioner's right to a fair trial. The district court read our opinion and was mandate to mean that the incident complained of to be inquired into the hearing was the purpose and the effect of an FBI investigation. Okay, consequently, the court finds that the incident complained of was entirely harmless so far as the petitioner was concerned, okay, and did not have the slightest bearing on the integrity of the verdict. Again, didn't impact the verdict, nor the state of mind of the foreman of the jury, okay. But now they're saying that they wanted to explore the entire picture. I'm paraphrasing here because there's a lot of words. And then here's this first prong that we covered earlier. Need for full hearing, which is what we saw in Murdaugh. Okay, we don't need the facts of the case specifically. Let's just see what they end up saying at the end here. The unduly restrictive interpretation of the question by the district court had the effect of diluting the force of all the other facts and circumstances in the case, which may have influenced and disturbed Smith, We hold that in consideration of all the of all the evidence uninfluenced by the district court's narrow construction of the incident, petitioner's intelligence. Interesting. So this is like interesting. They didn't even talk about this part in the Murdaugh, all this hearings, but this is like saying they went back and they said, when you look at everything as a whole, wow, what a craziness. The petitioner's entitled to neutral. So in other words, the case from 1954 is definitely what was being used at this with Murdaugh. This seems very fact specific, like fact pattern specific to this particular case with like the FBI and whatever the fuck else that ended up with a new trial. So that I think that's why we didn't hear anything about it. It doesn't seem to be applicable. And the opinion from 1954 is what first set out that standard, and that's what they have been relying on. Okay, so just to be thorough, we just checked on this. This doesn't change anything. It would be the one from 1954 that we just covered that would be applicable, which is what they are using. So there we go. Let's see if I can find out how to pronounce this word. I'm usually pretty good at okay, certiorari. Can you guys hear that? Oh, hold on. Listen.
Certiorari.
So not at all what I guessed. Well, it doesn't. Yeah, certiorari. Yeah, no wonder that was a tougher one, because certiorari, the sh part was the surprise. Anywho, so yeah, so there's the case law for Green, SC v. Green, State v. Green, and the Remmer case, and there you have it, guys. So yeah, wow. So there's gonna be a bit of ping ponging, I suppose. It'll be interesting to see what happens. I mean, again, Poot's expecting them being the South Carolina State Supreme Court to take this up before the end of the year. It will be very exciting to see, and we'll be following it, of course. So, but we are all set here with this, guys. We've got the full situation here, and yeah. So tomorrow we have another day. Karen Reed, obviously, should be Judd Welcher, is what is expected. And of course, I'll be covering that in the evening. So for anyone who is new here, though, guys, if you check out the playlists tab on my channel, all of the cases that I'm currently covering and have covered have their own playlist. So that makes it easy to find certain cases. There's also the music playlists, guitar and violin and whatnot. But anyway, so that is a feature. And you can also sort those playlists however you want. So for example, if you go to the Murdaugh playlist, I have it sorted, I think, by most recent first, but you can always sort those to do like by oldest or whatever, just in case you guys have never fiddled around with that. And as always, I always do very detailed timestamps once I finish a live stream. So that makes it, for those of you guys on replay crew, rewatch crew, you can find something you're looking for specifically if you're looking for something specifically. But yeah, but that'll be it for this one, guys. Welcome to all the new squirrel friends. And hopefully we will see you guys all again here soon for Karen Reed. And but other than that, I think we are we've got another Murdaugh in the books here, guys. But as always, thanks for being squirrels. Love you guys, and I'll see y'all next time.